Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next church on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
I object.
What more do we see?
All right, did we make the jump? Are we here? I think we made the jump. All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining me. We are about to jump in live to the. I need to go back to where we were. Hang on. Let's go back here. All right. Let's turn this down a little bit. We are about to jump in live to the part 12 of the Ashley Benefield trial. This is going to be the closing arguments segment and the beginning of a verdict watch as court is about to begin. Big shout out to Adam Nusky, first in chat today. Thank you very much, Adam. The internet, my friend, is all yours, which is a small deal because right now, even as we speak, the guys are still replacing the line on my pole. Don't let them break it, Adam. Don't let them break it. If that snaps, we've got trouble. So we'll go back to court. Sorry, the two cameras aren't working right, but we'll go back to court here. And Adam, we're here. All right, that was one of the quicker transitions we've ever had. We're expecting to start any moment now. It's actually 1 minute late. So there's some bailiffs present. Looks like they've got, they're putting the finishing touches with the getting the poles in place. I think we're good. I don't think my internet's going to break. I hope. But I'm still recording them just in case something happens so I can send it to my carrier. All right. Lift the pole cam a smidge. Let's see. We lift it up right up here. And then we lower, put it over here. Just make it a little bit bigger, make the bottom drop. There we go, a little bit from the left. A little to the right. There we go. A little bit more on the top. There we go. There's our pole cam. It's still fully functioning. There's our defendant, Ashley Benefield, just walking into trial court right now with Mr. O'Keefe, the judicial assistant, and just waiting for Mr. Taylor. I think he's out in the hall, so he'll be in just a moment. No audio yet from court. It's going to be loud when we get it. Oh, you guys are still standing? Hang on. Let me get that fixed. I forgot to reset the Lumia stream. Quit and relaunch. Okay, I'm setting up all the chairs for you right now. I'm feverishly setting it up. 3, 1, 2, 3, 4, 5. Boom. Good to go. You're in. It's all set up. Thal, she smacked you the second you posted. I don't know how was she that quick? Okay, so now the buffer sound should work, Amber, even though I didn't get that one. Mr. O'Keefe doing non-lawyerly things, talking with the other lawyers. Judge is not on the bench. Judge and Mr. Taylor suffering from a little bit from a cold today. That might affect his presentation during closing arguments. Hopefully that's not a bad thing. It looks like Ashley and Tommy Benefield are both present. ISO record. There we go. This is probably going to be a packed courtroom for this last segment.
Have them send someone with more experience.
Must give closing. Yes, he will. He'll give a closing, but it's got to be good. This is what we need to do. We need both sides, okay? Because there's a lot of evidence that came in and it was just testified to and then left alone. But both sides need to put together their arguments so that everything wraps up to one big, complete picture, and not leave anything just hanging. I think we'll see. I think Mr. Taylor has a great opportunity to say, you heard from the defendant, like her or not, everything she's said, everything she's always said, matches up with the evidence you've heard, and that is reasonable doubt. I think he needs to hammer that it's reasonable doubt. The fact that she might have done some mean things in the relationship and everything, it doesn't weigh in here. Basically, he has to just say that she was in that moment, even after she invited him over to help move and they were trying to work things out. In that moment, she was afraid for her life and had legal right to use deadly force. I haven't heard if there are time limits at all. I imagine with Mr. Taylor not feeling the best, he might limit himself a little bit. Joey Girl, welcome. Ashley is an only child. Yes, she is. 1.2 hours each. Oh, man. See, her story has not changed. Still don't believe her. So, that's all right. That's all right. Check out the paddle and the switchboard. I added to the thumbnail. I will add that to the final version. Let's see if I can do. She never told her story before. But what I'm saying is what she said before when she was, what she said to the few people she talked to. I guess Mr. Sants, was that his name? The neighbor was one of the few people who she actually talked to. That was consistent. The way she told her story, the timeline matches up. I know we heard earlier that he was cool to the touch. Doug was cool to the touch when they went in, but we had a neighbor who was walking by who heard the gunshots and saw her then immediately run out of the building. That takes care of she shot him and then planned everything out. And, that theory is shot down. It's everything just seems to match up her story with all the facts that are found. They haven't found any facts that discredit her story. I have not watched the stand your ground hearing, but it was my understanding that she did not take the stand in the stand your ground hearing, right? Did she testify in that one? She said all the shots were very quick to each other. She was smart not to talk. She did everything we tell people to do. We tell defendants, shut up, get a lawyer, don't talk. We tell them that. She did that. That we can't hold that against her. So if she did not take the stand, I think that was a huge mistake, not taking the stand in her stand your ground hearing. First time he said he may have been running away as to the leg wound. She said his legs were up in the air. Both were possibilities. And both MEs said they could not testify as to where the gun was because they weren't there when it happened. All they can say is that the bullet went at this angle. Judge is late. Comes bustling in with a lot of papers. I have heard this, that Florida has some weird rules as far as stand your ground. And lawyer, Peter Tragos, says it's really common not to testify at stand your ground because the standards are different and it's in front of the judge. You save it for the jury. It's almost impossible to win in Florida. Tisha S., thank you for membership message of 9 months. Says, I don't 100% believe her, but I have huge doubts and the state didn't prove their case for me. My biggest concern right now is that in the jury instructions, I don't remember, and it's possible they might have just skipped it over by reading the heading. I don't remember them reading any heading or discussion about the burden of proof shifting to the state to prove that it was not self-defense.
All right, good afternoon, everyone. We're back on the record in State versus Ashley Benefield, case 2020 CF 3014. We're ready for closing arguments and jury instructions. However, I've been informed that there may be a change or an error from earlier.
On 3.6, where it's the false imprisonment, I think your instruction said forcibly or, and you crossed out by threat, then you circled it, and I think we thought it was supposed to be left out, and so it's typo. It says Judge Benefield forcibly or confined or restrained, because you've written or. I didn't catch it. So it's on the second page of 3.6F, and it's the first element of false imprisonment. And I don't know if we were supposed to say threat or not.
Okay. Let me hand out, thank you for doing those and sending them. The reason I'm late coming back, I apologize. The copier upstairs is moving just as slow as the internet today, so it just took forever to make these copies.
Adam, that's on you.
There's one for each the state and the defense, and I want you to check. I saw that, and I think I fixed it.
We printed them thinking if you found it, we could at least just print that page. So
look and see. There was also a few punctuation issues that I changed, so a couple of commas.
Well, we did a poll yesterday as soon as the...
Listen, I really appreciate you guys putting that together for the standards. But look at 3.6F, I did catch that.
Yes, sir. I see where you fixed it. Thank you.
Madam Court Reporter?
Yes.
3.6F is the one I have an issue with. That talks about the burden.
Okay, so we have one other issue, Judge. In 3.6F, when the court lays out the forcible felonies, we kind of feel like they lose their individual identity because they're not separated at all. And we were wondering if we could label them. For example, the elements of the forcible felony of false imprisonment are 2 dots, and then do the same thing with the elements forcible felony of aggravated assault are 3 dots. If you look at the instruction, the way it's printed, knowing that they're going to take it back into the jury room with them, it doesn't seem to have an individual identity. It just kind of is all lumped in there. So what I am proposing, may I approach?
Right.
I've shown this to Rebecca. Perhaps if we could just number them to give the jurors some sense that they're individual crimes. The only other thing we had, Your Honor, is the last paragraph on that page in deciding whether or not Ashley Benefield was justified. That refers to subparagraph A, and we were thinking it should come after subparagraph A, and then the rest applies to subparagraph B.
Lynn, you are so close to the year mark. Next month you'll be there. Thank you so much for 11 months of support. I believe all the witnesses are allowed in the courtroom now.
I don't care about the numbering. I think that they're fine. I think Mr. Taylor's welcome to explain it in closing. I think it's clear they're each labeled what they are, and you have them in a sentence. We have them in a sentence. As to that paragraph, I don't think that paragraph actually goes to A or B. It's for the self-defense instruction altogether. It's not as to that one section A or B, the last paragraph on page 2 of 3.6F. So I just ask that it remain where it's at.
All right, final thoughts. All right, I think that how we have it is, how I've prepared it, is correct. The elements of the forcible felonies are laid out as discussed previously. They're not misleading. It's one solid instruction referring to the various forcible felonies. I'm going to read it to them, and I think when they hear it from me, read to them, it's going to be eminently clear that these are separate forcible felonies. So I think they're ready to go. Holiday. Any other objections?
No, sir.
Are you ready to bring the jury out?
Yes.
You ready?
Yes.
Before we do that, all right, I want to speak directly to the observers that are in the audience. We are now about to begin closing arguments. This is when the attorneys are allowed to tell the jurors what they believe the evidence was, discuss how the law applies to this case, and explain to the jurors why they should vote one way or another. You will likely agree with one side and not the other. However, you are instructed not to behave in a manner that is distracting or in any way attempts to influence the jury using threats, intimidation, or sympathy. If the court determines that your behavior is distracting, you will be removed from the courtroom and prohibited from returning until closing arguments have been completed. This includes coming in and out of the courtroom during closing arguments if the court determines it is distracting to the jury.
Tommy was shaking his head.
I've got 9 copies without verdict forms. Just check. The ones I gave you should have the verdict forms, right?
Yes,
Artie
sir.
Bay, thank you.
Yours
7 months as well.
And Judge, I will need the screen, so I don't know when you want to put it down.
People sprinting for the door.
All right, y'all can have a seat. All right, everybody have a seat. All right, before we get going, just to make sure one final time, did anybody discuss the case amongst yourselves? Did anybody do any research on people, places, things, or legal topics we've heard anything about? Or did anybody talk about the case with anybody outside of this jury?
No.
Members of the jury, both the state and the defendant have now rested their cases. I will now give you the initial jury instructions, after which the parties will give their closing arguments, if they wish, and then I will give you the final jury instructions before you retire to deliberate. The courtroom deputy will now hand out a copy of the jury instructions for each of you to review as I read them. The jury instructions are like your notes. You may write on them. After the trial, the deputy will collect your notes and jury instructions and return them to me to be destroyed. No one will ever read your notes. I will also add that I am confident that you can all read a lot faster than I can speak these jury instructions. Sometimes I've said to Miss Sarah that I'll take that as a challenge, but we want a good, clean record. So I am going to ask also that you stay with me as I read the jury instructions. There's also a point, like I said, where I'm going to stop, turn it over to the attorneys to do their closing arguments. So it's just be better if we all stay together. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Ashley Benefield, the defendant in this case, has been accused of the crime of murder in the second degree. Ashley Benefield is accused of murder in the second degree. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Douglas Benefield was killed by Ashley Benefield, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune and in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Ashley Benefield may be found guilty of murder in the second degree or any lesser included crime. To prove the crime of murder in the second degree, the state must prove the following three elements beyond a reasonable doubt. 1. Douglas Benefield is dead. 2. The death was caused by the criminal act of Ashley Benefield. 3. There was an unlawful killing of Douglas Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of murder in the second degree, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Ashley Benefield did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Ashley Benefield was, in fact, so provoked and did not cool off before she committed the act that caused the death of Douglas Benefield. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should not find her guilty of murder in the second degree. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm, and in doing so caused the death of Douglas Benefield, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing death. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Douglas Benefield is dead. 2. Ashley Benefield intentionally committed an act or acts that caused the death of Douglas Benefield. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to do harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Ashley Benefield committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally used a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Ashley Benefield committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, or used a firearm, then you should find her guilty only of manslaughter. It is a defense to the crime of murder in the second degree, including manslaughter, if the actions of Ashley Benefield constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Ashley Benefield does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force.
That's important.
The law on justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent A, the imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1. Douglas Benefield had permission or consent to enter a structure owned by or in the possession of Ashley Benefield. 2. Douglas Benefield, after entering the structure, remained therein, A, after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure, or B, to attempt to commit a forcible felony. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. The elements for the forcible felony of false imprisonment are: 1. Douglas Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. 2. Douglas Benefield had no lawful authority to do so. The elements of the forcible felony of aggravated assault are: 1. Douglas Benefield intentionally and unlawfully threatened, either by word or act, to do violence to Ashley Benefield. 2. At the time, Douglas Benefield appeared to have the ability to carry out the threat. 3. The act of Douglas Benefield created in the mind of Ashley Benefield a well-founded fear that the violence was about to take place. 4. The assault was made with a fully formed, conscious intent to commit false imprisonment upon Ashley Benefield. The elements of false imprisonment are as I have previously explained to you. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Ashley Benefield may be found to have been in fear, and actual fear on the part of Ashley Benefield need not be shown. In deciding whether Ashley Benefield was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. If you find that Ashley Benefield, who because of prior threats or difficulties with Douglas Benefield had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Douglas Benefield, you may consider this fact in determining whether the actions of Ashley Benefield were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Ashley Benefield knew that Douglas Benefield had committed acts of violence, you may consider this fact in determining whether Ashley Benefield reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Ashley Benefield and Douglas Benefield. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, the conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's question? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and the other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give their opinion. However, an expert opinion is only reliable when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of all of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Now at that point, if you would please mark that spot, that's where I'm going to ask you to stop. And I'm going to take a brief moment and explain the verdict form to you. The attorneys will now be given the opportunity to do their closing arguments if they wish. Sometimes they'll show the verdict form to you, so I want to take a minute to explain it and how it works. So, and I know you can't read it from there, and you do not have a verdict form in your packet. I have the verdict form that I'll be giving you. In the Circuit Court of the 12th Judicial Circuit in and for Manatee County, Florida, State of Florida versus Ashley Benefield, case number 2020 CF 3014AX. Verdict. We, the jury, find as follows as to the defendant in this case. Check only one. When it says that, it means as to A, B, C. So as a jury, you will deliberate, and you must agree on either A, B, or C. A, the defendant is guilty of murder in the second degree as charged. B, the defendant is guilty of manslaughter, a lesser included offense. C, the defendant is not guilty. And what I meant to say earlier is you must agree unanimously. That is, all of you must agree on what the verdict is. Now, if you, as a group, you debate, deliberate, and as a whole, you find either A or B, then you must go down here to this series of questions. If you find the defendant guilty of A or B above, then you must answer all of the following questions. 1. Did Ashley Benefield actually carry a firearm? Yes, no. 2. Did Ashley Benefield discharge a firearm? Yes, no. 3. Did Ashley Benefield, as a result of discharging the firearm, cause death to Douglas Benefield? Yes, no. So say we all this blank day of July 2024 at Bradenton, Manatee County, Florida, and then it'll be signed by the foreperson, and the foreperson will print their name. And I'll talk about that when I give you the final instructions. Members of the jury, the attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, you should listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide its time between an opening argument and a rebuttal argument after the defense has given its closing argument. State.
Can I have the screen, please?
Yes. And how much did you want to reserve?
Are you going to give a warning?
Yeah, do you want the lights down?
Yes, if we could just see the ones back there.
The power pole's replaced and the trucks are leaving right now. They're all gone. Thank you, Stephanie Barnes.
Domestic violence is absolutely a real problem. There are many, many women around that are in horrendous situations. Women, and sometimes men, that are in situations where they're being abused and beaten horribly on a regular basis. People that feel like they cannot get out, they have no way to get out. That is not this defendant, and it never was. Now, some of those women who are victims of horrible domestic violence may be justified in a situation where they have to use self-defense to kill their abuser. Absolutely, there can be situations where that might be a valid point, but not for this defendant. This defendant used domestic violence and allegations of it to make progress on her goal. And her goal was she wanted sole custody of that child at all costs. And to understand that, I think we need to go through the background, even though this case really is about what happened in that house. What happened in that house, the last moments of Doug Benefield's life. But we need to go through the timeline to see the tenor of this relationship and to see how it unfolded. The bottom line is you have to decide at the moment that she pulled the trigger in that bedroom, was it reasonable and was it necessary? That self-defense instruction is called justifiable use of deadly force, is very complicated. But there are two words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did. So let's go through the timeline. In September 7th of 2016, this couple was married. After knowing each other 13 days and a 30-year age difference, they married each other. According to the defendant's testimony, very shortly after, there starts controlling behaviors and name-calling.
Slowest pan ever by the camera.
Then, 4/15 of 2017, Doug Benefield has a vasectomy reversal. They decided in less than a year of marriage, they wanted to have a child.
Nothing wrong with that.
This is about the time where the defendant says that there are these angry outbursts in South Carolina by Doug Benefield. And the state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. Not at all. His behavior was unacceptable at the time. But he also apologized for it. If you look at the emails, or I'm sorry, the text messages between him and Ashley, he says, I'll spend the rest of my life making this up. And he says how wrong he was and how stressed out he was. And he apologizes. But that's not the most important thing. The most important thing is what happens after that. Does any more abuse happen after that? Within days of these anger outbursts in South Carolina, there's a lavish wedding reception where everyone seems to be happy. And then within about 3 months after that, the defendant gets pregnant. In the midst of all of this, she gets pregnant. The very next month, she moves to her mother's house in Florida because she's so sick and needs someone to take care of her. That is the last moment that this defendant ever lived in the same house with Doug Benefield. Was August of 2017. Very, very important date. Within a couple of months after getting to Florida, the defendant starts this campaign of complaints against Doug Benefield, all with the idea to get sole custody of her child that she was pregnant with. So she filed for a South Carolina injunction while she's in Florida. She doesn't even live in South Carolina. She doesn't even live with the person that she's trying to get an injunction against, but finds it appropriate to get an injunction in South Carolina. Do you normally get injunctions against people you live with? It is a mutual injunction. Don't mistake that. The judge did not make any findings of fault. There was no evidence presented. No one was ever found at fault. The two parties, Doug and Ashley Benefield, agreed, fine, we just won't contact each other. That is not what we are used to probably in Florida for injunctions. Then December 2017, so that's within a month, Ashley starts the series of allegations in Florida. So she files for this injunction in South Carolina. They mutually agree, okay, we're not going to talk to each other, we're not going to be around each other. But she starts a series of complaints in Florida. She starts saying he violated the South Carolina injunction, and she claims he's poisoning me. He's poisoning me and my unborn child, and also goes back to things that he supposedly did in South Carolina when they don't even live together. So on March of 2018, she gives birth. She gives birth after Doug Benefield has a lawyer contact her, because they're not really supposed to be talking to each other. The lawyer helps him write a letter where he says, I want to be a part of this child's birth. Please, I'll honor your wishes, but please let me be a part of this child's birth. Not only does she not respond, when she goes early to give birth, she doesn't tell Doug. She doesn't tell him once the baby's born. For weeks, he didn't know this child was born. Then she does not put his name on the birth certificate. Now, alleged behavior or not, she knows who the father is. Why is she not putting the father on the birth certificate? And then she gives this child her maiden name instead of her father's maiden name. Or, I'm sorry, her father's last name. Then 1 month later, she starts complaints to law enforcement. She says he violated the injunction in South Carolina. She files for a new injunction in Florida based on all of the same things in South Carolina. This is all based on the same information that she had already already spoken about in South Carolina. And when she went to law enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. And you heard from Detective Gillum about the conversations that they had. And the conversations that she had with Detective Gillum are the entire crux of this case. It is her motive, it is her plan, it is what she did everything for. He said her true motives were to use the criminal system to affect her family court case, to get sole custody of her child, which is what she wanted from the very beginning. He said it was very clear that she was trying to use the criminal system in that way, and he was very uncomfortable with that. He had forwarded charges to the state attorney's office, let the state attorney's office decide, which they end up not filing, by the way. And she did not think that was good enough. She was furious. She said, and I quote, "If the judge sees him arrested, it will help me keep my baby." She wanted him arrested in family court in front of the judge and made that very, very clear. That was what was important to her. The detective said in 20 whatever years that he's been doing this job, he has never had anybody ask him to do that. Never. And she was very adamant, and they talked for 15 to 20 minutes. And she went from crying almost hysterically to aggressive and yelling at him and then screeching at the top of her lungs, all because she could not get him to go with her plan. She also said to him, "You will fucking arrest him in front of the judge, and I will make sure that you do." Then she said, "I will do anything I have to do to keep my baby, asshole." She wasn't saying, "I'm so afraid of this man.
There's a comma in there.
Please help me. I'm a victim of domestic violence. I need help." Not at all. She's saying, "I want to keep my baby." And she's afraid that this man, who is 30 years older than she is, and a lot more established, has a lot more money, has a lot more resources, she's afraid that this man is going to get custody of her child instead of her. So after this discussion with Detective Gillum, in about September 17th of 2018, the second hearing for the injunction happens. Remember, this injunction hearing was in two parts. One was in July and one was in September. All of the same allegations. He's poisoning me, the stuff in South Carolina. Again, they're not even living together. And she fails. The judge in that case says, no. No injunction. And this man will have immediate visitation with his child, who, by the way, was 6 months old and he'd never met her. It wasn't for lack of trying. There may be a lot of deadbeat dads out there that don't care about seeing their children and don't want to be around. This man tried everything to be around for his child, to be there for the birth, to visit the child, to see the child. And she kept the child away from him for 6 months. And the first visitation, you heard from Stephanie Murphy, the first visitation, all of a sudden, everything's glorious again. Now, all of a sudden, the defendant wants to go with him. I'll go with you. And now we're in a stage where we're acting like we're going to get back together. Because she knew the court system was not working, and she was afraid that if she didn't buddy up to him, he was going to get this child away from her. So it begins the charade of her telling him, you know, we're going to get back together, we're going to be a family. She played on Doug Benefield's wishes. He wanted more than anything to have a family, his family together, to have his wife that he loved and this child all together. And she kept telling him, yes, that's what we're going to do. That's what we're going to work towards. So that starts about a year of them kind of getting along, right? And then September of 2019, which is about a year later, Doug finds out she's dating someone else. He files for divorce. And a series of complaints start. against Doug Benefield for now abusing the child. Which, by the way, were investigated by law enforcement, and not one of them resulted in any charges. And May 1st of 2020, the defendant, having failed in the criminal system, again, files for another injunction based on these allegations that fail in the criminal system. Do you see a pattern here? May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody. And what happens? All of a sudden, she sidles up to him, and now we're getting back together. And we start to go to marriage counseling, and we go see Dr. Forrest, who referred them to Dr. Quintel. And they're going to marriage counseling about how they're going to get together. And to Doug, she's saying, yes, I want to reconcile. Let's get back together. But behind his back to the doctor, she's like, no, I know how. I'm not getting together with him. Then she goes on all these social outings with Doug and the child. Goes to the beach, goes to the movies, goes out to dinner, to lunch, swims at the pool at his apartment complex, giving Doug all of these mixed signals. We're gonna reconcile. We're gonna get all this back together. And in the back of her mind, she knew all along. She was just waiting for an opportunity to strike. And then 6/1 of 2020, the system sends them for an evaluation with Dr. Broder. And they're like, what is going on here? Someone needs an evaluation. So they go to this evaluation with Dr. Broder, and this deception on the part of Ashley Benefield continues. She does the same thing. We're going to reconcile, we're going to get back together, and then when she's not with him, she's saying that that's not true. And then towards the end of September 2020, but before the 21st, there is a last meeting between Ashley Benefield and Dr. Broder. He said it was in his office. She was leaving. She was walking through the waiting room and going to the door, and she's upset because this is not going fast enough. I want the report. I want this to be done. We need to move to Maryland. Why do you think she's moving to Maryland? We need to move to Maryland. This is taking way too much time. And she says to him, I'll take matters into my own hands. And that was 7 days, up to 17 days before, depending on about what time it was, he gets murdered. On 9/21 of 2020, after this comment to Dr. Broder, she goes to mediation with Doug Benefield, and they end the mediation saying, everyone's going to drop everything. Because at this point, Doug had filed for a divorce, again. And Ashley had filed for an injunction, again. So at this hearing on the 30th, those things were going to be heard, as well as a motion, joint motion to release a report by Dr. Broder. But they go to mediation, and at the end of mediation, it's very fast, because they all agreed. We're dropping everything. We're going to Maryland. So that was the plan. Ashley Benefield had no intention of dropping that injunction. Look at the text messages between her and Doug that were introduced by the state for the week before this homicide, murder happened. They're talking to each other about the fact that everything's going to be dropped. Give this attorney a call. Okay, I'll give that attorney a call. Ashley's telling him we're going to drop everything. And she knew that was not true. Her attorney testified, we were not dropping that injunction. We were ready to call witnesses. At that hearing on the 30th, we were going forward. Ashley Benefield knew that day it was over. It was going to be over. Her entire charade was going to be done this entire get along, go along that she's trying to say was because of domestic violence. She was just trying to fake Doug out. And she knew that on the 30th, her ruse was up. Because if she goes forward with an injunction, what better way to tell someone you're not going to reconcile than trying to get another injunction? So what does this timeline tell us for what happened at the time of the shooting? Okay? It's background, yes. But also, it tells you they did not live together for 3 years before the homicide. And if there was violence towards Ashley Benefield in South Carolina, that was 3 years before. And they hadn't lived together since. And is that something that justified her being in such fear of Doug Benefield that it was necessary to shoot and kill him? The answer is no. I do want to talk a little bit about domestic violence, and Mr. Ferris testified a lot about this wheel, this power and control wheel. So I want to put it up there. First of all, the overarching umbrella right here is physical and sexual violence. There is no physical violence in this case. There is no sexual violence. There's no allegations of any of this, unless you believe the defendant that the day this happened. But there was never any allegations of physical or sexual abuse. However, it's a power and control wheel. So let's go over some of these things. One of the first categories, using intimidation. So this is, did Doug Benefield use intimidation to control Ashley Benefield? They hadn't been together in 3 years. The first year they were apart, they barely even saw each other or spoke. So how exactly was he using intimidation to control her? And there's no allegations of threats during this time. The defendant testified she didn't say that there was anything going on during this time. One of the other prongs is using emotional abuse. Same answer. They weren't together. There was no allegation of emotional abuse. The defendant didn't talk about anything that was going on during this 3-year period, that he was emotionally abusing her. She felt comfortable enough. She even said, I told him when he thought he was going to move in with me, I told him I didn't want to do that. She felt comfortable enough to say, no, you're not moving in with me. But yet somehow he's emotionally abusing her. Then using isolation. How can that even apply when they're not even together? He has no influence over her comings and goings, over her daily routine, and she even started a new relationship with someone else. So how is it that Doug Benefield is exercising control over her by using isolation? And then minimizing, denying, and blaming. Well, nothing had happened in 3 years. So was there even anything to minimize, deny, or blame? Nothing had happened. And there was no evidence of anything happening other than maybe some things that the defendant said happened, but did they really? For instance, Doug Benefield's peeking into my windows. My neighbor told me that Doug Benefield was peeking in my window. Okay, let's think about this. She said it was her across the street neighbor. Okay? So these houses face each other. Their backyards are behind the houses. The neighbor said, I saw somebody walking in my backyard that had a ball cap on. It was dark. I couldn't see what he looked like. And when I asked him what was going on, why was he there, he said he lived there. And somehow this translates to this person is looking into your windows across the street, and the neighbor couldn't identify who it was. And here comes Ashley with her recording. Here, let me play this. Did you recognize his voice? Does that sound like him? Okay, it was Doug. Doug was peeking in my window. Really. Then the next spoke on the wheel is using children. This man did nothing but try to see his child over and over and over. Ashley Benefield kept his child from him. So if anybody was using power and control, it was Ashley Benefield against him. And I think if you look at a lot of these spokes, you're going to see a lot of behaviors on the part of the defendant that were actually using power and control instead of being a victim of power and control. Then male privilege is the next spoke. There was absolutely no evidence of male privilege. There was an email to the realtor to get a house, just as one example. And if you read that email, he says, okay, but I have to check with Ashley first. How is that male privilege? He's telling this guy he's going to talk to his wife. Using economic abuse. Again, they didn't live together. Ashley Benefield's financially independent. She has her own home. She's completely separate, has her own car. That doesn't apply. Using coercion or threats. No threats. She didn't say there were any in those 3 years. None. There were no allegations that he threatened her or hit her or did anything. He didn't make any reports or threaten to report her to Department of Children and Families. He didn't say, oh, you better do what I say or I'm going to call DCF and tell them you're a bad mom. No. That was the other way around. That's what she was doing to him. There were no allegations that he was trying to get her to drop charges. Quite to the contrary, she was not dropping any charges of anything. And Mr. Ferris talked at the end of his testimony about domestic victim mentality. So let's talk about this. One of the things in the domestic victim mentality is covering for the abuser. Like making excuses, covering for them. Did you ever hear any evidence of the defendant doing that? Never. Making excuses for the abuser, making excuses for their behavior, not once. She was telling everybody, anybody that would listen. Not reporting abuse, same answer. She was telling anyone that would listen and a bunch of people that wouldn't listen. Dropping criminal charges. That certainly didn't happen. The domestic victim mentality, she won't stand up for herself. Never saw that with this defendant. And she won't leave the relationship or the home. She left. She left the home, she left the relationship. They were not together for 3 years. So how does this domestic violence mentality, domestic victim mentality even apply to her? It doesn't apply to her. And don't be mistaken about what applies to her and what does not. Even, like I said before, even if you think that Doug Benefield's behavior was inexcusable and abusive in South Carolina, you have to remember that we are talking about 3 years later. After all of this, time has gone by and there are no allegations of anything else in between. So I want to talk to you a little bit about the jury instructions that the judge talked to you about. I just have a few on here that I want to go through. It's got to be overwhelming, I know, when you read the packet. There's a lot of words. So I try to help break it down a little bit. So the defendant is charged with murder in the second degree. So I would recommend the way you go through this is check off the things that you don't have to argue about. If everyone agrees to one of these, just check it off. So number one, Doug Benefield is dead. That should be easy. Check it off. There's no dispute. Number two, the death was caused by a criminal act of Ashley Benefield. Check it off. She shot him. Number 3, there was an unlawful killing of Doug Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Now that's a lot of words. So what does that mean? The next slide explains what that means. An act eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, and again, check off things, okay? So a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. Shooting a gun, firing a gun into someone clearly qualifies. A person of ordinary judgment would know that that would kill someone. Check. Let's go to number 3. That this act is of such a nature that the act itself indicates an indifference to human life. Pulling a trigger, pointing a .45 caliber firearm at someone and pulling the trigger 4 times shows an indifference to human life.
For preservation of
So
your
then
own.
we go back to number 2. If the acts are done from ill will, hatred, spite, or evil intent. Now notice, this is or. It does not have to be all of those. Ill will is a pretty low threshold. What is ill will? Devising a plan to keep this man away from his child. Is that ill will? Sure. Filing complaints against him that are unfounded and nobody ever files, fictitious complaints, that's ill will. Trying to do anything she can to keep this child to herself is ill will. Everything she did was for this goal, and everything she did was to get Doug Benefield out of the way. And unfortunately, the way she did that was by killing him to get him out of the way. That is ill will, hatred, spite, or evil intent. Now, the judge read to you that there's something called a lesser included offense. And what you may have heard, but it's in your packet, is the way you should handle a lesser included offense is such. So if you agree as a jury that the state has proven a charge beyond a reasonable doubt, you should start with the highest charge. So start with second-degree murder. And if all of the jurors agree unanimously that it's beyond a reasonable doubt that the state has proven their case and the defendant is not entitled to self-defense, then you don't even get to manslaughter. You don't have to go and then review manslaughter. You stop at the highest charge. You only get to manslaughter if you don't agree on the top charge. Then you get to the description of manslaughter. And again, check off the things that you are not arguing about. Doug Benefield is dead, check. Ashley Benefield intentionally committed an act or acts that caused the death of Doug Benefield. Yes. There's no question as to that. Now, the state did prove this, but the state also proved the added element of ill will, hatred, spite, or evil intent. So we have proven manslaughter, but we have also proven above manslaughter. And I want to show you the verdict form, and then we'll go back. This was the verdict form that the judge showed you.
It's just over half an hour in.
Just to let you see it ahead of time. And this is the heading that the judge read. We, the jury, find as follows. As to the defendant, in this case, check only one. And here's A, B, and C that the judge talked to you about. Defendant is guilty of murder in the second degree as charged. Defendant is guilty of manslaughter, a lesser included offense, or defendant is not guilty. And then if you find A or B, then you have to answer all 3 of these questions. And then the foreperson will sign it and print their name. So the real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are 2 words that come up all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words. And like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately. So let's get to the date of the offense, okay? Clearly, these two are getting along, at least according to Doug Benefield. He thought they were getting along. If you look at the text messages between the two of them, if you go by the information that you had from the witness stand that Ashley was acting nice, she was acting like they were going to try and reconcile in Maryland. They were moving together. They were using the same truck. He was coming to her house to help her move the heavy things. So they were getting along. They actually went to the mediation during this time. It was about 3 days before she killed him. They had mediation where they said they were going to drop everything, move into Maryland, everything's going to be fine. But obviously that was not Ashley Benefield's plan because she knew she wasn't going to drop the injunction. Obviously, the day of the offense, Doug Benefield had a right to be at the house. She invited him over. They had text messages back and forth. Trucker on the way, you know, he's taking a picture of the stuff in the back of his truck. And she'd let him in the gate numerous times before. So he had a right to be at the house. She clearly was not afraid, but she had him over. And then her mother clearly was not afraid for her because then as soon as he gets there, she goes to the park with the daughter. So nobody's afraid at this point for Ashley Benefield's safety. And there's only one person who knows what happened in that house that is still alive. And that's Ashley Benefield. And you heard her story. And she made herself a witness just like any other witness in this trial. And you will judge her credibility and the truth of what she said just like you do any other witness. And see if it matches the evidence in this case. If you noticed, when being asked questions, she became evasive. If questions got a little too difficult or she didn't really have an answer for it, specifically on cross-examination, she would use methods to avoid answering the question. One of the methods that you saw over and over was, I don't know, I just don't know, I don't know. The other method was crying. Started crying. Did you ever see one tear come out of her eyes?
Yes.
Did you ever see one drop of liquid? One red eye? One swollen eye? She had a breakdown. We had to take a break. Crying hysterically. Takes the stand right after that. Eyes are just fine. Makeup's just fine. That goes to her credibility. What is she trying to convey to you? The truth or her version of events? Let's look at what she did say. She said during this move that Doug bumps her on the shoulder a couple times, body check or something. She didn't really act that out very well. Who knows what that was. Doug carrying a box, rammed a box into her stomach and scratched her. But did you see those pictures? Does that scratch look like a scratch from a cardboard box? Does it, I mean, wouldn't you expect a bruise to be there as well? You'll have the pictures in the back. So look at those pictures and see. There's no bruising. They look like cat scratches. The defendant also said when they were by the front door to the house that he grabbed her by the wrist and hit her in the head. So when I asked her, okay, what do you mean hit? Well, I don't know. Okay, was it an open hand? Was it a closed hand? What was it? I don't know. She should know if a grown man balled up his fist and punched her in the side of the head. And there would be a lot more damage than what she claimed she had. But she didn't know. He just hit her. Now, 4 people testified that they saw her after this incident, very shortly after this incident. Well, one of them was 3 days later, but the rest of them were very shortly after this incident. John Sants, the neighbor, he didn't see any swelling. He didn't see any injuries. He didn't see any disheveled clothes like there'd been a rumble. Detective or Officer Burrell, Deputy Burrell, was the one that put her in the back of his squad car. No injuries. Didn't notice any injuries to her head or swelling to her face. Crime scene tech Dvorak took pictures. Didn't notice any injuries, any swelling to the face. 3 days later, crime scene tech Conlon takes pictures just to make sure, because bruises don't always come up right away, that she's not bruised. No bruises, no swelling, no nothing. But yet the defendant sits right here and tries to tell you that her eye was droopy and the side over here was swollen. Let's look at these pictures. These are 4 pictures that were entered into evidence. The first picture was, the defendant said, was before she even knew Doug Benefield. She thought it was before she even knew him. The second picture over at the top, over on the right, is the night of the shooting. Down lower left is 3 days later. And then one over is about 5-6 weeks later.
Camera's gone. Please show this.
Does it really look like her face is swollen? She said the side. She said right here. On the right side. Or, I'm sorry, the left side. Right here. The left side of her face doesn't, it actually looks slimmer than it did in the picture taken before she even knew Doug. So let's talk about what she did when she claims that Doug grabbed, I think she said she was going for the front door. He grabbed her arm. She kind of spun around. He hits her in the head, although she didn't know if it was open hand or not. And then she said, I just wanted to get away. I just wanted to get away. Right? Here's the front door. Right? She went this way and could have gone right out the door. But she just wanted to get away.
You guys, please be careful. No name calling in chat. Okay?
She turned to her right and went into this room. This room that has nothing in it except for a mattress, a broom, and a hamper, and 2 handguns. It's hard to see in this picture because of the lighting, but I just want to remind everyone, here's the mattress, here's the broom, nothing else in this room, but there's a hamper right here with a gun on it, and there's a gun in this closet right here. And that's where she runs. And this is a better picture of the hamper and where the murder weapon was. So she just wants to get away, but she runs into the very back corner of this room and grabs a firearm. Now, she claims that as she's retrieving this firearm, he slams the door open and she turns around, right? And she sees him standing there. When I asked her to get down and show me what he was doing, that was another one of those evasive talk. I don't know, he was in a fighter stance. I don't know what fighters do, but I know it's a fighter stance. Okay, well, show me. What do you mean a fighter stance? I don't know, kind of like this. Okay, well, what are his hands doing? Just kind of moving around. Okay, so his hands are kind of moving around, and it didn't look a lot like a fighter stance. And then she said, I'm standing there with the gun pointed at him, and he lunges at me. He lunges at me. Let's think about this. So if she's standing in the room, she has the gun in her hand, and he just came in the door, and she's pointing the gun at him. She says he takes a fighting stance. First of all, he's right-handed. Do this yourselves when you get in the back. If someone told you to get in a fighting stance, what would you do? And determine for yourselves, use your common sense, which side would be bladed away? I think you'll find that your strong hand is going to be the one that's bladed away. So if he's right-handed, he's in a fighting stance, he's going to be like this. Interesting, because he's shot from this side. So he's like this, and then she says he lunges at me, right?
Oh, guess which side just went
forward? So if he lunges at her, he's head on, straight on to her, lunging. That bullet hole would have been here and out here. Would have gone straight through him, front to back. That is not the way that bullet went.
She lunged. And went forward with the right hand. Then she corrected and straightened out again.
And if he's in a fighting stance and he's right-handed, why would he have this side towards her? And
because of the lunge.
Mr. Haig, the expert, the firearms expert, displayed when I said, okay, I'm going to point a gun at you. You show me where your body would have to be in order to get that trajectory. And he turned sideways. So his body in his fighting stance would have to be completely sideways. And what, he's skipping to her to lunge? I mean, how is that trajectory going to happen based on what she said? More than likely, the hands that were up was a defensive stance. He probably came into the room and said, whoa, she's got a gun, and started to turn around. He had his hands up, like, whoa, what are you doing? It makes no sense to be in a fighting stance. So I want to talk a little bit about this trajectory.
More than likely is not beyond reasonable doubt.
There's sort of some misconception that this shot was front to back. That is just the planes with which the medical examiner uses. So it can be a little confusing. But if you look at the way this arrow is, the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from the back. So if it went in on the side, the right-hand side, and that red dot is where it landed in the back.
That's worse. That looks like it's right in the middle of his back.
And let's talk about the leg wound. It's very hard to determine exactly how this leg wound happened. And we may never know exactly how it happened. But this is the basic trajectory of it if a person were in a normal standard anatomic position. This is the medical examiners said that. This is a standard anatomical position. So in a standard anatomical position, that is the way the wound path went through his leg.
Why does he have a belt?
So you can figure out for yourself different ways that might have happened. Now, Dr. Lou said, based on information that she got from Ashley Benefield, by the way, that it must have happened this way. That once he shot the first time, somehow he falls and his legs go way up in the air and he shot like this. Where did that bullet go? If he was shot like that? The expert testified about the two that went into the wall had not gone through a body. He said the one that hit the leg was in the room. Might have been kicked, and that's normal when you have emergency technicians in there and they're kicking things around. But the projectile was in the room. It was not in the wall. So if he's falling back this way and his leg's flipping way up, and by the way, Dr. Vega said the only way your legs flip up like that is if you're falling over a rail or, falling over something and your legs come up that high. So that just does not make sense with the rest of the evidence. Now, this may not be the way it happened, but it is also another way that it could have happened. He is turned away, leg up, and that bullet could have gone in and come out his knee, with his leg is bent. So you use your own judgment and decide what you think about that leg wound. What's important is this wound. This was the wound that killed him, and he was not facing her at the time. The defendant trying to say he was in a fighting stance, he lunged at me, that is just her, once again, trying to manipulate the system. She's trying to manipulate you to believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. I had to do it, but somebody help him. Not once. Not once did you ever hear any concern that I just shot another human being, and regardless of what the facts are. No. And then she sees her mother come by the car. Not once does she say, Mom, he just came at me. Like, I had to shoot him. It was awful. Nope. Not a word. She goes back to her mom that night. Not a word. Really? You're not going to tell your mom exactly what happened? And then this lady, Barbara Russell, that she lives with for 9 months after the shooting, never tells her what happened. Not once. Remember, the defendant sat right there and said the defendant never punched her ever. Never choked her, never kicked her, never came at her with a knife, never came at her with a club, never came at her with a bat. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying, and she goes to the neighbor and not once asks for an ambulance. And he dies, either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. And that's murder. Thank you.
51 minutes, 30 seconds for the prosecution.
All right, Mr. Taylor, do you need the screen?
I do not.
I'll turn that off for you.
Mr. Taylor needs to shine right now.
Yes, sir, when you're ready.
Thank you. Good afternoon, ladies and gentlemen. I have a bit of a cold. I tested 3 times and it's not COVID. Don't need to be concerned. I've just listened to the state's closing argument. I have to tell you, I think there's obviously some real different perceptions of what the evidence is. I think perhaps there's even been some distortions. You all have taken, we've observed, pretty careful notes. If I say something that is not reflected in your notes or is not as you recall it, I want you to trust your own recollection. But I think if you check your notes, you will find that what I represent to you is accurate. This is and has been a fundamentally flawed prosecution. And I think we can demonstrate that through the testimony of two of the state's witnesses. The first is Stephanie Murphy. And you may recall she was the attorney who was representing Douglas Benefield. In my cross-examination of Stephanie Murphy, I served up for all of us, but especially for you, the members of the jury, what the state's theory of prosecution was. And I said, so Miss Murphy, let's be clear so that there's no misunderstandings. It's your belief and the state's theory that Ashley Benefield killed her husband because the Broder report was scheduled to be released 3 days later. She said that's correct. Check your notes. Now, the state, in their opening statement, even made it dramatic. They said to you, this report by Dr. Broder was to be released on the 30th of September, but she killed him on the 27th to avoid that. If you look at the emails that have been introduced into evidence that reflect the conversations back and forth between Stephanie Murphy, Faith Brown, Miss Benefield's family court attorney at the time, and the judicial assistant for Judge Moreland, you will read in no uncertain terms, black and white, the Broder report was not set to be released on September 30th. Not only was it not set to be released on September 30th, there was not even a day for it to be released scheduled. Stephanie Murphy was attempting to have it scheduled. The JA wrote back in no uncertain terms, Judge Moreland will not hear that. The only thing being heard on September 30th is the domestic violence injunction. The other witness that I think reflects what a fundamentally flawed prosecution this is Detective Gillum. Now, you might recall that Detective Gillum, check your notes, said that the South Carolina domestic violence injunction that required no contact by either one did not go into effect until November 27th. But if you look at the written email that we introduced into evidence, where Detective Gillum is contacting Gina Torsha, Miss Murphy's assistant, Detective Gillum tells her, wait a second, he's helping them. Wait a second, this injunction, unless I'm reading this wrong, went into effect on November 3rd. The judge signed the order on November 27th, but on November 3rd, he announced it in open court, and Doug was present, and so was Ashley. So unless I'm reading this wrong, I want you to be aware of that. This is Gillum trying to help them. This is the same Gillum who gives you quotes of exactly what Ashley Benefield said 2.5 years later without having one word of it written in his earlier report. The same Gillum who I asked the following questions of. Detective Gillum, do they teach you in police academy about the importance of writing reports? Sure. And is the reason why the reports are so important is because it preserves important facts about a particular incident? Yes. So how many cases do you handle, Detective Gillum, in a month? You might recall he said, oh, probably about 20. And then we multiplied that out by 2.5 years. I think we were into about 600, 700 cases. Yet he remembers the exact words she had to say, despite the fact that on the day she said it, not one word of it appears in his supplement 2.5 years earlier. Ladies and gentlemen, Detective Gillum, you might also recall, countermanded the capias, the arrest warrant that the other deputy issued for Doug Benefield when Ashley went down there and explained that Doug Benefield had mailed her this package in violation of the South Carolina restraining order. Detective Gillum said he remanded it, he reversed it, and he was going to refer it over to the state attorney's office. This was a good old boy network. They liked Doug, and they never looked back. And that's the truth of the matter. Do you not find it astounding that Detective Gillum 2.5 years later could remember such things as Ashley Benefield saying, if the judge sees you arrest him in front of her, it'll help me keep my baby. Isn't that something that you would put in a report? I think perhaps the most disturbing thing about the testimony of Stephanie Murphy and Detective Gillum is the following. Remember that common sense I told you about that you're going to be able to take with you back into the jury room, and that without offending anybody, there would probably be more than 100 years worth of it, which there is. Does anyone believe that either side calls witnesses that they don't know what they're going to say? So how do you reconcile the state calling Murphy and Gillum knowing that they're going to testify inaccurately? Read Gillum's written email about how he misrepresented his knowledge of when that South Carolina domestic violence injunction went into effect when he testified in front of you, and read the emails between Stephanie Murphy, Faith Brown, and Judge Moreland's judicial assistant. Okay, so what happens after that testimony? Now, I want you to remember that the state's theory of prosecution up to that point is that Ashley Benefield killed Douglas Benefield to stop the release of the Broder report because she was so afraid of what was in it. And right in front of your eyes, I've never seen it before, right in front of your eyes, the state changes their theory, and the next thing you know, their theory of prosecution is she killed him because the domestic violence injunction was scheduled 3 days later. Check your notes. See if what I'm telling you is not accurate. Both theories, honestly, are ridiculous.
Objection, Judge.
Sustained on that.
Both theories are not supported by common sense. Let's look at Broder. What exactly was it in Broder's report that Ashley Benefield was so afraid of that she killed Douglas Benefield? Check your notes, but try to think back to Broder's testimony. I think your notes will reveal that Broder never had one thing adverse to say about Ashley Benefield. In fact, the only thing that Broder had to say was that after evaluating Ashley Benefield, he found that she had no violent tendencies. She was not prone to impetuous acts. That's it. Her only concern, according to Dr. Quintel, was that she was afraid if Doug found out what she had to say about him, that he would take it out on her or on the child. Okay, let's look at the theory then when it shifts to it being the domestic violence injunction that was scheduled for the 30th of September. What kind of reason exactly is that for her to kill Doug Benefield? If that was a reason, wouldn't she have done it before? There was already a domestic violence injunction the first time. It was denied. It was not only denied, but Judge Moreland ordered shared custody of the child. Why wouldn't she have killed him then? For 4 years, Ashley Benefield did what any law-abiding citizen can be expected to do. She filed complaint after complaint after complaint, calling Doug Benefield's behavior to the attention of the authorities with no result. Over and over again. No relief. So she kills him? Really, that's quite a leap, ladies and gentlemen. You need evidence to support such an inference. You know, you can't take innuendo and wrap it up in an inference and call it a fact. You got to have evidence that supports a theory. For example, you know, in the reasonable doubt instruction, I'm going to show you in a minute, but it says a reasonable doubt can arise from the evidence, from the lack of evidence, and from a conflict in the evidence. So what evidence would you need to show to support this theory that flies in the face of common sense? Well, how about somebody who comes in and testifies, yes, I heard Ashley, I overheard her say, you know what, I'd kill this SOB before I'd let him be alone with my child. Or how about this? How about downloading from Ashley's phone when she's sitting there in her most private moments, never expecting it to be revealed to the world, searching on the internet how to kill an abusive spouse? How about that? Instead, what you saw in her most private moments, 6 months before this happened, was her searching on the internet how to co-parent with an abusive spouse. Am I making this up? Check your notes. How to get along with an abusive spouse. In my opening statement, I told you two things. I said that at the conclusion of the case, those were the only two things that would be established beyond the reasonable doubt. The first one was that Doug Benefield was a very sick guy. I think there's no doubt of that. The second thing was that Ashley's action on that day, September 27, 2020, was absolutely justified. Let's take a look briefly at Douglas Benefield's behavior. And I want you to keep in mind Bruce Ferris's testimony, who's the former cop who specialized in domestic violence, ran a domestic violence department, and then was so fascinated by it, went back to school to become a licensed mental health counselor. I thought he was a pretty persuasive witness. Doug Benefield shoots a gun into the ceiling of their kitchen to intimidate Ashley to stop speaking. Now, those are easy words for me to speak. And they fall on ears and you move on to the next thing. But I want you to try to imagine how it would feel.
Objection.
Sustained.
That was improper.
How would one feel sitting
still objection.
in their kitchen, having their husband pull out a gun and actually fire it into the ceiling of their kitchen? Can you imagine the trauma of such a statement? Do you think that that's something that you forget about after 6 months, after a year? I think that's something you remember for the rest of your life. You never forget it. Throwing a loaded gun at Ashley Benefield, threatening suicide, not only to Ashley, but to his former wife, Renee. You've got a copy of her text message that she wrote to Doug, kicking her on their honeymoon and threatening suicide. So this is twice now, not only with Ashley, but with his prior wife. Punching the dog so hard that he knocked the dog unconscious. Bruce Ferris on the wheel. Now, I'm not an expert on the wheel. I don't pretend to know it anywhere near as well as apparently Miss O'Donnell does. But I can tell you with certainty that it has a provision, and Bruce Ferris elaborated on the fact that abusers tend to hurt pets because they have no empathy, and because, check your notes, they can control the victim because the victim loves the pets. So hurt the pets, you keep the victim in line. You get compliance, control, and compliance. That's what they seek. Threw the cat down the stairs. Put a tracker on her car. The neighbor catches him in the yard at night. It wasn't in the house across the street. You've got the schematic of the houses in the neighborhood. You see Mr. Sand's house is right next door, literally, to the left of Ashley's house. Ashley's house has got the red dot on it. Cursing, yelling, screaming, belittling. Text messages, I'm in a murderous mood. I want to rid the earth of them. Take them out. That was about two guys having a conversation while Ashley was on a cruise. Doug Benefield was so demented that just hearing in the background two men speaking while Ashley was on a cruise makes him say he wants to take them out, rid the earth of them. That puts him in a murderous mood. Of course, Ashley at the time at 24 thinks, well, gee, that's kind of flattering. I guess this guy really loves me. Oh, that was just a little tip of the hat to what was to come. The South Carolina injunction He violated it. There's no way around that. How about driving from South Carolina to Florida so that you could follow Ashley in the car? I mean, if that's not determination, what is? If that's not fixation, what is? If that's not obsession, what is? And most chilling, I thought, was Mr. Vincicaro, the realtor, who, while the injunction is in effect from South Carolina, look at the email between Doug Benefield and Vince Vincicaro. I asked him, did you have any dealings with Douglas Benefield? Yes, I did. What was it? He was a customer looking to buy a home. Where was that home? It was the house immediately behind Ashley Benefield's house. This is sick, ladies and gentlemen. This is while the domestic violence injunction is in effect. Not only that, but then he says to Mr. Vincicaro, well, I have to first check with Ashley. Well, you know that's a lie. He can't check with Ashley because the injunction doesn't allow him to communicate with Ashley. So what's the basis for that conclusion that Doug was that disturbed? Well, how about Doug's own admissions? You have the text messages where he admits to Ashley, you know, I'm sorry, I apologize. And according to Miss O'Donnell, well, that should be the end of it. You apologized, it's over. Unfortunately, Bruce Ferris explained to you that that's the MO of an abuser. Oh, baby, I'm so sorry. Please forgive me. It'll never happen again. And it happens again. Time and time and time again. That's their pattern of behavior. And Bruce Ferris told you that. He explained that to you. Ashley Benefield got on the stand and told you about all of that. And I have a great discrepancy. I'm wondering if we were at the same trial between Miss O'Donnell's evaluation of Ashley's testimony and ours. But how about this, in addition, as a basis to establish how disturbed Doug was? How about the letter that Ashley Benefield leaves for Doug on November 17th?
Objection, not entered in evidence.
Sustained.
Judge, I was testified to by Ms. Benefield. I'm just speaking to the letter, not quoting from the letter itself.
Okay.
So she told you that she left him a letter. She told you what she put in that letter. That letter recounted some of the things that he did. Some of the things that you heard about in the trial, such as shooting the gun, punching the dog.
Content of the letter.
So, how about that as a basis to support it? She described them as controlling and manipulative. You're putting me and my unborn child in danger by the way you drive. You drive crazy when you get angry. How about Dr. Quintel? He doesn't even have a dog in this fight. He's got absolutely no reason to shade his testimony one way or the other. What did he tell you that he concluded about Doug? That he was, quote, super controlling, unquote. That he was jealous. That he was intimidating. That he was a real alpha male. Dr. Quintel's description, not mine, ladies and gentlemen. And then we have Ashley, who's the victim of domestic violence. We have the history of the prior acts of domestic violence by Doug. According to Dr. Broder, the state's witness, and Bruce Ferris, our witness, victims of domestic violence look for appeasement. Dr. Broder, I even asked him, I think that word appeasement appears in your report about at least 4 times. They go along to get along. They walk on eggshells, always afraid that something they might say will set them off. And according to Bruce Ferris, what the abuser wants is compliance. That dynamic changes very significantly once a child is introduced into it. And why is that? Because the abused woman is going to look to protect her child. That's what mommies do. So she will put herself in danger in order to stand between the abuser and her child.
That's going to resonate. We've got 7 women and 2 men.
Miss O'Donnell argues,
so far,
well, when they first exchanged custody, as Stephanie Murphy said, Ashley looked happy and very content. Well, we know from Bruce Ferris that that's the compliance mode. That's what you do to protect your child. She knew how Doug was. He went off on her. The only thing worse than that would be him going off on Emerson, the child. You keep the beast at bay. Those were the words of Broder and of Bruce Ferris. Importantly, Bruce Ferris told you that victims of domestic violence appear to act happy. So you have these text messages in the week leading up to the shooting where they're saying nice things to one another with emojis and smiley faces. And you have the video of the restaurant where Ashley and her mother and Emerson are present. And Ashley appears to be acting happy, when in fact she's actually quite scared, according to Bruce Ferris. But you go along to get along. You might recall in the voir dire, I asked you about the presumption of innocence and how many of you had ever seen a cop car on the side of the road with somebody sitting in the back, and the first thing you thought to yourself was, gee, I wonder what they did to cause them to be in the back of the squad car. And I told you that the issue to be resolved in this case was going to be, was the force used justified? All of you pledged that if the state failed to prove their case beyond a reasonable doubt, your verdict would be not guilty. All of you took an oath that said, at the end of the case, if you were unsure, if you did not know what happened, if you did not have an abiding conviction of guilt, you'd vote not guilty. I want to show you the beyond a reasonable doubt instruction. Deputy, if I could have the easel, please. This is in your packet of instructions. You're not going to have to memorize it. I want to just go over it, though, for a moment. I think we can agree it's pretty important. It reminds you that the state has the obligation and the burden to prove the case overcome the evidence to the exclusion of and beyond a reasonable doubt. And here's how they define reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, goes back and forth, gee, I don't know, I'm not sure, then the charge is not proved beyond every reasonable doubt, and you must, not you can, ladies and gentlemen, not you may, you must find the defendant not guilty because the doubt is reasonable. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. Thank you, Deputy. Let's take a brief look at the facts rather than theories. Because once again, the prosecution could not have been more clear. Ashley killed Doug to prevent release of the Broder report. So, where was the evidence to support that theory? You can't simply say it and make it so. Ms. O'Donnell comes up, and the evidence that she presents to you to support that theory is that Ashley said, I'll take matters into my own hands. Ladies and gentlemen, Dr. Broder testified that Ashley made that statement on her way out of his waiting room. And I asked him specifically about it. Please check your notes. What was she referring to?
So far,
and he said, going to the authorities in Maryland to seek relief from them because the system here had failed her, and she was very frustrated. Ms. O'Donnell also told you that Doug Benefield filed for sole custody of Ashley. Please check your notes. No one ever testified to that. There's absolutely no evidence in this case that such a thing was done or a statement was made. Other evidence in the case? Justin Warren, the lead homicide detective. State never even called him.
Objection.
We called him. What did he tell you? He told you that in his arrest warrant, he said it did not appear that Douglas Benefield was facing Ashley Benefield when shot. Now look, Dr. Vega came in here and testified that the shooting in the chest, the shot to the chest, was from front to back. Yet Miss O'Donnell comes up here and distorts that and tries to tell you that it wasn't from front to back. It was from side to side. Dr. Vega told you the trajectory of the chest shot was front to back, right to left. Now, not only did Dr. Vega tell you that, Michael Haig told you that, front to back. Dr. Liu told you that, front to back. There has never been any evidence introduced in this trial that the chest shot or the arm was anything other than front to back. Detective Warren told you he did not speak with the medical examiner before he submitted his arrest warrant. I showed him his report to refresh his recollection. Oh, yes, I did speak to the medical examiner. And finally, I asked Detective Warren about a supplemental report that he wrote where there's a section that provides for any bias that he was aware of that Ashley would have had against Doug. And the form was written none. And I asked, is that not where you would write in things like ill will, hate, or spite? Mike Haig, let's look at his testimony for a minute. I think you'll remember him. What he said, I thought, really presented it well, was in explaining what forensic meant. He said it's the juncture where law meets physical science. Okay? So he told you there were 4 shots. He gave you a 3-dimensional diagram, and it showed you the room and how the shooting took place and where the shots went. One shot, according to Michael Haig, went out the door and down the hallway and lodged in a book. He described it as a miss. One shot was in the wall. Told you it was a nice round hole in the wall. They put a trajectory rod in it. One shot was in Mr. Benefield's chest. It was lodged in his back. Dr. Vega removed it. And one shot was in the leg. The state's own witness, crime scene people, told you that the shot to the leg was on the floor in the room and that a piece of it had broken off, and Haig told you that as well. According to Ms. O'Donnell, if you completely suspend the explanation that Dr. Liu gave you about the shot to the leg, if Douglas Benefield was running away, that's how you could get the shot in the leg. You might remember that the trajectory or the wound path to the leg was up. Ashley would have had to have been lying on the floor to shoot up so that the bullet would go in her calf. Dr. Liu explained to you exactly how that happened. We even had our summer law clerk, William Galvano, come here and demonstrate it.
It's a proper argument.
Shout out to William. First mention in court in the court record, and he got objected to.
What else did Michael Haig tell you that was significant? He told you that they were moving. He said both Douglas Benefield and Ashley Benefield was moving. And he even showed you how it went from right to left in that 3-dimensional diagram, with the first shot out the door, the second shot in the wall, or one shot out the door, one shot in the wall, one in the chest and one in the leg. He showed you the 2 different cones. That would be consistent with what Ashley told you about trying to get more distance to move away from him. There was only one way to go in that room. She was already back to the back of the room, so the only way she could go was sideways, to her left. Finally, he also told you that Ashley's explanation was absolutely consistent with the physical evidence. Then we had Dr. Liu, Emma Liu, former medical examiner for Miami-Dade County, who has always testified for the state. Except here, she came in and testified for the defense. Why do you think that is? Dr. Liu told you that the abrasion to the arm, she believes, was from front to back, and she believed it was the shot that went out the door and down the hall. And the bullet would not have mushroomed or expanded, as you heard Michael Haig explain, that bullets are designed to be able to expand, because the wound was so superficial, there would not have been enough tissue in the hollow point of the bullet to expand it. She also told you it would be consistent with Doug lunging at Ashley Benefield. And she showed you with rods how the abrasion to the arm would take place, as well as the shot to the chest. Now here's something interesting that maybe everybody's forgotten, Miss O'Donnell did not address. Who was it that told us that Doug was skilled in martial arts and trained to take the weapon away? Why, that was his daughter, Eva. So here's Doug, who gets into his fighting martial arts position and lunges at her to grab the weapon, and Dr. Liu explains the abrasion shot. All four of these shots had no pattern at all. These are four random shots, no association whatsoever, indicative of somebody who's in an absolute panic firing a gun. What's more, as not only Mr. Sant told you, Mr. Haig told you, and as the state's own witness told you, if you don't hold the weapon properly and give it, it will result in a jam from one of the cartridges, just like what happened here. So I want you to please consider something. Before evaluating the defense case, you have to first determine whether or not the state failed to prove that the shooting was unjustified. That's your first order of business. Because if the state failed to prove their allegations beyond a reasonable doubt, it's over. You don't need to evaluate the case that the defense presented. We weren't obligated to present anything, but we did. And I think we can agree that if the state's case does not meet that threshold of beyond and to the exclusion of every reasonable doubt, your verdict must be not guilty. Ashley Benefield got on the stand and endured over 2 hours of cross-examination. It was our perception that the state never landed a blow in over 2 hours. That's 2 hours in addition to the hour and a half that I had her up there on direct examination. in the world in which we live, it sounds strange to try to reduce an event like this to an explanation within an hour and a half. But this is the only form that we have to resolve things like that. So we did it. And Ashley got up there and she explained to you exactly what happened. And she did it well. And the state never touched her. Look at the crime scene photos that were taken, not at some modeling presentation, not at some outing. Look at the crime scene photos that were taken by Miss Dorvac. They're in evidence, and you see if you don't see swelling and redness on those photographs. So it's September 27th, 2020, the day of the homicide. Doug arrives at Ashley's house late that afternoon, and he's already simmering. He's on a slow boil, ladies and gentlemen. Why? Because he knows she's leaving. She's leaving. He's not going with her. He's going to live somewhere else. He knows that. This was his last hope for any kind of reconciliation. And Bruce Ferris told you that the most dangerous time for a domestic violence victim is when the abuser recognizes that she's leaving. So how does Doug respond? With threats and intimidation. He would not leave. Ashley tried to de-escalate it. She could see how he was starting to build. She wanted to avoid a confrontation. Gee, you know, Doug, we pretty much got everything done. Why don't we quit for the night and we can continue tomorrow? He ignored her. Instead, his hostility starts increasing. 2 body checks where he bumps her shoulder passing her in the hall. And it's not a bump that's an accident. It's a bump to intimidate her. She told you she almost lost her balance. Then we have the cardboard box incident where he slams that into her. Once again, she tries to de-escalate it. She even apologizes to him, and I asked her, why in the world would you apologize when he was the one who hit you with the box? Well, shortly after that, Ashley's had enough. What does she do? She tries to leave. She tries to flee the house. He catches up to her, grabs her by the hand, whirls her around. His back is now at the front door, and he's got her blocked. Somehow, Ashley finds the inner strength to yell, "I'm done. You need to leave now. I'm done. You need to leave now." Please check your notes. That's going to be real important. Why? Because that revoked Doug's permission to be in Ashley's home on that afternoon. And here's what the instruction is going to tell you about that. It's in your packet. It's going to say the law on justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, I think we can all agree this was her home. Doug did not live there. He was there by her permission on that day to help pack things. She had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed such conduct was necessary to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1. Douglas Benefield had permission or consent to enter the dwelling or structure owned by or in possession of Ashley Benefield. 2. Douglas Benefield, after entering the structure, remained inside after permission to remain had been withdrawn, and with the intent to commit an offense other than burglary or trespass inside the structure.
That word
the
is
offense
hard.
was false imprisonment. Ashley tried to leave her home. Doug stopped her, spun her around, and held her trapped inside the house. Or B, attempt to commit a forcible felony. Forcible felony is aggravated assault. Through threats and intimidation, Doug committed the offense of aggravated assault. It's in your packet, read it. The important point is that once Ashley says, "I am done, you need to leave now," he becomes, in essence, a burglar by remaining in that house after she tells him to leave.
Sounds like he has an extra syllable in the burglar.
Not my law, the law that Judge White has given you. The last witness that we saw was Amy Carlton. And you might wonder how Miss Carlton fit into all of this. Well, actually, she played a very significant role. We called Amy Carlton to show that this was anything other than a staged event. If you accept Miss O'Donnell's interpretation of this, it was a staged event. It was a setup. Miss Carlton told you that she was out walking her dog with her husband. They heard a series of shots, and less than 30 seconds later, Ashley emerged from the house, hysterical, screaming, holding the gun, and ran right next door. If you're going to stage an event like this after the shooting, you're going to certainly check the scene to make sure it's going to support your version of the event. Because if it doesn't, you're on your way to prison. It's going to take you longer than less than 30 seconds to do that. The state has failed to prove anything here beyond a reasonable doubt. We prove self-defense beyond all doubt. But the burden is not ours. It's theirs. And they must prove it beyond and to the exclusion of every reasonable doubt, which, ladies and gentlemen, they just have not done. So, for the last several years, I've walked hand in hand with Ashley.
Objection.
I'm now going to surrender her fate to you. I've presented to you everything that I possibly could to show you the dynamics of what took place on that day and why they took place and what Ashley knew about Doug at the time they took place, to show you that her action in using deadly force was reasonable. The judge is going to tell you in your instructions you can take into account what she knew about the domestic history with Doug, the size differential between Doug and Ashley. Ladies and gentlemen, Ashley Benefield is not guilty of murder in the second degree. She's also not guilty of manslaughter When you read the manslaughter instruction, it tells you that it is not manslaughter if the shooting was justifiable, if it was in self-defense. The manslaughter instruction tells you that as well. You all promised in voir dire that you would stick to your guns and not be intimidated by the majority or the other jurors. Manslaughter is a compromise. Ashley's not looking for a compromise. She's entitled to more than that. This is either second-degree murder or it's not. If you follow the oath that you took and you read the instructions, we're confident you will return a verdict of not guilty in this case. Thank you very much.
So 56 and a half minutes for the defense.
AB had enough. The defense just said that. AB had enough. She did have enough. On September 27th, 2020, she had enough. She took out a .45 caliber gun and shot Mr. Benefield 4 times. At Mr. Benefield 4 times. And why did she do that? Why had she had enough? I will do anything I have to do to keep my baby. Asshole. To a detective that she demanded
she got the comma in there.
Arrest somebody in a courthouse because that will help her keep her baby. It is not surprising at all that Detective Dillon remembered that. That is an outrageous statement to say to a law enforcement officer. You will arrest him or I will make him. That's what she told a law enforcement officer. Do you think she'll tell a law enforcement officer that and she won't shoot Doug Benefield when she's had enough? No, she would and she did.
Where's she going?
Time is running out. Within a week of murdering Mr. Benefield, time is running out. She said that, I will take matters into my own hands. She said that to a psychologist who was doing reports for the state, for the court. I will take matters into my own hands. And she did, with 45. And let's talk about what we've heard. And it's my job to rebut the defense's argument. That's what I'm here for. And I think we can. And I do ask you to depend on your memory. But I want to set some groundworks. Number one, Ms. O'Donnell and I are clearly part of an old boy network. No, this is not an old boy network. This is law. This is the law. And if those law enforcement officers did not find that they had the sufficient basis to arrest Mr. Benefield, then they wouldn't have. And that's why they did it. That is not an old boy network. That is how our country works. That is what the law is for. Otherwise, any woman could walk into any police station and say, my husband did X, Y, Z, and they're just going to arrest him? No. It requires evidence. It's the same reason that law enforcement took a long time between this murder and her arrest. They were investigating it. They were making sure they had everything they needed to have. And when they did, they effectuated an arrest. And the prosecution, you heard a lot. You heard Ms. O'Donnell's name more than Ashley Benefield's name during that closing. It's not about Ms. O'Donnell. It's not about Ms. Friel. It's not about either of us. It's the state of Florida, and we have the burden. And we've overcome it. It's not a flawed prosecution. Our job is to prove to you beyond a reasonable doubt that the elements in this case occurred, that manslaughter occurred, which it did. Manslaughter is an intentional act that caused a death. She intentionally shot him, and he died. That's a manslaughter, no doubt about it. But that's not enough. She did it because she has ill will, hatred, spite, or evil intent. She had a depraved heart when she shot and killed Mr. Benefield so she could keep her baby. And does it matter if the report was coming out or if that injunction hearing was happening? No. Clearly, Miss Murphy and her client, who was murdered just a few days later, thought that Mr. Broder's report was coming out. Clearly, Faith Brown and Ashley Benefield thought or knew that they were having an injunction hearing on that day. The jig is up. She has wanted this man out of her life. She has wanted her baby to herself. And what is she doing? She's so scared of him, she has him doing her manual labor. You can come over. You can move my stuff. You can get the heavy stuff. You know what? Can you stop and buy me boxes? Can you stop and buy me tape? Do you want to go to the gardens? She told you that she couldn't dress a certain way. She was in a sports bra and shorts when he showed up. You didn't hear that he said a word. You didn't hear that he had insulted her in any way. She would have you believe all these things about Mr. Benefield. And mind you, Mr. Benefield is not on trial. Ashley Benefield's on trial. Ashley Benefield's the one that committed a criminal act on 9/27, 2020, when she murdered him. Don't be confused or distracted by emails and questions that showed you nothing. The question is, were the facts, did you learn whether or not she shot him and at the time she had a depraved heart? And there was no dishonesty by Stephanie Murphy. Don't be confused by that. I think they just had a different understanding of what was going to happen. There's certainly no dishonesty by Detective Gillum. Not remembering something or Detective Warren and being dishonest are two wholly different things. And nobody's expected to remember everything. The question for you, as Ms. O'Donnell said,
Ashley,
is whether or not it was reasonable and necessary for her to kill him, for her to shoot him that day when he's in a shorts and a t-shirt and flip-flops doing her work for her. And keep in mind, this ninja we've heard of, 5'9", 169, adult small t-shirt. Adult small t-shirt, size 30 waist. We know what that means. This is not a huge man. This is not a hulking beast of a man. And the state is not contending that he didn't make mistakes. He certainly did. One of the biggest being trying to maintain this relationship. It ended in his death. But was it reasonable? Never hit her. She said he never hit her. He did some outrageous things, but never hit her in any way, shape, or form. In 3 years they'd been apart. 3 years. Reasonable. Is it reasonable? She would have you believe that, and look at those text messages. Look at the text messages going into that week, that whole week. And look at, I would ask you to read the state's version, because that is the complete conversation. Oh, I'm sorry, those are the older text messages. When you look at the older text messages, this murderous intent, he's talking about her old boyfriends. She admitted that. And them choking her during sex. He's not talking about wanting to go out in the world and murder people. He's certainly not talking about her. It may not be what the average person thinks of a way to express your love, but apparently to Doug Benefield and to her, it was. Because she's like, I know, baby. Don't talk like that. She never checks him, right? She never says, oh, don't. She says, I think she says, it was just a fight. These men that were just talking, she says it's a fight. So don't be confused. Look at the evidence. But in the text messages leading up to that week, look at them. You have them. They're the ones Ms. O'Donnell did that had the video of them playing a game at Panera where they're all yucking it up. I would dispute that she was afraid. I would dispute most of what Mr. Ferris said, but we'll come back to that. So she would have you believe that this man who has never struck her, who in 3 years she reports no abuse. 3 years. He's done nothing. She left him while pregnant, did not tell him that she birthed his baby, did not give that baby his name, and then files before he ever meets his child to terminate his parental rights. And no allegations that he insulted her, came to her house and hit her, did any of those things. Shot any guns, had any guns, none of that. Right? So she did all those horrible things. If you want your baby, those are horrible. To Doug Benefield. She did all those things, and nothing happens. But this day, when she has been dictating for a week when he could come over, when he could help her, what they would do, she would have you believe that he got so enraged because she was done moving and she was tired that he hit her for the first time ever. And you get to decide if you believe her or not. I would submit to you that did not happen. There is no evidence of it, and you know it. You can see by those pictures. I don't care what Barbara Russell, who's clearly biased, right? Barbara Russell is a clearly biased witness. That's her. They have some kind of relationship that is clearly not professional. And she sat there and told you that she saw swelling. Keep in mind, she saw her the night of. This is her. This is somebody who she had a professional relationship with and then moved in. The night of, that's who comes to her, this woman. She tells you that she has edema on her face. I don't know what edema is. I assume it's swelling and bruising. It's not there. You can see in those pictures. You're going to look at them. You can look at them.
Is, but it's not there.
Till the cows come home, you won't see swelling. All those law enforcement officers who are trained to look for that, crime scene techs who went there for the sole purpose of finding injuries, and had some lawyer pointing out that her ear was red. Look at that picture. There's no redness. No redness. So he becomes so enraged that he hits her for the first time. She doesn't go down. She didn't say I fell. This man is a trained fighter who's a ninja, and he hits her and she doesn't go down. And she can't tell you if it was a slap or a punch. There's a big difference. There's a big difference. And if he punched her in the eye, her eye would look way different than it does. There's no swelling on the side from a punch. She'd have a black eye. Not a bruise, not a swell, nothing. So let's say it was a slap. Let's believe her. It was a slap. There's no redness, no swelling, no bruising, no scratching, no evidence in the photos. I mean, if somebody slaps somebody in the face, there's a red mark. Nothing. Within minutes. Stop. And even if you don't believe law enforcement, which I submit there's no reason to not believe them, Mr. Sand, that sweet old man who she brought this drama into his home, said, I didn't see any injuries. Wouldn't he be the one in the best position to see if she had been slapped in the face moments before? Certainly. He didn't see it because it wasn't there. It's an attempt to manipulate the system, which is exactly what she continues to do. And keep in mind, he's flipped out to the point of hitting her for the first time because she's tired and doesn't want to move anymore. That's what she told you. She didn't say she had tried to break up with him. She didn't say she had told him she didn't want to see him again. She didn't say any of those things. She told him she didn't want to live together when they were alone together, and it was fine. It was fine. So he gets so enraged and pops off and hits her or punches her in the face when she's tired, but not when she says she doesn't want to be with him. Is that reasonable? It is not. And I'm trying to think of a way to say this nicely, but I would submit to you that everything that Dr. Quintal said about Doug Benefield was basically Dr. Quintal talking with Ashley Benefield's voice. She's a manipulator. She manipulated him the same way she tried to manipulate everyone else in the world. He said he met with them 9 times, and Ashley Benefield was present for 7 of them, and alone for 5 of them. So every bit of information he got, except for 2 sessions, comes through the voice of Ashley Benefield, the way she wants him to think things are. Right? He's very controlling. He's very alpha male, which is apparently a bad thing now. He's super controlling. He's jealous. Keeping in mind, she's the one that asked Doug Benefield, are you dating her now? When he's there with her lawyer. But Doug Benefield's the one that's super jealous. And what did he tell you? Other than he thought all those things he conceded that they were all based on what Ashley told him. Not based on anything he observed. He conceded that, which I appreciate. But the weird thing was that he had this weird encounter where he thought that Doug didn't want to see the child. And what did he say? I saw him for a few minutes in my waiting room. I went into a session for an hour. And then I saw him for a few more minutes, and then we started their session. So what happened in that hour? Dr. Quintel doesn't know. For him to make any assumptions on what the relationship was between Doug Benefield and his child based on seeing him for those few minutes is not reasonable. There was no basis for that. And keep in mind, through all of that she's dictating when Doug can see that baby. We don't know if he knew she was out there. He's sitting in the lobby of a psychologist or a therapist's office. We don't know that he knew she was out here. There's so many assumptions that Dr. Quintel jumped to in order to say those things, and they're just not reasonable. Despite a court order, she's dictating when Doug sees that baby and how, and that you're supposed to believe that it was something weird about Doug that he didn't go out to the parking lot. He could have been in the parking lot for an hour for all Dr. Quintel knows. And you know, the one thing he did say that was interesting was Ashley said she was frustrated with the system, which sounds familiar. Time is running out. I'll take things into my own hands. I'll do anything I have to do. She's frustrated because she's trying and trying and trying to do these things based on things that are not happening or not true, and it's not going her way. She tried to terminate his parental rights. The judge said, he can see that baby. That 6-month-old that he's never seen. So what does she do? Well, I don't really want him to do that, so I'm going to dictate how he sees the baby. Now I'm going to be sweet again. Now I'm going to go back. I think the only person that was in a cycle was Ashley Benefield. I'm not going to talk to you for months, but when somebody says you can have my baby, now I'm your best friend again. That's not Doug Benefield. He acted the same way in those text messages as she told you he did for 3 years. No violence, no threats, no manipulation, no emotional abuse. And that brings me to Dr. Ferris. Mr. Ferris. Mr. Ferris has never seen a relationship he wouldn't say is a domestic violence relationship. He would not concede anything. On direct, Mr. Taylor was giving him hypotheticals that had 6 or 8 aspects to them. And he was able to just answer. Oh yeah, sure, that's domestic. Goes right on the wheel. I'm asking him simple questions, and everything he would not concede. The only one he conceded about was that if she was living on her own, he couldn't have been economically controlling her. But how do you not concede that one, right? That's common sense. Every other thing he refused to concede. And this is one thing I will agree with Mr. Taylor. We have different perceptions because I think Dr. Ferris was clearly biased based on his inability to answer my questions when he clearly could answer the defense questions. It's clear from what was happening in this relationship that Ashley Benefield was not a victim of domestic violence. Doug Benefield's the victim in this case, not Ashley Benefield. And that there was not this power and control wheel that Doug Benefield was on. And keep in mind, Mr. Ferris would have you believe that somebody could be violent and then never be not violent again. That's what he said. I said, are you telling me that once there's violence in someone, it can never be changed? Well, if that's true, why does he teach CBIP? He makes his money on CBIP, right? Certified Battery Intervention Program. If what he told me was true, he's wasting people's time because he doesn't believe anybody can get better. And we all know that's not true. People change. People learn. People realize what they've done. People apologize for what they've done. And while saying the words is not enough, 3 years of not being in any way violent or threatening or abusive, that's an indication that Mr. Benefield was trying to change. He was trying to do anything he could to be with his wife and to be with his baby. Mr. Taylor kept saying, the defense kept saying trauma. She was so traumatized by this gunshot in the ceiling. So she had a baby with him? She testified to you that that happened before they reversed, or around the same time they reversed his vasectomy. That's a big deal. That's a decision. That's not it. I think Mr. Taylor said, you found yourself pregnant. She didn't find herself pregnant. She planned to have a baby. They planned it together. They went through medical procedures to do it, and they did it. All the while, she's so traumatized. I would submit to you that is not the case. She wanted a baby, and she got one. But Doug was in the way. And as to that neighbor thing, it wasn't Mr. Sant. I don't know where that came from. There was no allegation it was ever Mr. Sant. It was some neighbor across the street, and Ms. O'Donnell told you exactly what was in evidence. Somebody across the street saw some man in her backyard wearing a baseball cap, and clearly that must be Doug Benefield looking in Ashley Benefield's windows. That's ridiculous. That's a jump you cannot make. That man could have been looking for his dog. We have no idea. There's certainly no evidence he was looking at anybody's windows, other than the defense counsel saying that. And even if he was, does not make it reasonable and necessary to shoot him. It is not a basis that would cause you to believe he's going to kill you. Going to kill you. Not a basis. I would submit to you he never was in that yard. He was never looking in the windows. But even if he was, a tracker, not a basis to believe he's going to kill you, if that even happened. The house. Buying the house. I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Ms. Benefield was lying to him, telling him they're going to move to Maryland and live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that mutual injunction was, I'm sure, Ms. Benefield was speaking to him when it was convenient for her, when she could get something out of it. It only goes with the rest of it. This letter we've heard about, that Ms. Benefield testified all these things, it's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Liu and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great. I loved it. I thought he was very interesting. I thought he shed a lot of light on how this murder occurred, right? And I would submit to you that you should believe him over Dr. Liu when it comes to trajectory. He's an expert, no doubt about it. That's what he does, all the time. Dr. Liu is a medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why would she do that? She did that because she's getting paid. She got paid to be here. That's why she's here. That's why she's saying those things. And most of them are probably very accurate. So Mr. Haig tells you there's 4 shots. We know that, right? We had 4 casings. We have 4 projectiles. One is in Mr. Benefield's chest or back. And I think there was some misunderstanding of what Ms. O'Donnell was trying to show you. What she's trying to show you is that if it was from the front, because say I'm lunging, it would go in my chest and out the back. That's not what happened. It went front to back because it hit in here and came out here. Well, that's front to back. That's not front to back like it goes in my chest and comes out my back. That's front to back because it didn't end up here, right? Or she didn't shoot him in the back, it ended up in the other side of his back. It goes across his body, destroying his lungs, destroying his spinal cord, damaging his ribs. And what did Dr. Liu say? He dropped. He dropped. I think that's important. So Mr. Haig said there's one bullet, right? We got 4. One is in his chest, so we know where that one is. One's in the living room wall that Mr. Haig said he believed was going down and struck the tile and then bounced up and hit the wall. He knows better than me. Seems reasonable. 3 is in the wall, number 7. Perfectly round. Typical gunshot. Nothing in its path, because what did he say? If something was in his path, it would begin to tumble. It wouldn't be that perfect hole that we picture as a gunshot in a wall or a target or anything else. And then through his leg. So which bullet hit his arm? And I think Dr. Liu might have been correct when she had that young man laying on the floor. It probably went through his leg when he was on the floor, because Ashley Benefield told you something. She said, she's shooting down. We know that's not true, right? Because his chest is way up here. His chest isn't down here. But she told you that once I had stopped shooting when he fell. That's also, I think, untrue. Dr. Liu told you he would have dropped. So he's paralyzed, laying on the ground, and she continues to shoot at him. Otherwise, if you believe that she's moving from left to right to get away from him, he's dancing around dodging bullets? I mean, they would have you believe this is a very tight room. I don't know how tight it is, but you can see there's either a full or a queen-size mattress in that room, and there's plenty of other room. This is not a broom closet. This is a full-size bedroom. And what else do we know? Dr. Vega said that they had to been at least 3 feet apart. 3 feet apart. Uncontroverted. Nobody said anything different. Except for our firearms guy, who talked very fast, but said he looked chemically at the shirt and found nothing. 6 to 7 feet. 6 to 7 feet. Even if we go 3 feet, you have to keep in mind, that's from the end of the gun. She is pointing a gun at him. Here to Mr. Benefield is at least 3 feet, if not 6 to 7, when she hits him in the chest. At least 3 feet when she hits him on the leg, because Dr. Vega said there was no stippling on the leg. They're not in close combat. We keep hearing about this. They are not in close combat. They're a whole grown-sized man apart, 6 feet, from the end of her gun to his body. And we know that. That's from the science. That was uncontroverted. You heard nothing to question that. You can take that one to the bank. And I would submit to you that those 2 experts, Mr. Haig was the one you should be depending on, even though he's also spoke to Ms. Benefield, so clearly got one side of the story, or a made-up story, and that Dr. Liu is not the expert that Mr. Haig is on trajectory. So if you go in the back and you're curious about the trajectory, I would say you should depend on Dr. Vega's testimony about how the bullets entered the body and exited, which Dr. Liu did not contest. And as for the other bullets, you should depend on Mr. Haig, because he was clearly more suited to answer those questions. As to Detective Warren, poor Detective Warren, who gets called just to be impeached, said he had opinions. You know whose opinions don't matter in this case? But Detective Warren's. Mine don't matter. Ms. O'Donnell's don't matter. Defense state attorneys don't matter. It's your opinions that matter. It's when you go in the back and you listen to the facts and evidence in this case, and you decide if we've proven our case. If Detective Warren, at the time in which he made his decisions, thought that he was shot in the back, that's not wholly unreasonable. He may have been mistaken. It doesn't make his opinion invalid, but what it does, it's not relevant to your decision making because you're depending on the facts, and you have the accurate facts.
You have 10 minutes.
Thank you, Judge. I appreciate that. And that whole bias business, Detective Warren explain what that is. That's sexual bias or racial bias. This wasn't a hate crime. This wasn't a crime because somebody hates somebody else because of their sexual orientation. That's not what this is. That's not a place to put ill will, hatred, spite, or evil intent. Ill will, hate, spite, or evil intent is not bias. It's an element of second-degree murder. It's a depraved heart. And that's what Ashley Benefield had when she murdered Doug Benefield. A few more things, and then I want to talk to you lastly about the reasonable doubt. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was a abusive, horrible man. They have defamed him up and down. No, she didn't say that. She didn't say, I was afraid that Doug would freak out on me. I was afraid he'd do this. No, she said, I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. She can't say in front of Doug, I'm not moving to Maryland, because then who's going to move her boxes, right? I can't say in front of Doug, I'm not moving to Maryland with you, because then maybe he won't drop his divorce case. Then maybe he'll try to take my baby, right? She can't let him know that. She can't let him know that until he's packed her up, ready to go. It's manipulation. And that's what she does. That's what she's done. The evidence has shown it to you. And it doesn't matter if it was the report or the injunction. She knew. The jig is up. He might seek more control. It probably just went in there. But Stephanie Murphy told you that when they went, that she was trying to get an injunction, and it was denied. And he was trying to get custody, visitation, see his baby for the first time. She said something I thought was very telling. The judge gave Doug sole medical control, or primary medical control over the baby. Right? So now he's already got some control. She can't do anything without him on the medical stuff, right? Of course she's worried. Of course, because she wants that baby, and she'll do whatever she can do to keep it. Her. And I wouldn't put anything in the fact that she didn't confess on her phone, that she didn't tell somebody that she had shot him one way or the other. She didn't even tell her mama. Her mother would have you believe that in all these years she's never said something to you. You think she's going to put it on her phone? No, she's smarter than that. If that's true, she's certainly not going to put it on her phone. And just because you search up how to co-parent with an abuser doesn't mean that person's an abuser. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina. It ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did. and she's trying to manipulate you. You can decide what you think about her testimony. She's a witness like any other. But I would submit to you that that was all manipulation. There were no tears. You use your common sense. If you cry and have to take breaks and you're racking, then you're going to have a swollen face. Your eyes are going to be puffy. You're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney told her, hey, there's tissues. Oh, yeah, I should have a tissue. She'd been crying for 15 minutes. Didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe that she was a victim. She is not the victim. Douglas Benefield was the victim in this case. And reasonable doubt, I would ask you to read your instructions, because that board they put up was an incomplete instruction. It left out parts. And the part is that proof beyond a reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt. And the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead. The death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the 2nd degree with a firearm. Thank you.
36 minutes on the button for round 2.
Thank you, Judge.
All right, can you go back to your instructions?
Poll's going to go up. How long will the jury deliberate?
Left off at 3.10. And we're going to ask, when you find that, if you just look up at me and I'll know we're all on the same page. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case at all. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that made you think that I preferred one verdict over another. You may find the defendant guilty as charged, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And of course, I explained it earlier. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the courtroom, in the jury room.
We've got a frozen face going on here. Not sure what's happening.
Juror goes to the restroom. The deliberations should see during deliberations. These communications rules must apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. Let me break the script to say also, these jury instructions haven't been updated in a while. And if you have a watch, a smartwatch that can communicate with the internet or make calls or send and receive texts separate and apart from your phone, that also needs to go in the Tupperware container that the deputy's holding up. All your electronic devices will be there, but you can't have anything in there that will communicate outside the jury room. If you need to communicate with me, send a note to the court deputy. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court.
Tupperware's a step up from
During
Solo
the trial,
Cups.
items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I'm going to stop there also. When you go back, I think there was a few electronic items or things to view on a computer or on a DVD player. There's going to be what we call the tech cart that will be in the jury room with you. There's instructions on top of that about how to work the different devices and everything. If you have any problems at all, send a note to the court deputy, and I'll make arrangements for our IT department to come down and get going whatever you need to get going. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Now, as you gather up your notes and your other items, as I said, you're able to take these jury instructions, your notes, back in the jury room. Before I let you do that, though, I do want to let you know, all of you know, that in almost every case, we select the jury as well as alternate jurors in case one of the main jurors is not able to fulfill their duties. Especially as we've come out of COVID, it is not uncommon. I'd say 20 to 30% of the cases, we have somebody get sick or something happens, and an alternate juror has to step in and serve on the main jury. Alternate jurors are incredibly important as it does happen every so often that for various reasons, jurors are not able to complete their service and an alternate must be seated on the jury. In this case, jurors 38, 42, and 43 have served as alternate jurors. As such, I am not able to allow you to retire to deliberate with the rest of the jury. Do the three of you have personal effects in the jury room? You have stuff in there. Here's how this is going to work. You're going to leave your notes here. I'm going to ask you to go back in the jury room with everybody. The deputy is going to take you back. I need you to gather up all your personal effects and then come back out here to the jury, to the courtroom, so I can give you your final instructions before we let you go. But I'll need you to come back out. The other remaining 6 of you, when you go back, let those 3 jurors or alternate jurors get their things. You may not begin your deliberations until the deputy steps out, has received your electronic devices, has stepped out, and that door has closed. Then you may begin your deliberations. All right, do we have the exhibits? You've got the exhibits. Deputy, can I give you the verdict form? All right, so all of you may step out at this point, and then I'll need the 3 alternates to come right back out, please. For the other 6, you may now retire to consider your verdict. All right, you all can sit down. State defense. Any objection to how the jury was charged other than the objections during the charge conferences?
None from the defense.
No.
All right, thank you. Yes, I have the
I unplugged my my timer, so I need to go plug that in so we can have a timer.
That's contact number feed that we need to call. Get questions.
Just grab whatever seat you want. I won't keep you much longer. We've got, Deputy, we have all the notes and... Yes, sir. Thank you. I want to just take a minute and thank you for your service. I was here for jury selection, and I know that some of you missed very important work engagements that you expressed meant a lot. Some of you missed doctor's appointments. And all of you missed personal time at work, with your friends, with your family, in sacrifice of your civic duty as serving as jurors. Contrary to what a lot of people think, I find this to be possibly the most stressful part of my job, because I now sit and look at all 3 of you who have given us a week and a half of your time so willingly and so graciously, and to say, I'm sorry, I can't let you deliberate. Now, sometimes I do this, and you see the smiles come on people's faces. because they're glad they don't have to be part of the deliberations. And I have received some angry calls afterwards about being an alternate and the person wanted to go back and deliberate. However you feel, relieved or upset, I just want to say thank you for doing your civic duty, for answering the call, for being here, just being so generous with your time. I've watched the entire jury the last 7 or 8 work days, and you have been incredibly attentive, paying attention. There's been a lot of people in and out of this courtroom. You have not been distracted one bit. You are exactly what we want in our jurors. And I thank you. On behalf of myself, the other judges of the 12th Circuit, thank you so much for giving us your time. I have some certificates of appreciation that I'm going to give you to commemorate serving as a juror. Also attached to each of those is the paper for work, if you need it to show where you've been for that. If for some reason that paper is not sufficient for your needs, please reach out to my judicial assistant. My card had her direct number, and if they need a letter from me or whatever they need, we'll get it to them to show that you've been here this entire time serving as a juror. I am now going to read you your final jury instruction. I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. The law gives you a unique privilege not to speak with anyone about the jury's work. Although you are at liberty to speak with anyone about your jury service, you are also at liberty to refuse to speak with anyone. It will be up to you to decide whether to preserve your privacy as a juror or not. With that said, again, I offer my heartfelt thanks on behalf of myself and the other judges of the 12th Circuit, all of the court administration, and for all the citizens of the 12th Circuit for being part of this process. I now discharge you as jurors in this case and release you from any further obligations in this matter. If any of you would like to be escorted to your vehicles, all you have to do is let this deputy know, and he will make sure that you are walked all the way to your vehicle until you leave. Thank you again very much.
Thank you, Judge.
We're going to end the poll for deliberation time right now. Looks like the results came back as... Let's see here.
All right, you all can have a seat.
We're tied on 2 to 4 hours and 4 to 8 hours.
What's the 12th Circuit's position about approaching alternate jurors to see if they will speak?
I'm not aware of an official position on our website.
I just want to make sure. Does the court have any?
Oh, you mean like interviewing them or just walking up to them?
Just approaching them and asking if they would be willing to speak.
My timer is more accurate.
I would appreciate having a hearing on that.
Okay.
All right, anything else before we go?
We've got the JOA.
Oh, yes.
Okay, so on behalf of Ms. Benefield, we renew all previously made motions and objections, specifically our JOA. And now for the final, I would state that the state has failed to meet its burden of disproving self-defense beyond a reasonable doubt, and that the uncontroverted evidence clearly demonstrates that Ms. Benefield acted in justifiable self-defense. More specifically, she testified that Mr. Benefield physically intimidated her, prevented her from leaving the residence, struck her on the head, pursued her to her bedroom, and advanced on her in a threatening manner despite her warnings to stop.
Thunderstorm, thunderstorm, thunderstorm. That's down in Florida. See, my timer continues. Okay, we might have some feed issues. Let's see if we can grab another one here.
She reasonably believed in DCA 1986, quote, The state has the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. The state's evidence was legally insufficient to prove guilt beyond a reasonable doubt because the state failed to rebut the defendant's direct testimony that he acted in self-defense, and in fact, some of the state's evidence corroborated defendant's testimony of self-defense. Thank you.
Steve.
Judge, I would just say that the state has met its burden, that a reasonable jury could find beyond a reasonable doubt that this charge has been proven. Would ask you to deny JOA.
Any rebuttal?
No, sir.
All right, I'm going to reserve at this point.
What?
All right, if there's no other business, then we are going to
chicken.
Be in recess until we have a question or a verdict. I would ask if you could please leave a cell number with the clerk so she has, so we can get a hold of you. Please don't be more than 10 minutes away so you can get back here pretty quick if we have any questions or issues.
What time do you think you'll let it go till good?
Go for the evening?
Yeah.
I tend to let them go until they ask to leave. The issue that's in the back of my mind right now is to see if they ask for dinner. Do we have a cutoff for that? To order? Like 7 p.m. 7? So, I mean, usually if they're hungry, we'll hear from them between 5 and 6. That's my experience. But if we don't hear from them, maybe by 5:30, I might have the deputies just kind of knock and say, "You guys okay? Do you want a menu?" And just that'll be it.
Okay.
That way I don't have to
You guys okay in there?
to deal with that.
Yes, thank you.
Anybody in there?
The other thing I will not call you back for is if they ask for IT help. I don't reconvene for that.
Thank you.
Okay.
Thank you, Judge.
Okay, so we are in verdict watch. Those were closing statements as everyone files out. There's Eva right there. This has been fairly difficult for her. She's shared a little bit on social media, and this is a difficult process, as you can imagine. She also was going through a lot of stuff with her personal company and things like that. So tough time. As they leave now, we'll wait until we hear word. What was IT help? If they need help with like the technical stuff, if the computer isn't working or something like that. Let's see. They might go past 5 p.m. See, I just rewatched the juror interviews from day 3. The alternates are Ted and 2 of the women. So we have, thank you, Tyrone. First of all, thanks for doing that. That tells us that we have one man and 5 women deliberating on the jury, because we know the makeup of the jury from thanks for the Jules. So almost all women on the jury. I will say this: it sounded like the approach to the closing arguments from the prosecution. They yelled a lot. Okay, and that might just be a style thing, but there is there's that little saying that comes to mind. It says if you have the facts, if the facts are on your side, argue the facts. If the facts aren't on your side, argue the law. If the law's not on your side, pound the table and yell like, yeah. They did a lot of yelling, and that was interesting. That was very telling. Both of them did yelling. There wasn't usually you'll have 2 different approaches, but it could be perceived as a lack of confidence, Rocky, in their case. It sadly, and I didn't like this at all, but sadly it looked personal for both sides. You've got Mr. Taylor up there. He's got limited time. This is his last time to address the jury. And he's getting personal about, yes, I did impeach that person. And it's like, seriously? You want to open up with the fact that another lawyer, a lawyer for the defendant, had a different interpretation of an email they had sent about a scheduling event. That's your open? That's where you're going to go. I mean, this is what I want to prove. First and foremost, let's get this out of the way. I think that was a big mistake. It missed for me. It just missed. I think he ended much better. But yeah, it did seem personal. And even so, even on the prosecution side, it seemed personal. The attacks almost against the other lawyers were, and I realize it's hard to go into a case like this where you have completely different opinions. Like one side believes that Ashley Benefield should be locked up for at least 25 years, and the other side believes that she should be free. And you're trying to argue this. They have very diametrically opposed opinions. Tough for the jury, man. Tough for the jury, because if they side with Ashley Benefield, sorry, I just saw this message. It's IT help is what he said. If they need IT, like information technology help. If they side with Ashley Benefield and say not guilty, if they believe her, and that's what it's going to boil down to, is if they believe her testimony, because if they do, this is over right there. I don't think if they side with her, they actually have to sort of look at the family and say, Doug's family, Doug's daughter, Doug's cousin, other family members that are here, we believe Doug was an abuser. And so they're sort of ruling two things. They're ruling that the shooting was justified because of a bad thing Doug did at the same time. And that's a tough call to make. Let's see. What is defense doing now? Nothing now. They're waiting. We are in verdict watch. We have the courtroom wall to look at, and that is it. So we are, as far as deliberation time goes, we're 14 minutes and 59 seconds. Let's see, let's try 3 is 4. There we go. There we go. Counter isn't on the screen. I put it on, sorry. I just realized it was off. You missed my pun. It was a rargument. Rargument. I thought it was a typo, not a pun. I see it now, Crusoe. How's long until a jury question? We did a verdict poll yesterday, Dr. Dew. We came back at 66% said not guilty, with 32% saying guilty, and YouTube, as always, stole 1% of the vote. I'm not sure if we can do a panel on this one. Honestly, here's the reason, and I blame me for this, for not wanting to do a panel on this. And I say this because there are a lot of people who have experience in this, like personal, firsthand experience, which is valid, which is real. And their experiences are different than other people's, and maybe different than Ashley's, and so I don't want people to I don't want people to call in and share things that are very, very personal, that they only share with people that are very close, and have people discount that. I don't want your experience with abuse, or with someone that experienced abuse to become the target of an argument because someone else experienced it differently, and their experience is just as valid. I don't know how to deal with that, and I've told you over and over, I'm not the one to be on the jury on this. This is a tough call. I don't know how you make this call, whether or not you believe Ashley Benefield. I don't know how you can do that, how I can do that. I feel I can make a call based on the law, based on the fact that the evidence that she put forward was not disputed, she was not impeached, and we get a spam call. Hang on one second. Hello? 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 Please call me back. I can't hear them. It was a spam call. This would be a tough one to be a juror on, but looking at the law, she presented evidence, and they say, what evidence do we have other than her words? That is evidence. All the jury has to consider is the words that were admitted, and the physical evidence that was admitted. The gun, the bullets, or actually, I don't think the bullets were. The DNA was not admitted. We don't have DNA evidence here. Hang on 1 second.
Call from Angela.
Hello, Angela. How are you doing this afternoon?
Hi, I'm doing good. How are you?
Doing well.
Well, I wanted to continue on what I called yesterday regarding the actress. And I promise I'm not going to talk anything, about Ashley and whether she is acting or not, talking from a perspective that is, I have the same background, more or less. Mm-hmm. I mean, the same field background. Yeah. We are performance artists, but you guys have to know that we do not take the classes that actors do. None of us do. We do have, at least I had a class that I had to learn how to not, how to behave on the scene. On a stage. Mm-hmm. Let's put it that way. But how to behave, not how to act, and I'm talking from my perspective. I also talked to a few of my friends that are dancers, and none of them said, none of us have ever learned how to act. We know how to put on a show, but that's a ballerina show or a musical show or something that we learned for the last X amount of weeks, then and perform for a few months or however long, and then we move on.
Right.
So I don't think she's acting. Do I believe her? Yeah. But so that's what I wanted to say.
For me, she seemed different when the jury was there. She had a pose, and I'll say it's a pose, but there was the head down, and not any rapid movements, and even, I mean, I don't know if you could probably count on your fingers how many times she made eye contact with the jury area during the entire trial when they were there. It was very much
Don, I have to answer a question from chat. Donnie, no, I'm not from Ukraine, but I'm from Serbia, so hence the accent. But yeah, I do think, I do know, I noticed that, but we talked how on previous trials, how certain defendants have no either poker face or are acting very weird or have certain facial expressions. Yes, I'm talking about Karen Reed, among others. I think that she just, she had to be professional around the jury, not show as much as she can, not show her expressions, Yeah. And then when jury's not there, then she can let out whatever anger or whatever she felt while they were there.
That's very much a possibility. It could be also that she was given instructions saying, hey, just sit there. Don't look at anybody. Just hold still during trial. That's it. We know she was given instructions from her lawyer, right? Day one, okay? Don't talk about it to anyone. And she didn't. So she's very good at following instructions, at least in that area.
Yeah. I have another case that I talked about a few times here that maybe people know about, Scamanda. And there's a podcast about it, which doesn't matter. But there on that podcast, the mother, one of the victims, was there, and she talked about how her lawyer told her to not. It was a messy divorce, and her lawyer instructed to not show any emotions. Unfortunately, she could not hold her emotions, and unfortunately she lost. So I do think she was instructed to not show anything and be as. I would say that she probably used whatever classes. I mean, since I took the class, I guess she took it also. I guess how to act, as in how to not show what she really feels at that moment.
Yeah, to steal yourself, basically, and just poker face. I don't have one. I don't have a poker face. I lose all the time when I play cards because I'm like, hey, aces. But I
have no poker face. I am the worst liar in the world. Seriously.
We need to play cards sometime. Maybe I can win.
Yeah, not only that, but I will also be the worst criminal because I will probably go to police myself before they even start looking for me.
The guilt is just eating me up. It was me. I did it. That's awesome.
That will be me.
Love your call as always. Anything else you wanted to say?
No, that was. And I actually wanted one more thing to say regarding her testimony. What I liked is she tried as much as it was emotional. She tried to make eye contact with people, not just with her lawyer. Yeah. I went back and I slowed it down and looked at her, how she looked at people. And that's why I think she also was truthful. Because you either stare at one point, if she was acting at all, she would probably stare at one point and just tell out whatever she needed to tell out, But she did not do it. She made eye contact.
Her mannerisms during testimony was very trust. If it had a trustworthy feel to it. The way she answered, the way she was immediate with an answer. There wasn't like there was none of this reservation before answering. If she didn't know, she said, "I didn't know. I don't know." She was consistent throughout. Like when the defense asked her a question first and then prosecution asked her about it, she was consistent with her answers, even under pressure and sort of peppering with sort of different questions from different angles. She was everything we want in a witness that's truthful. And there was no testimony of any substance whatsoever that called her testimony into question. They didn't discredit her on anything. She was not impeached on anything. How do you not believe her? How do you not say, at least give that, there's reasonable doubt?
There is one more thing that speaking of that evidence, one more thing I promise that I'm going to stop talking.
One more thing. You're like Apple. Their big their conference. There's one more thing. What was that?
Speaking of evidence, you said something about how there is no way to prove which bullet was first to hit him. That's right, but you can recreate based which she did actually.
The
based
scenario
on
scenario
and most likely scenario. So she probably ran through a few scenarios. What are the most likely scenarios to happen, and what are most likely bullets to have hit him first?
Yeah, Dr. Lou did a good job on that. The whole lunging right hand, left hand. If you've got your right hand back, the reason why you hold it back when you're right-handed is because that's when you lead with, that's your strong arm. That's your big punch. That's your default, and you're getting ready. You're loading up that arm to make an attack. So if he lunges, yes, his right hand would go forward. He would turn that way with a lunge if he was lunging for something. That side of his body would be forward. The state made the defense's case, I think, for me, even when they demonstrated. They're like, yeah, he was right-handed, so his right hand would be back. You guys try this back there. Yeah, but when you lunge, it goes forward. And she did it herself. Yeah. It was like, oh, man. But but the way Dr. Lou spelled out the injuries with the lunge, if he was shot, if the first shot missed, okay, let's assume the first shot missed. It could have been any of them. It could have been the last shot that missed. We don't know. But one of the shots missed. So we'll say the first shot's missed. We take that out of the picture. The first one that struck him would have been the arm. Our testimony, according to Ashley, was that he kept coming. That didn't stop him. That bullet was not the one that stopped him. The next bullet that she fired, and she's firing rapidly. We know that because of the injury to the back of the leg, and it wasn't in the ground. She didn't like shoot him on the ground, or there would have been damage to the tile and everything underneath. But she shot, and that's when he falls over, and his legs get kicked up. I don't know if he had made a motion to as she's shooting that sort of assisted that and caused him to rotate the way he did, because that seems like a little bit much for me. I said before, that's not what happens. People don't just get blown off their feet unless they get shot with a cannon. In a way, this is a cannon. This is a 45. It's a very, very big gun, point blank, 6-foot range. It's got 1,000 foot-pounds of muzzle. I forget. It's at the muzzle. There's a lot of energy released by this round. Leg goes up. She fires again. It makes sense. The pieces fit together. It might not be how it happened, but it makes sense, and it's reasonable to say this is what happened. And there's nothing to say that's not how it happened. That for me is reasonable doubt.
Yeah. Oh, I said it in chat the other when Dr. Lou, Dr. Lou was it?
Dr. Lou.
Yeah. Well, we need a doctor like her to explain the Karen Reed's case seriously. Probably then the jury will acquit her. But that's a whole other story.
I was nervous when she was talking because I thought she was a little out of her depth at what she was testifying about. That was my gut feel, and I don't know what was she certified under. Let me just look. She was a Dr. Lou. She's a medical examiner. And she's testifying about the order the shots had fired. It seems like, medical examiners, especially her, she had seen a lot of autopsies. But then recreating the crime scene, that was like, that's sort of outside of your lane a little bit. But they did allow it, and it came in.
Not necessarily, because there was, as a medical examiner, you can take courses that can give you you can do such thing as recreate and what are the most likely scenarios to happen in order for this person to die this way. So that's why the prosecution didn't object to her telling that, because they knew her whole CV and what courses she took.
Yeah, that's how they got it in. They had to get her authenticated that way. But thank you very much. Appreciate the call. Thank you as always. It's wonderful talking to you, Angela. We'll see you. Bye.
See you. Bye-bye.
Oatmeal, by the way, thank you for your...
Chicken.
Biggin? Is it Biggin? Who's on the phone? I couldn't... I was talking.
Chicken.
Chicken?
Yeah, that's it.
Chicken, how are you doing?
Very good. I just wanted to call in because my husband introduced me to you. He has a similar backstory to you.
Oh, no.
And I have to say that
poor guy.
This is, I know, but he's come right out of it. And I really enjoy your whole channel. Your coverage is amazing. Your chat is very diverse, but very accepting.
They're amazing.
And I just wanted to give everybody a huge shout out for being awesome RA. And RA chat people and the mods and everybody, and thank you so much for your content.
Oh, thanks for all the kind words. I would agree with you wholeheartedly that this community is absolutely incredible. The ability that we have to talk about really difficult things that matter, and that we have strong opinions on and feelings about, and still be friends even if we don't necessarily agree with anybody. I mean, this is incredible, and I love that.
Exactly, yeah. I enjoy tuning in every time I can. I'm always here whenever I can. And I just want to thank you so much, and I don't want to get emotional, so I'm going to go.
Well, I'm going to get emotional. If you get emotional, we'll all be crying. No, I'm good. I'm good. I got all my tears out yesterday. Amazing community. Thank you so much. And you said your name was Chicken.
It's Chicken Shite if you're looking for me.
Okay. Now I know why you shortened it. Chicken. Now I know who you are, Chicken. Okay, thank you very much. I appreciate that.
Thank you. Okay, bye.
Bye. That's funny. Oatmeal, thank you for the super chat here. Asking what happens next. What do you cover next? This is my first trial with the channel. I enjoyed it so much. Oatmeal, thank you very much. Tomorrow is Mr. Lou's sentencing. That's a big thing that happens tomorrow. That is, he's the Apple River, the Bad Apple River I think it's the Bad Apple River trial. I think I forget what our name was for it, but it was the people who floated down the river and there was a fight. It was that one. He's getting sentenced tomorrow. He was found guilty, but the sentence comes in tomorrow, so we're going to be watching that. We have next week. We have a hearing in Utah for Corey Richens, which I will be present for. I'll be there at the courthouse. So we'll be running a live view from the courtroom, probably streaming it to Topmark Media, and then if possible, I might be depending on the setup. I've got to see what the court allows us to do, but I might be in the media room live with just my laptop camera running StreamYard and all that. So we'll see how this works. I might have to be elsewhere. I might not be able to commentate live during it. It depends what the rules are in the court. I'll have to check those again. But we do have some fun court cases coming up, so stick around. Texco 18, welcome to the gallery. Genius Landscaping. Ooh, I need to talk to you. I need help with my lawn. I had mixed feelings about that trial, too. That was also a mixed feeling trial. I think we had similar poll numbers in that one. Angela says, I had a crash course in pew-pewing today. I mostly watched pew-pewing on Olympics. I also found interesting. Olympics are in full swing. There's great stuff going on. Athletes at the top of their game. Love that. Thank you, Bite Me. Give Buttercup a pat for us and maybe a little treat. That would be great. Sarah Boone have a hearing on August 5th. Okay, I'm on Sarah Boone's website right now. I was doing this while Angela was on the phone. Sorry, Angela. I was listening as well. But there is a new document that is trying to be uploaded right now that's 29 pages long that says correspondence received from judge. And then there's a 20-page one. Oh, it's working now. It's coming in. We have motions. Okay, so we've got 29 pages of motions from Sarah Boone. Holy cow. Handwritten, every single one. 23, 24, 25, 26, 27. She's numbered every single page. 29 pages of motions. And then we have another correspondence from the judge, which is not yet finished uploading. I think it just barely was scanned in just moments ago. The response to these motions is already in, I believe, with the order setting the hearing to address these. Okay, so let's take a look at Sarah Boone's. Let's take a look at Sarah Boone really quickly while we're waiting. Is that all right? Any objections to while we're in verdict watch? We have audio turned on from the court, so if something were to happen, we'd hear it immediately. And as always, if you see something, give me a buzz on the burner phone. Been following since Cavalcante. You finally got me. Keep up the good work. We got you. Yes, mission accomplished. Texco, thank you very much. Cavalcante was a crazy time. Absolutely crazy. We're gonna go over these with Sarah Boone right now. Well, Thal's on the phone, about to get himself timed out, I think.
Call from.
Let's see. Thal, my friend, how's it going?
Hey, how's it going? I was counting things. Sorry. That was all you almost caught me in the middle of going, man, okay, so if I just click on this, I can actually count everything. That's excellent. Yeah, anyway, that has nothing to do with what I called about. The thing is that both things can be true at the same time, okay? So her crying on the stand, it's not necessarily that I didn't believe it. Mm-hmm. It's just the fact that you can cry on the stand and regret what you had to do, okay? Right. So my thing for manslaughter, my argument for manslaughter for this lady isn't that she was, sitting there cackling and, twirling her mustache or whatever, right? It's not that. It's that she really believed this was necessary, and she really did attempt to plan it out. And after the fact, she's weeping on the stand. I believe those are real tears. I don't believe they're fake. But I think she did what she convinced herself she did what she had to do. And yeah, she still cries about it because, I think this is one of those things that this is going to be one of those really depressing verdicts. You know what I mean? That no matter which way you go, it's going to be a sad story nonetheless.
No matter how you look at this, there's a victim. There's a victim involved, and you've got to feel bad for the victim anytime, because generally the victim is a victim because they somebody else made a bad decision that affected them. So yeah, it's going to be sad regardless. If she's convicted, obviously she's going to be sad. Her family's going to be sad. If she's declared, if they say not guilty or hung jury, then the family feels they haven't got justice for Doug, and
right. But
there's the child involved as well. So,
well, I can still feel bad for her at the same time of convicting her of manslaughter and holding her accountable.
Yeah, that's
all I'm saying. I can still be like, oh, that's too bad, but you're guilty. Have a nice day. Go to prison. So. It doesn't affect me, but I'm cold and dead inside. So it's
you have no soul. That's what it is.
Hey, just because I feast on other souls to replace the one I sold doesn't mean.
Yeah. I think there might be something there. I agree. Both can be there. I'm still up in the air about her. I mean, there were parts of this that I thought that just doesn't sit right with me, with what she's doing, what I'm observing. Clearly, there's prior case history with other hearings where the conclusion was reached that everything she said is not accurate, or at least there's no evidence to support the things that she said. But that being the case, there are things also that were accurate and did check out, that Doug did admit to in a letter to court, in court, and say, yes, these things did happen. I did those things, but I apologized. That's fine. The fact that they happened was the issue. That means that it puts the realm of possibility there that the other things could also happen for me. But 3 years prior, nothing happened for 3 years because they were separate. That's why nothing happened for 3 years. Maybe she wanted to be away from him because of the things that happened prior, and she was managed successfully for 3 years to do it until the court orders, co-parenting. Then she's like, we've got to make this work as best as possible. I don't know, and I can't judge her for saying, okay, then I'm going to be there. I want to be with him. I want to be with my kid. I don't know what went through her head and why she felt she wanted to be there. It could have been to protect the kid. It could have been, I want to supervise and make sure nothing's gone wrong. It could be that she didn't trust him. She thought, I'd rather be there than not be there. I don't know. And I can't assign, I don't know why she got pregnant after they had a huge fight. I don't know why. Well, I know why, the hows of that are pretty clear, but I don't know why they would move forward with the relationship if it was that bad. But I also...
I can actually answer that one for you.
Well, people, especially in abusive relationships, there are times when the victim thinks, well, first they blame themselves sometimes, and other times they think, it's going to change. That was a one-off. I refuse to accept this is my reality, and we'll give him another shot, or... Yeah, I don't know.
No, this is very common outside of DV cases. Ask any guy in the chat, and there's probably a few women that admit it too. This might have been their experience also, is that women will have a child with someone in order to fix the relationship if it's falling apart. DV need not be a part of it.
I'm going to take issue with that and say not women will. Having a child takes two. That's not a woman having a child to fix it. That's the couple.
Okay, so both parts. Yeah,
there's a dual effort there involved.
My point is, outside of that, okay, is that this happens in some relationships and not others, but DV doesn't really have anything to do with that part. So what I'm trying to parse out here is what's in a normal relationship, what's part of DV, because DV is a part of this relationship, but at the same time, we have to consider those things outside of it that are normal also. We can't just heap everything on the DV pile.
Yeah.
And I don't want to do that.
Let me say.
But real quick, this is my last point.
I'm fighting with all for my channel. Oh, sorry. Go keep going. It's your dime, Paul.
Win ultimately.
Yeah, I've got the button.
He's got Calypso on his side.
I'll argue this.
I'm a dead man after I get off the phone. But no, sorry about that. But yeah, but the deliberations for this one, regardless of who's on the jury, men, women, I don't care if there's pink buffaloes on it. This is going to be a hard one to entangle. And I think the deliberations are probably going to go on for weeks. I wouldn't be surprised if that happens. I would not be surprised. Yeah. I've already made up my mind, but I'm not on the jury. So
yeah. Okay. Thank you very much, Thal. I think it's going to be quicker than that. We'll see who's right.
All right, brother.
All right. Good talking to you, my friend. We'll see you.
You too.
Bye. Two things, Genjo. From the other side, there are some things that are very problematic that really look bad on Ashley. And I think the biggest one is I'm going to take the matters into my own hands. Why would you say that? That is as close as you can get to a threat and not be arrested as you can possibly get. I realize they have an explanation for that, but it just sounds bad, and the timing of it, terrible, absolutely terrible. There is an argument to be said that she was also manipulating him, or that she was manipulating him entirely. The behavior that in his presence, she was in a way leading him along, or it seems to be encouraging him in a direction that she was not doing in private when he was not there. There's some issues there. I can't judge. I can't be the one in the middle. I'm trying to look at it from a legal perspective, but I'm doing terribly at this and failing miserably, probably on both sides. There's one more comment here from Q. Says, if there's no DV, then there's no DV there, period. I would argue that firing a gun in an argument with someone is domestic violence, regardless of if it struck them or not. Change my mind. At that point, I can tell you that if a police officer was involved in that, they would have shot and killed Doug at the time. That's what they would have done in that moment. I don't think that you can look at that and say, oh, that doesn't count because she wasn't injured, or there's no bruises, or that he never struck her with anything. He threw a gun at her, allegedly. Again, we have testimony that seems to be corroborated by Doug's admissions of what happened. That happened. I would say that is domestic violence. It happened before, and that's why she was separated from him from 3 years. After 3 years, nothing happened because they weren't together. They get back together, and guess what? More things happened. That's where Anyway, I'm stuck. I realize I've made up my mind a little bit on this one. I'll listen to arguments the other ways, but let me do this. Let me read the Sarah Boone letter. Is that all right? I've teased you with it. It's a long letter. I'm not sure if we can read through all of it. Domestic violence is not a reason for murder. If she had reason to fear for her safety and for her well-being, for life, if she thought she was going to have serious bodily injury done, not only is it reason, it's justified. It's legal. It's like the law specifically says it's authorized to do that. Police would not kill him for bumping with a box or taking a ninja stance. No, but coming forward to attack her and saying this is over, saying, now you're done for, and coming in a fighting stance, he's attacking. How many times have police shot people as they're coming forward before they make contact with the officer, and say he was reaching for something, or he was lunging, or he was trying to get at my gun or something, and they'll shoot him. I would say that can be argued all the time. And those police officers lose their jobs. I'd say case by case. There are definitely police officers who use force that they should not. It goes back to 3.4F in Florida, or 3.6F. Just 1 second. Justifiable use for deadly force. Let me just pull this up. This is Florida law, and that's what applies in this case. So let me pull up their law. Their law says this: it is a defense to the crime, meaning that it's an exception. So you would not be found guilty of the crime if of using deadly force. If, let's see, we have imminent death or great bodily harm. So if they feel he's going to kill me or he's going to do serious damage to me, that's one. Imminent commission of a forcible felony, and there's a list of those, and those lists are if she thought any of those were going to happen, then she could legally in Florida shoot him. let's see, she had no duty to retreat before using or threatening to use deadly force. She was in a place where she had the right to be. No duty to retreat. Trying to find a list of all the crimes. The use of deadly force is justifiable if Ashley reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder or commit any applicable felony upon her, commit applicable felony upon or in any dwelling or house in which she was present. You're not justified in using deadly force or using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who's engaged in execution of a legal duty if the enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. You have to consider the circumstances at the time the force was used. The danger need not have been actual, but it has to be so real that the defendant actually believed that deadly force was necessary. And it meets that reasonable, cautious, and prudent person standard as well. All right. Colleen testified that she tried to walk out the door and she was restrained and told that she was not going to be leaving. He was not going to allow her to leave. That was the unlawful restraint, charge, or that's why we got that charge read to us as far as what the definition was. So she did not only try to leave, but she also retreated, two of which things she did not have to do under Florida law at all. I think it helps to look at emotional abuse with the lens of being severely bullied. When reduced to nothing, your state of mind is altered. We're going to move on to Sarah Boone motions. We are. I've teased you about it like over and over, but now we're going to go there. Okay, I'll stop talking. I'm on 4 motions are loaded. The judge is printing everything right now. Okay, so we have a ton of reading. Good grief. All right. You can see the deliberation timer. The screen's a little bit small, but we can get through that. Go camera 3. Circuit Court, 9th Judicial Circuit in Orange County, Florida, State of Florida versus Sarah Boone. This is received from the judge. Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of a criminal case for trial. Comes now Sarah Boone, pro se indigent defendant, respectively requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney and in her proposed lawful representation of herself in her criminal case. Defendant's justifiable reasons for requested relief and assistance are as follows. 1. The defendant's 6th and constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. By the defendant's lawful practice of her entitled first constitutional right to free speech and her God-given right to do so by writing her experience-derived truth and providing red flag exposure in her correspondence to the court requesting needed intervention to avoid present circumstances, she has lost completely her ability to take an advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted, while having the ability to be leveled equally with the prosecution. The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal... Sarah Boone did not write this. I mean, this is her handwriting, but Sarah Boone did not write this. My kids are playing tag in the street, not in the street, in the hallway here. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in the field of law presently and historically. The defendant is defective and ineffective counsel as to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. That sounds like a word she would write. By the courts rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include: A, the defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24, with only 4 days to submit my demand and motions delegated by the court on or before 7/22/24. B, the defendant has not reviewed from the court to date as of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24, another asterisk, with only 4 days to submit my demands and motions delegated by the court on or before 7/22/2024. C, the defendant does not have access to a computer. D, the defendant does not have access to the internet. E, the defendant has extremely limited, irregular access to basic tablets supplied by the Orange County Correctional Department. F, the defendant has access to payphones for collect calls only limited to 15 minutes each call. G, defendant does not have access to organizational supplies or production equipment, copier, printer, etc. H, defendant does not have access to meeting place for privacy and case review or preparation. I, additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated, and once my case materials are finally received. Continued continued application and reasoning and further law support of defendant's request for immediate relief with standby counsel to aid and assist in preparation of her criminal case. Where are we on? What letter was that? J? It says A right here. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance and counsel for his defense. Amendment 6, United States Constitution. Right to counsel is assured by the 6th Amendment, which has been incorporated into the Due Process Clause of the 14th Amendments, as well as the state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Right to counsel applies whether the defendant can afford to hire a lawyer or not, in which case the court will appoint without charge to defendant. Right to counsel, Bolivar Law Dictionary, 2012. Waiver, what just went beep beep? I don't know what that was. Waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. It is made by a person with full capacity, unprepared, that is knowing, it's a loud truck, that is knowing and voluntarily forced, and that clearly and unequivocally rejects representation or assistance by an attorney at law during the pending proceedings. Waiver of counsel, Bolivar Law Dictionary, 2012. We've got lots of definitions in here. A defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. That's Maynard versus Boone. It's funny that it's Boone in the case law, as she gives a citation from 2006. The right to waive counsel, forced by the court, is the right knowingly to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record, taken in its entirety, shows that the defendant comprehends that a waiver of counsel means that they will proceed into the labyrinth of the law without the assistance of a trained guide. The court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused waiver of counsel, which she never gave. Competence means more than a minimum of mental awareness and capability. However, it involves an intelligent conception of the consequences of its act. No one explained this to me. That's the People versus Holcomb with case law from 1973. The trial was a farce or a mockery of justice, or was shocking to the conscience of the reviewing court, or the purported representation was only perfunctory, in bad faith, a sham, a pretense, and without adequate opportunity for conference and preparation. That's People versus de Graffenried from 1969. Part D, ineffective counsel is both a standard of inadequate performance for a lawyer in a criminal representation and a failure of due process of law to criminal defendant. A person who has suffered a punishment in a criminal proceeding I was repeatedly lied about by former attorneys to the judge, who was unjustly believing all over me, falsely accusing me of inappropriate and wrong strategy, and removing attorneys who withdraw from my requests. We have a spam call. Hello? Hello?
Are you there?
Is this Sarah? Hello?
Hi, this is Sarah. I'm calling because the
I know?
updated plan for Medicare has been released. And
Sarah, see ya. Sorry, Sarah, you're a robot. No spam call yet. I want a real person. So she was repeatedly lied to, who was the judge is believing all over me, falsely accusing me of inappropriate and wrong strategy of removing attorneys who withdraw from my request to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel, to which there is a right to counsel, but who received ineffective assistance is ordinarily entitled to a new proceeding with adequate representation, as long as there is a reasonable probability that the result might have been different if the person had received adequate legal assistance. I'm not sure if the result would be different. That's the definition of, or that's the explanation of ineffective assistance of counsel from the Bolivar Law Dictionary, I guess. Due to ineffective assistance of counsel, the federal courts in 1999 set this record sentencing aside. That's Smith versus Arizona. That's a very short excerpt from that case. Florida Constitution, 2024 edition, Article 1, Declaration of the Rights, says, Section 2, basic rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty to pursue happiness. Section 4, freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or the press in all criminal prosecutions and civil actions for defamation. The truth may be given in evidence if the matter charged is as defamatory is true and was published with good motives, the defendant writing the truthful, lawful letters to the court requesting help with dysfunction of attorneys, then the defendant is unlawfully forced to forfeit her right to counsel from lies, misrepresentations, and ineffectiveness from those former attorneys, retaliation from the court. The party, defendant, shall be exonerated, given appointed counsel. That's actually not what it says, but exonerated doesn't mean given appointed counsel. Section 5 says, right to assemble. The people shall have a right to peaceably assemble without harm, to instruct their representatives, and petition for redress of any grievances. Why did she cite that one? That's so we can have like political assemblies. Why did she cite Section 5? I think she's misreading these. Section 9, due process. No person shall be deprived of life, liberty, or property without due process of law, or be put twice in jeopardy for the same offense, or be compelled in any criminal matter to be witness against oneself. That's a good one. That is a good one. Section 16, rights of the accused. A, in all criminal prosecutions, the accused shall, upon demand, be informed of the nature and cause of the accusation and shall be furnished with a copy of the charges, and shall have the right to have compulsory process for witnesses. That means they can subpoena them. To confront a trial adverse witnesses, to be heard in person by counsel or both, and have a speedy and public trial by impartial jury in the county where the crime was committed. I'm surprised she didn't go into the speedy trial thing. New call. Hang on. Not a spam.
Call from
Sarah Boone.
To accept, press 1. To send a voicemail, press 2.
This is not Sarah Boone. Who's on the phone?
It's me, Donnie. I'm so sorry, man. I just had to. There's a lot going on over here with this writing, and it's getting me nervous. I just figured I'd throw it out there. All right. Have a good one. You did great today, by the way. You did great, by the way. And I found out that you're going to sit through this until the verdict comes back.
Yeah. Yep, we'll do that. Thank you, Donnie.
So even if it takes 24 hours or 48 hours, you're still going to be live?
I reserve the right to change my mind at a later point.
All right.
Thanks, Donnie. No caps.
I'll FaceTime you later, man. I'll FaceTime you later.
Sounds
Bye-bye.
good. We'll see you. Donnie, appreciate that. Donnie is a comedian. I say that truthfully. Access to courts. The courts shall be open to every person for redress of any injury, and the justice shall be administered without sale, denial, or delay. F. The 14th Amendment of the Federal Constitution declares all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This provision has been construed by the United States Supreme Court and has been uniformly held that due process of the law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. A like rule as to necessity for due notice and a reasonable opportunity to prepare for a defense is declared in Franklin v. State of South Carolina. Here's a citation. What's the year? I don't see the year in that one. And in other cases. Such notice was not a reasonable one, was not due process of law within the 14th Amendment to the Constitution of the United States, and a judgment obtained upon such notice was not binding upon the defendant. Okay, I've got to say this. I have read every letter that Sarah Boone has sent to the judge, and this is different. She is either receiving help from someone, or she's been very effective at Googling, and she's got case law that is pertinent to her case. This is interesting entirely. Let's see. Page 446 states that the essential elements of due process of law are notice, opportunity to be heard and defend in an orderly proceeding adapted to the nature of the case. The term due process of law, when applied to judicial proceedings, means a course of legal proceedings according to those rules and principles which have been established by our jurisprudence for the protection and enforcement of private rights. Penover v. Neff. There's a citation. Okay, a lot of these, the things that she just copies out of law books, obviously that's not her language, but some of the stuff that is her language seems to be written by someone else. Maybe her last lawyer bequeathed her some files. The accused cannot be deprived of his life, liberty, or property unless by the judgment of peers or the law of the land. The law of the land, like due process of law, requires timely notice and an opportunity to defend. It is vain. She's got some great. I mean, these are relevant case law for the most part. This is really good stuff. It is vain to give the accused. She might be better at being a pro se than we give her credit for. It is vain to give the accused a day in court with no opportunity to prepare for it, or to guarantee him counsel without giving the latter any opportunity to acquaint himself with the facts of the law of the case, or the law of the case. Every man is presumed innocent, and when accused, entitled to a reasonable opportunity to prepare his defense. That's Commonwealth versus O'Keefe. O'Keefe once again makes a rise in the third consecutive case that we're talking about. Sarah Adams, 9 months, long enough to have a baby. Time flies. Thank you, Sarah. I missed part 2 of a comment earlier from Elijah. Part 1 was, I think it helps to look at the emotional abuse with the lens of being severely bullied. When reduced to nothing, your state of mind is altered. Part 2 was, I still react to the picture of my main bully, permanent damage with multiple psych diagnosis on LTD since January 23 with a very poor prognosis. I'm sorry, Elijah. Thank you for sharing that. I do apologize. And Vic Stefani, thank you very much for a super sticker. We will go back to reading here, but I wanted to make sure I missed that. I didn't want to leave that behind. Sorry about Elijah. Part G, it is true that great and inexcusable delay in the enforcement of a criminal law is one of the grave evils of our time. Tell that to Georgia. Oh my goodness, they struggle with this. The prompt disposition of criminal cases is to be commended and encouraged, but in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. To do that is not to proceed promptly in the claims in the plain, it says claim spirit of regulated justice, but to go forward with the haste of the mob. An affirmation of the right to the aid of counsel is in petty offenses, and its denial in these crimes of gravest character, where such aid is needed most, is so outrageous and so obviously a perversion of all sense of proportion. Recognizing that the rule was settled at common law, denounced as it was, not keeping with the rest of the humane treatment of prisoners, for upon what face of reason can that assistance be denied to save the life of a man which has yet allowed him prosecutions for every petty trespass? How can a judge whose functions are purely judicial effectively discharge the obligations of counsel for the accused? He can and should see to it that the proceedings before the accused shall be dealt with justly and fairly. He cannot investigate the facts, advise and direct the defense, or participate in those necessary conferences between counsel and accused, which sometimes partake of the inviolable character of the confessional. Oh man, she's getting that sounds like something out of the federal papers. Let's see. Mildred Hornblower, there's always a jailhouse lawyer who helps inmates in exchange for favors. That might be what's happening. And Chicken, thank you for the call. SB was different last hearing. She seems scared now, so it worked. Not sure how fair it is if she doesn't get at least a small continuance. Fair is fair. She might win that. She might win that. Hey, Mrs. R.A. No. Is it missing? Sorry. Missing a piece on the Instapot. Article 5 declared that all criminals shall have the same privileges of witnesses and counsel as their prosecutors. Every person charged with treason, murder, felony, or other capital offense should be admitted to make full defense by counsel learned in law. Notice and hearing are preliminary steps essential to the passing of the enforceable judgment, and that they, together with a legally competent tribunal having jurisdiction of the case, constitute basic elements of the constitutional requirements of due process of law. The words of Webster, so often quoted, that by the law of the land is extended a law which hears before it condemns. Judgment without such citation and opportunity wants all the attributes of a judicial determination. It is judicial usurpation and oppression, and never can be upheld where justice is justly administered. Even the intelligent and educated layman has small and sometimes no skill in science of law. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he may have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he may not be guilty, he faces the danger of conviction because he does not know how to establish his innocence. If that be true of men of intelligence, how much more is it of the ignorant? If in any case, civil or criminal, a state or federal court were arbitrarily to refuse to hear a party by counsel, it reasonably may not be doubted that such a refusal would be a denial of hearing competency, and therefore of due process in the constitutional sense. The decisions all point to that conclusion. Pointing to the fact that the right of counsel is secured by the Sixth Amendment relates only to criminal prosecutions, Judge said, but it is equally true that the provision was inserted in the Constitution because the assistance of counsel was recognized as essential to any fair trial or case against a prisoner. In Ex parte Riggins case law, a case involving the Due Process Clause of the 14th Amendment, the court said, by way of illustration, that if the state should deprive a person of the benefit of counsel, it would not be due process of law. Judge Cooley refers to the right of a person accused of crime to have counsel as perhaps his most important privilege, and after discussing the development of the law upon that subject, says, With us, it is a universal principle of constitutional law that the prisoner shall be allowed a defense by counsel. The necessity of counsel was so vital and imperative that the failure of the trial court to make an effective appointment of counsel was likewise a denial of due process within the meaning of the 14th Amendment. All that is necessary now to decide, and we do decide, where the defendant is unable to employ counsel and is incapable adequately of making his own defense because of the ignorance or inexperience or the like, it is the duty of the court, whether requested or not, to assign counsel for him as necessary requisite of due process of law. And that duty is not discharged by an arraignment at such a time or under such circumstances as to preclude the giving of effective aid in the preparation of trial to the case. To hold otherwise would be to ignore the fundamental postulate already adverted to, that there are certain immutable principles of justice which inhere in the very idea of free government, which no member of the Union may disregard. Holden v. Hardy, supra. In a case such as this, whatever may be the rule in other cases, the right to have counsel appointed when necessary is a logical corollary from the constitutional right to be heard by counsel. Compare Carpenter and Sprague v. Dane County v. Smith, Hendricks v. State, Curtis v. State, People v. Goldson, and Delk v. State. Lots of citations. In Hendricks, so we're going to go through all of them. In Hendricks, supra, there was no statute authorizing the assignment of an attorney to accomplish the ends of public justice, and that the court possessed inherent power to make it. Where a prisoner, the court said, page 269, without legal knowledge is confined in jail, absent from his friends, without the aid of legal advice or the means to investigate the charge against him, it is impossible to conceive of a fair trial where he is compelled to conduct his case in court without the aid of counsel. Such a trial is not far removed from an ex parte proceeding. Let us suppose the extreme case of a prisoner charged with a capital offense, unable to employ counsel, with the whole power of the state arrayed against him, prosecuted by counsel for the state without the assignment of counsel for his defense, tried, convicted, and sentenced to death. Such a result, which, if carried into execution, would be little short of judicial murder. It cannot be doubted would be a gross violation of the guarantee of due process of law, and we venture to think that no appellate court, state or federal, would hesitate to so to decide. See Stevenson v. State, and a bunch of more citations. The legislative has become so thoroughly convinced by the impropriety and injustice of shackling and restricting a prisoner with whole respect to his defense that they have abolished all of these odious laws. And every person, when he is accused of a crime, is entitled to every possible privilege in making his defense and manifesting his innocence by the instrumentality of counsel and the testimony of witnesses. That's Powell v. Alabama. Part H. In a long line of cases that includes Powell v. Alabama, and a lot of other cases, this court has recognized that the Sixth Amendment right to counsel exists and is needed in order to protect the fundamental right to a fair trial. The Constitution guarantees a fair trial through the due process clauses, but it defines the basic elements of a fair trial largely through the several provisions of the Fifth Amendment, including the counsel clause. It's like the Santa Claus, but it's the counsel clause. Mildred Hornblower says there's always a jailhouse lawyer. Thank you very much for that, Mildred. Sorry, I missed that comment, or I might have got it. I apologize. This is if this is a jailhouse lawyer, they're doing some research. I mean, they're doing serious law research. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. I think she needs to argue the speedy trial one particularly, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. Thus, a fair trial is one which evidence subject to adversarial testing is presented to an impartial tribunal for resolution of issues defined in advance of the proceeding. The right to counsel plays a crucial role in the adversarial system embodied in the Sixth Amendment. Since access to counsel to counsel's skill and knowledge is necessary to accord defendants the ample opportunity to meet the case of the prosecution to which they are entitled. Adams v. United States. Oh, that's the end. Adams v. United States. That's the citation. Because of the vital importance of counsel's assistance, this court has held that, with certain exceptions, a person accused of a federal or state crime has a right to have counsel appointed if retained counsel cannot be obtained. And there's case law. That a person who happens to be a lawyer is present at trial alongside the accused, however, is not enough to satisfy the constitutional command. The Sixth Amendment recognizes the right to assistance of counsel because it envisions counsels playing a role that is critical to the ability of the adversarial system to produce just results. An accused is entitled to be assisted by an attorney, whether retained or appointed, who plays the role necessary to ensure that the trial is fair. For that reason, the court has recognized that the right to counsel is the right to effective assistance of counsel. More case law. Federal Rules of Criminal Procedure. Ooh, this is going to be fun. Section 44, right to appointment of counsel. Right to appointed. A defendant who is a defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding, from the initial appearance through appeal, unless the defendant waives this right. Defendant has been forced to forfeit her right to counsel from one-sided lies and unquestioned, misinterpreted requests for understanding, intervention for remedy, not removal, from the defendant to the court in her criminal case. That was Sarah Boone talking in the quotations, there in the parentheses. Part B, appointment procedure. Federal law and local court rules govern the procedure for implementing the right to counsel. Notes of Advisory Committee on Rules, 1944. 1. This rule is a restatement of existing law in regard to the defendant's constitutional right of counsel defined in recent judicial decisions. The Sixth Amendment provides, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. 18 U.S.C. former subsection 63, now subsection 3005, which is derived from the Act of April 30th, 1790. Well, that's going way back. Provides every person who is indicted of treason or other capital crime shall be allowed to make his full defense by counsel learned in law, and the court before which he is tried, or some judge thereof, shall be immediately upon his request assigned to him such counsel, and they shall have free access to him at all reasonable hours. Oh my goodness, she's going back to 1790, saying she should be able to reach her lawyer any time of the day. The present extent of the right of counsel has been defined recently in Johnson v. Zerbst, I think was the name, Walker v. Johnson, and Glasser v. United States. The rule is a reinstatement of the principles enunciated in these decisions. See also Holtzoff. Another citation. When society acts to deprive one of its members of its life, liberty, or property, it takes its most awesome steps. No general respect for, nor adherence to, the law as a whole can be well expected without judicial recognition of the paramount need for prompt, eminently fair, and sober criminal law procedures. The methods we employ in the enforcement of our criminal law have aptly been called the measures by which the quality of our civilization may be judged. That's the United States Supreme Court decision from somewhere. It just says U.S. Supreme Court. No citation. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests the Honorable Court to provide immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration, correct understanding, and overall perspective of in her extraordinary circumstances by rendering her cognitive incapacities, procedural inabilities, and extremely limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation, and oppression in her criminal case. Fair and equal position by fair and equal opportunity also will be greatly enhanced. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and her representation of self. Conclusion, this motion for immediate relief to defendant by appointing effective standby counsel to the aid and support of preparation of her case for trial should be granted. Oath. Under the authority of section subsection 92525 Florida statute and state v. Shearer, the defendant makes the following oath under the penalties of perjury. I declare under penalties of perjury that I have read the foregoing document and the facts and matters stated are true. Signed, Sarah Boone, with her name, Sarah Boone, underneath, in case you couldn't read it, which you could. We have a certificate of service. It says, I hereby certify this original of the document has been filed via U.S. mail by the clerk of the court, 9th Circuit, on the 18th day of July. Further certify the copy of the original document can be e-served via Florida courts to all attorneys or other parties on court record. That would include Mr. Prison Break himself. Taking bets, Boone ends up in another courtroom with her. Whoa! Objection sign. I'm going to say no on that one. I don't think that'll happen. I think she's going to actually try to do a good job. Motion is mute. She clearly has legal advice. She wants standby counsel. There are now 5 motions. Or we need to read faster because guess what? These things are coming in quickly. Let's go back to Orange County. That was motion number 1. Let's see, motion number 2. Let's refresh the page. Oh, never mind. Let's search again because apparently we timed out. See, our timer is up to 1 hour and 23 minutes, and I guess the seconds are cut off there, but let me actually shift this over. That bugs me. Box 1. We'll extend that out a little bit and move it to the right. Beautiful, beautiful. There we go. Okay, so all the 3% who chose less than an hour of deliberations, you have lost. Unfortunately, we're over an hour. There we go. Now we're good. So 5 motions. We've got some more. BG0369 says, I just went to ChatGPT and said, file a motion to dismiss a murder trial, cite historical case law, and it did it. Someone read it over the phone. You think she's doing ChatGPT for case law on this? That would be epic if she was. That's got to come out in court if she does. She's like, I have to file my motions with ChatGPT. All right, next motion. This one is, let's bring it over. Let's go full screen and embiggen the pixels so we can read this. All right, and I'll look at it this way. All right. Also, State of Florida versus Sarah Boone. This was filed, I believe, on the same day. Temporary motion for preservation of proposed costs. For reservation of proposed costs to acquire investigator for defendant's defense in trial. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire investigator for defendant's defense in trial. The investigator is to be determined. The total amount requesting is also to be determined. Oh my goodness. We'll fill in the links later. How to calculate, unknown by defendant. Reason, no discovery of or case materials provided to defendant from the judge. She wants an investigator to find out where her discovery is. This temporary motion is being submitted to meet the delegated due date of 7/22 by the judge and court as stated to defendant in the order dated 6/28. The defendant is trying to avoid any further persecution and penalization from the judge and court while vigorously attempting to succeed in her enforced position of pro se attorney and representation of self. The exceeded time limit of waiving to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed, will revise, and resubmit this motion upon completion of her review and research of the contents. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honorable Court to reserve any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The defendant requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and a representation of self. Conclusion. This temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial should be granted. There's the oath where she says, I declare under penalties of perjury that I have read the foregoing document and the facts and the matters stated are true, and certificate of service. She's delivered it to the judge. Now, next, we have another temporary motion for reservation of proposed costs to acquire expert witnesses for defendant's defense in trial. Comes now Sarah Boone. Pro se defendant respectfully requests from this court the reservation of proposed costs to acquire expert witnesses for defense at trial. Expert witness? To be determined. Total amount requesting? Also to be determined. How to calculate? Unknown by defendant. Reason? No discovery or case materials provided to defendant from the judge. This temporary motion is being submitted to meet the delegated due date of 7/22 by the judge in court as stated to the defendant in the order dated 6/28. This is terrible. She is doing a lot of copy pasting, but she does not have a copy paste device. Instead, she has to rewrite this every single time. The defendant is trying to avoid any further persecution and penalization from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney and a representation of self. The exceeded time limit of waiving to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed. We'll revise and resubmit this motion upon completion of review and research of the contents. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honorable Court to reserve any and all costs proposed to be incurred to acquire expert witnesses for and in the defense of her criminal case for trial. The defendant's requests are in good faith, and her merits are worthy of striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and representation of self. Conclusion. This temporary motion of reservation for proposed costs to acquire expert witnesses for defendant's defense in trial should be granted. There's her oath, signed by Sarah Boone, and a certificate of service. Mailed July 18th. Next one. Temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial. Comes now Sarah Boone, pro se indigent defendant. Respectfully requests from this court the reservation of proposed costs to acquire all witnesses needed for the defense in trial. Do witnesses get paid? This is not expert witnesses. This is, I guess, to fly down witnesses to court or something. The witnesses are to be determined. The total amount is also to be determined. How to calculate is unknown by the defendant, and no discovery or case materials provided the defendant from the judge. This temporary motion is being submitted to meet the delegated due date of 7/22 by the judge, as stated to the defendant in the order dated 6/28. The defendant is trying to avoid further persecution and penalization from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. Once again, we've got the same finalization here. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion once the defendant has finally received. These are placeholders. She's literally saying, hold this spot. Reserves money in case later we need it. As forced the temporary motion, once the defendant has finally received, she'll be able to proceed. We'll revise and resubmit this motion upon completion of her review of the research of the contents. Wherefore, Sarah Boone, pro se defendant, respectfully requests to the Honorable Court to reserve any and all costs proposed to acquire all witnesses needed for the defense in trial of her criminal case. The defense requests are in good faith, and her merits are worthy of striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and a representation of self. Is it just copy pasted? Did she? Nope. She rewrote every single one of these. I would have done differently. That was acquire all witnesses. We read that one. Let's see if we have one more. Conclusion. Temporary motion for reservation of any and all costs proposed to incur to acquire all witnesses needed for the defendant's defense in trial of her criminal case should be granted. There's her oath, her signature, certificate of service, and another one here. Temporary motion for depositions to be conducted for per Florida Rules of Court Procedure, I think, Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court for depositions to be conducted per the rule by defendant under pro se attorney title and position ordered by the judge and court. The deponents, who are you going to depose? We haven't decided yet. To be decided. Scheduled dates for deposition, also to be decided. Total amount requested for completion, to be decided. Total amount requested for transcripts, also to be decided. How to calculate, unknown by the defendant. Reason, defendant has been forced into the title and position of this pro se attorney by the judge and court. Pro se attorney requests to take the depositions for her defense, and no discovery or case materials have been provided to defendants by the judge. She's in all caps now. She switched to yelling right here on the reason. Florida rules 6H discovery depositions states generally, at any time after the filing of the charging documents, any party may take the deposition upon oral examination of any person authorized by this rule. In any case, no person shall be deposed more than once except by consent of the parties or by order of the court issued on good cause shown. A witness who refuses to obey a duly served subpoena may be adjudged in contempt of the court from which the subpoena is issued. A, the defendant may, without the leave of the court, take the deposition of any witnesses listed by the prosecution as a Category A witness. After receipt by the defendant of discovery exhibit, the defendant may, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charged. Discovery sanctions states, if at any time during the course of the proceedings it is brought to the attention of the court that the party had failed to comply with the applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness or not disclosed, or introducing evidence the material not disclosed, or enter such other as it may deems just under the circumstances. Willful violation by counsel or party not represented by counsel of an applicable discovery rule or an order issued pursuant to thereof shall subject counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings against the attorney or unrepresented party. This is actually rules against her, as well as the assessment of costs incurred by the opposing party when appropriate. This temporary matter is being submitted to meet the delegated due date of 7/22 because the judge said I had to on 6/28. The defendant is trying to avoid any further prosecution and penalization from the judge and court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's disclosure and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed, will revise and resubmit this motion upon completion of her review and research of the contents. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests the court to allow depositions to be conducted per the Florida rule by the defendant under pro se attorney title and position ordered by the judge and court, and for her defense in her criminal case at trial. The defendant requests are in good faith, and her merits are worthy of... I'm not sure if this one is. She has no names that she wants to include. She's like, I don't know who it is, but I request the ability to do that. Saying that, I don't know. Maybe, obviously, she's going to want to talk to everybody. This is let's see, she's striving to successfully, lawfully, and properly perform. I don't see what, I cannot read this word right here. My brain just won't tell me what that is. Thrive and overcome. And they're forced by the court proposition. I should have this memorized because it was in the previous one, right? I don't know. I can't find it. There's too many. Let's see. We're going back to here. Thrive and overcome her forced by the court position of pro se attorney and representation of self. Conclusion. Temporary motion for allowance of depositions to be conducted per the Florida rule by the defendant under pro se attorney title and position ordered by the judge and the court for a defense, and this trial should be granted. There's the oath, there's the signature, and the certificate of service. And it was all sent in one fat envelope to the judge with a whole bunch of stamps to make sure it got there. 19 pages enclosed. And we got 20 because we also kept a copy of the envelope it came in. So in response to that, the judge set a hearing. The hearing is over here. Let me bring that to you. The matter came before the court after reviewing the file. Ordered in a judge. A hearing is scheduled for August 5th. And this is to go over, and this is the exhibits. This is discovery, back and forth. Both sides get to see things. They get to see witness lists. They see exhibits. They get to see from both sides. We have the defendant's motion for reservation of proposed costs. Defendant's motion for reservation of proposed costs require expert witnesses. So we have investigator, witnesses, all witnesses. Defendant's motion to be conducted this is for to interview the witnesses, and the motion for immediate relief for appointing effective standby counsel. All that's going to happen in Florida on the 5th of August. Wow, so that's next week. Next week we get that hearing. Holy cow. Deliberation timer. Oops, we go back to SuperSource. Just 1 second. There we go. Up to an hour and a half. We have a very international audience. What size shirt would you like all those printed on, Greeners? Greeners says that because he sent me this shirt. Inmate seeks attorney. This was the full-page want ad for an attorney that Sarah Boone sent. But I have not worn this yet because I have not mowed the lawn, Greeners. But I will wear it when I mow the lawn. I need to do it soon because that's how we can get her some attention. Tisha says, I need that shirt. We put a link in chat where I think you could get it. I think for every shirt you buy, Greeners makes like $70, was it? Greeners, is that what it was? I don't know. I don't know if he even gets anything from that. Let's see. Can you imagine Sarah Boone questioning you in a deposition? I imagine she wants to do this. There are probably people who have not sat through a deposition that are on the witness list. I don't know. There's got to be some that she's going to be able to do. If they've already sat through one deposition, the court's probably going to say no. You've got the transcript. You've got, if she doesn't have the transcript, they might allow it. But let's see, Greeners gets, $0. I added a 7 on accident. Sorry, it's $0. There it is. There's the shirt if you want to buy that shirt. Greeners designed it. That's all on him. It does not come through me at all, other than that I just shared the link with you. If she's incarcerated, how's she using ChatGPT? She says she has a tablet periodically. I will say, and this has been a big issue for me, Sarah Boone throughout this case has expressed that she never waived her right to a speedy trial. We're going on for, 4 or 5 years, depending on who's counting. I think the court says 4, she says 5. But the right to speedy trial was waived. It was waived at a hearing, and the document is not signed by Sarah Boone. I don't know how you can do that. I don't know how you can waive your right to a speedy trial, because that's one of those rights that the defendant has to choose to waive. Sometimes there's even a colloquy involved with that. So, what courthouse is Sarah Boone at? She's in Orange County. Let's see. I have to check. It's Michael Kranick. Judge Michael Kranick is the judge. So wherever he's based out of. A shirt would not get through to Sarah Boone. They would not allow that to go through. It's tough getting things into the jail. Oftentimes, to get something in, as Ivan has taught us, it has to be ordered through a special catalog for inmates, where they can order approved items that are designed specifically to be used in a jail. meaning it's made of product. It's either made in such a way that it's not a risk or can't be used as a weapon. All that. It's hard to you can't just ship something. You can't even send them a book. If you want to send them a book, it has to be shipped generally from a bookstore or something like that. All right, a couple more messages here. Oh, thank you, Nurse for God. Thank you. I just got that one. Ronell Reichert, watching from South Africa. Big shout out to you. Says, is it possible to send a text when the jury has a verdict? Unfortunately, I cannot text from the burner phone internationally. I cannot reply. So I would not be able to do that. There are some really nifty accounts on Twitter, on X, that you might want to watch. And you also can just check for a verdict periodically. But so far, we're approaching an hour and 45 minutes in. No verdict yet. We don't know if they asked for dinner either. I have not looked at any of that either. Kelsey says, attorneys can waive speedy trial in Florida. There's like 8 different ways. Kelsey, you may be 100% right. And I think you probably are. But man, I don't like that. Where that is that's a right. How do you have an attorney taking away a client's right? That's what's happening if the attorney is waiving the right on behalf of the client. Oh, I don't like that at all. And there are 8 ways to do it. Buffer, we have a jury question, says Amber. We have a jury question. We will we'll watch and see what happens here. About a minute. My timer is about 3 minutes faster than the other. We start our timer based on the time the jury was sent out of the room. We give them about 15 seconds or 30 seconds to get in there. That would give the other people time to walk in, take their stuff out, and start. And it's just an approximate. But jury question coming up, so we'll keep an eye out for that. The audio's on. As soon as it happens, you'll hear it. Might be half an hour though, because everyone who is a party, as far as the defendant, the prosecution, and the defense counsel, all have to be present for the jury question. Love jury questions. Probably asking about lunch. All right. She acts like the judge didn't warn her over and over. She does overlook that fact. Man, Jenny, I agree. You guys are right. You guys understand this better than I do. I'm not a Florida attorney. I'm not an attorney. Let me just make that clear. Don't take my counsel as advice, legal advice. But the right to a speedy trial, something like that's ingrained in the Constitution, that can be waived by an attorney. Ooh. I don't like it. I don't like it. They're probably asking to go home for the night. If they are, we might have a hung jury. CBD says, my timer's about 15 seconds faster than yours. I started as soon as the judge dismissed the jury. The jury question is pizza, pepperoni or supreme? Oh, MD Thomas, let me just say, I'm starving. I had a salad for lunch. I didn't have breakfast. This starvation diet is working wonders. Reached a new all-time, well, not all-time low. My all-time low was about the time I was born. But I reached a new weight loss low when I weighed in this morning, which is I'm just super proud of that. But it's still, I'm hungry and I need to eat. So don't talk about pizza. Please update the banner. Oh my goodness. I left that up there the whole time. How embarrassing. Unpinned message, edit. We have people coming into court. All right. I missed the banner many times. I had the volume turned off. I'm sorry. It's back up now. You can, well, at least it's very quiet in my ears. Intermittent fasting, it really works. Today's my fast day, apparently. I had a salad. Actually, confession, I ate Mrs. R.A.'s salad. I really did. And she eats her salad without that wonderful, delicious Italian dressing.
I think I'm about to catch a whooping.
I'm about to catch a whooping. No, Stephen, we have a jury question is what we have. I'm looking for Amber's message so I can pin it. I'm going to pin this one. Of course, now I can't find it at all. There it is. Jury question.
I'm not a cat.
I'm not a cat. Okay. As we go to court and watch for an update, we are going to keep the deliberation timer running as long as we have
Shame
the
on
jury
you, sir.
out. Shame on me. Sound effects are going. Sorry. Baskin Robbins for dinner. Oh, man. Little brother has jury summons in Florida next week. I'm not sure what county. He lives close to Orlando. He would make a great juror for anyone. There you go. The state's here and seated. We might be hearing this very soon. Just waiting for defense now. There's no way they want to go home already. Well, maybe they might. Holy cow, is it 5:30 already?
I think I'm about to catch a whooping.
Where did the day go?
Back, taking it easy.
Here comes Ashley Benefield. Entourage counsel is present. I think we're going to start in just a minute.
All right, welcome back. You're back on the record in State versus Benefield, 2020 CF 3014. And you've been called back because there's a jury question. And I'm going to read the question, and if either side wants to approach and look at it yourselves, you sure can. I'm going to read it as it is. Dr. Quintella testimony. Defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine?
This was a state's witness that the defense called. I think that what the response should be is you have to rely on your notes. You have to rely on your notes. That's what it's going to be.
Okay. Anybody want to be heard first?
Any particular order?
No, sir.
I understand the question. What's the court's inquiry?
How do you listen for? I mean, I know in my mind how I think I'm going to respond, but I'm always going to give the parties an opportunity to be heard on
Sure. I think they should have Dr. Quintel's testimony read back to them, specifically because I asked Dr. Quintel if he reached any conclusions as a result of meeting and evaluating Douglas Benefield. And those were the conclusions that Dr. Quintel said he reached. It had nothing to do with my asking him if it was based upon anything Ashley Benefield told him. And I think unless that message is sent, unless that's clear to them, then I think it's a terrible prejudice to the defense.
I'm sorry, what's a prejudice to the defense?
What's the question?
No, what was the prejudice to the defense if what happened?
Prejudice to the defense is that they're being misled.
If we do what?
If we do not read back their testimony, his testimony. That way it doesn't have to be the lawyer's comments, it's the testimony of the witness, it's objective.
Judge, I think there are a couple options. One is the standard use your memory. I don't know if the court can offer to have something read back when they don't ask for it, but if it is read back, it needs to be the direct and the cross.
Of both.
Any final thoughts?
He's going to say rely on your
They
notes.
clearly are not asking for a readback. They're asking a factual question. And I would direct both sides to standard jury instructions 4.3 and 4.4. 4.3 addresses answers to juror inquiries during deliberations. 4.4 is request for readback or playback or transcript of testimony. We've all done this long enough. This is not a request for a readback. If they want a readback, they say we want a readback. They ask for testimony. It happens all the time. So at this point, the appropriate response is going to come from 4.3.
What kind of wonderful trial.
My notes show that
Judge, my concern, Your Honor, is that we're just assuming they know that they can ask for a readback. And I don't know that that's a fair assumption.
In your 400 trials, when have you ever given when has a judge ever given an instruction, hey, by the way, you could ask for a readback?
No.
No, I haven't either.
No, but I don't know if they know that, and the question may be inarticulate, that maybe you could ask for a clarification of the question.
Your Honor, Judge, we don't object to 4.3. We ask that you.
I'm sorry?
We agree 4.3 is the right.
Yeah, that's the correct response.
Yeah, if you needed us to agree, we do.
Okay. No, it's not even a debate. That's the correct response. It's 4.3.
4.3 answers jury inquiries. Let me read this for you. Members of the jury have discussed your note or question with the attorneys. You have asked the following question or made the following request. You read the juror's note. If I have not read your note correctly, please raise your hand. The answer is, respond to the question, I am not able to answer or respond to this question request because it calls for information that is not in evidence, is not proper to be considered in this case, or the reason why the request is improper. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it. So he's going to say, this guy types with a jackhammer. Bam, bam. In my reading of the Dr. Quintel, the first time he testified for the state, I got from him that he provided couple and individual marriage counseling to Ashley and Doug. So he made his findings based on all of that. I realized he spent most of his time with Ashley and only met with Doug, was it 2 or 5 times, I forget, by himself. He did say that Ashley, when separate from Doug, would divulge more about him, about what she was unhappy with during the relationship, and Doug was very interested in making the relationship work. The second time he testified, very similar testimony, he was qualified as an expert, and he testified that Doug was controlling and was going to make the relationship work in spite of what Ashley had said. Those are his conclusions based on all of what he did. Only 2 times with Doug. 5 with Ashley, 2 with Doug, and then some together. I would say this is a bad question for Ashley. It's a bad indicator. The question had to do with Dr. Quintel. He was the one who, once he was testifying for the defense, was qualified as an expert and was able to provide his own opinions on what Doug was like. And that he made those findings saying he was controlling, or those things the judge just read. They're not complementary attributes, I think, in the context it was used in.
Okay, I'm going to read you what I plan on telling them, and then you can comment on it how you want. This comes directly from 4.3. Members of the jury, I have discussed your note with the attorneys. You have asked the following question, and then I'll read it. If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it.
No objection.
Object.
Object for the same reasons that you want me to affirmatively offer a readback.
Yeah, okay. Just so we're clear, I think that what created that question was the plethora of misrepresentations that the state delivered to them in their closing argument, and that's the reason why they've asked that question.
But you know what? Tell me his name. It's not Quintella.
Quintal.
Quintel.
Q-U-I-N.
Like William Tell, Quintel.
Okay, thank you. Because like a quinella is a bet at the track, isn't it?
I think so.
I think that's what they're.
Double.
It's like me trying to call the other witness the wrong name the whole time.
Keyless.
All right, Madam Clerk, I'm going to have to send this to you because I don't have a printer.
Judge is emailing stuff around. Clerk's going to print it out.
Yeah, I'm sure.
They're going to repeat the question here in just a minute. I believe the jury is going to be called in. He's going to answer them and then send them back out to deliberate. Just hit the 2-hour mark. We have a jury question. No verdict. This inherent in this question is saying, did he reach his conclusion based on what Ashley said or on what Doug said? Meaning they don't believe Ashley. We'd be here for a couple hours. I think he was on the stand for at least an hour and a half altogether. You agreed the other way, Peter? We're making sure it's not from Ashley.
All right, ready to bring the jury in? Okay.
Yes, Judge. No, he was back.
You will bring the jury.
Everyone who's asking about the question, the judge is about to read the question back to the jury as soon as they come in. So we're gonna hear it straight from the judge one more time. The question has to do with Dr. Quintel making a finding or a conclusion about Doug and his attributes or his nature. And they said, was that based on what Ashley said or what Doug said?
Do you guys want me to broach the subject of food as well?
Yes, please.
Yes.
If you could pass the menu around to all of us, Judge, that would be really good.
Okay.
Jurors are entering. We're going to pause the clock just for a minute.
And y'all can have a seat wherever you want. You don't have to sit anywhere particular. All right, y'all can have a seat. Welcome back. Members of the jury, I have discussed your note with the attorneys. You have asked the following question. 7/29/24, Dr. Quintella testimony, defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine, signed one of the jurors? If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it. Also, I don't want to know what's been discussed. However, it's getting to be almost 6 o'clock. If you want us to order food, it is not, it's not steak and lobster. But we can order some pizzas and get some sodas and have them and brought to the room. If you want that to happen, also send a note through the deputies. All right, you may retire to continue your deliberations.
Wait till the door closes.
All right, you can have a seat. The jury is out.
Here we go. We're going to start it again. I don't know how far away they have to walk, but our counter will be a little higher than everybody else. They might be mumbling to themselves in the hallway. You never know. I think the first deliberation that will happen is about dinner, or if they're going to go home. Pizza party in the judge's chambers. That's what I heard. Told you it was pizza. I may have a discrepancy in notes. They got pretty good notes, though. Those different descriptions, the alpha male, domineering, all that, those were the words he used.
Judge, are we on break? I missed the last thing you said.
Oh, yeah.
Okay. We're on break. I think that's it. Okay, we're back to waiting. We might get another note very quickly, and it might have to do with food and scheduling. A new pizza place called The Slice. Oh, it sounds good already. Just the fact that they have sliced pizza. You see how hungry I am? How could he get that opinion from only speaking to Doug twice versus Ashley's input? It's got to be from Ashley as well. Isn't all pizza sliced? Yes, but when I say a pizza slice, you can envision like holding a slice and this aroma just wafting up from, yeah. Motion eliminated. I found in Florida law, statutory speedy trial can be waived by counsel even over defendant's objection. Ouch, that hurts. Man, Florida, what are you doing? What good is a right if someone can take it from you without your permission? I'm a little bit hungry. Not quite hangry yet, but just hungry. 2 lasagna in the oven. Jennifer, what time's dinner? We'll be right over. That sounds delicious as well. All right. Thanks. I got citation from the courts as well. Thank you for that. I'm surprised. I thought for some reason I was going to be able to run to the post office today, but I'm not. I need to run to the post office for 2 reasons. I have to tell them to start holding my mail until I get back from my trip, and I need to pick up the mail that they already have for me. Yes, we are still live, waiting for a verdict. We just had a question from the jury. Interesting question. They were relating specifically to Dr. Quintel. The second time when the defense recalled him, where he was called as an expert. Man, the more I think about that, that's got to be good for Ashley. They have a question about his testimony about Doug being domineering, alpha male, those terms that he used to describe Doug, and if he reached those conclusions by meeting with Doug or by meeting with Ashley only. I'm not sure if he answered that even on testimony. Counter's going. I'm just not showing the seconds. We're at 2:08:35. It looks like this on my screen. So it's going. You can request mail hold online. Yes, for this specific one, I have to actually be there in person because I've got to make a deal with the postmaster because they have like federal law says you can only do so far. I need him to violate federal law just a little bit for me because of what I need him to do. And he said, "Oh, just come in and talk to me, and we'll get it done." So I think he answered on cross. He said all. Found the clip, episode 9A, 307 timestamp. Prosecutor's last question. JVA, thank you for that. It gets a little tricky, especially with my soundboard having audio issues on the channels that it is. I'm just lucky that it's working right now. I can't bring in a lot of other court things until I can get this fixed. Are we discussing pizza toppings? Oh, I'm hungry. I'm so hungry. Sarma? Angela, I don't know what that is. Dolma. I don't know what that is either. Sounds yummy, maybe? I'm that hungry. I find it ridiculous the jury can't be told or reminded they can ask for a readback. This is a little frustrating because most likely, most of the jury members have never been on a jury before. You've only got 6 people in there, right? They've probably never served before. They don't know what to ask or the terminology to use. And they're like, well, they didn't use the key phrase that specifically says we'd like to hear the testimony again. They said they just wanted the answer. Well, it's their job to determine the answer. They need to be presented the information. I think the question, I think it does mean that they want to hear what it was. but they just don't understand their role exactly. Okay. Pineapple does not go on pizza. Ooh, maybe a spam call? Hello?
My name is Becky. I'm calling from Senior Benefits on recorded line. How are you?
I'm doing well, Becky. How are you?
Great. I'm with American Benefits. So based on the records, I'm sure that you may qualify for state-regulated final expense life insurance plan that's going to cover all of your funeral and burial expenses. Now, so how old are you right now?
I get nervous talking about death. Is it something somebody can just plan for me and I can just pay for it? Becky? Becky was having none of it. Sounded too young. I should have said 150. 150. Oh. AI does not compute. Yeah, Becky was a computer. Those were recordings. I'm older than Methuselah. That's what I am. Oh, man. I've never had that call before. End of life. Apparently I'm old enough that I should start thinking about that. I mean, I guess it's never too soon to plan ahead, but I always thought the pine box and the shovel was just going to be enough, but I guess no. Becky was so upfront about me dying. Yes. She's like, by the way, you're about to die and you need to think this one through. What are you going to do? How old are you? Only in U.S. people fall for calls like this, says Crusoe.
Call from
Angela.
Angela, how are you doing?
Yeah.
Welcome back.
I'm doing good. Thank you. I was trying to write down what sarma/dolma is. Depends on where you live, how it's called. Mm-hmm. And then, I mean, you gotta try like international food seriously. I mean, there is so much out there.
Tell me what it is. I mean, I spent years in London and I've eaten stuff from Jamaica. I've eaten stuff from some countries that I didn't know existed. I love trying new foods. I love all sorts of curries, Indian curries. Oh my goodness. Talk about flavor. Wow. What is dolma?
Well, it's basically ground beef, pan fried with onion, spices, and then you mix that with cooked rice, and then you fill cabbage. You put that in a cabbage, and then you roll the cabbage, and then put it in the oven, and that's it.
So spam fried rice? Is that what you said?
No, pan fried beef.
Pan fried
spam. Ground.
No. Spam is not.
Pan fried ground beef.
Yeah, ground beef and in the cabbage.
Yeah.
It's stuffed cabbage.
Yeah, it is. Yeah.
And then you bake. Then you bake the cabbage.
You take the leaves. You don't you don't make a hole in the cabbage or whatever. You take a leaf of a cabbage and then you roll that.
You roll it like a taco.
Yeah, or just like.
Why did you say tacos?
Like,
Are you having cabbage tacos for dinner?
It's not a taco. It's not a taco. It's like that burrito. Burrito is the name.
Okay, burrito. I was thinking soft-shelled taco, but you're right. A burrito is probably a better term. So cabbage just is to keep the insides together. It's not really as much for the flavor. It sounds delicious.
But if you put like what's your favorite dill cabbage or sour cabbage? Oh, that gives a flavor.
I'm worried about what flavor it gives, though.
it gives like well, it
Because
gives
now I
a
start
really
thinking
good
like
flavor. Let's put
kimchi. How are we getting close to kimchi here? Like rotten cabbage?
I don't know.
Kimchi,
Actually.
I think
Sorry.
was that sauerkraut. I don't know. There's a few things. Okay, I probably should try this before I make fun of it any further. Thank you for explaining what it is. Dolma is what it's called.
Yeah. I mean, there might be like, I know there's like dolma, frozen dolma that you can buy here in Sweden. There might be something to buy in some store. I don't know. But it's sour cabbage sounds bad, but it has a lot of vitamin C. It's really good to drink during like winter, and it's really good for hangover.
So
not that I do drink that as to
just a
cure
fun
my
fact,
hangover,
right?
because
It's
I
just good
can't. Just a fun fact, but
so if you have,
do like.
If you have like the cabbage leaf for the dinner version, do you have like a finger food version where you use like Brussels sprout leaves, little tiny ones? Like you just little appetizers?
No, I don't actually like Brussels sprouts. Fun fact.
I'm a fan of both. I'll eat cabbage and Brussels sprouts. I've never had the sour cabbage. Sauerkraut, I've never.
Well,
never
we
compared.
actually, I'm happy that we have basement here in the house, so we actually have we can make our own sour cabbage. We put it around in October, end of October, something like that, just before the what's the name, Halloween, or just after the Halloween, depends on our willingness to do it. But
it takes some time.
We
right?
want to do it. Yeah, I mean, it doesn't. It takes a few hours. It's not that. It doesn't take a lot.
Okay.
Yeah, but I did. Speaking of sour stuff, once upon a time when I was a little, actually, my grandparents used to make our own dill
pickles.
Yes,
dill pickles.
Sorry, forgot
love
the
it.
word for the. Yeah.
I love the homemade dill pickles. Are delicious. We grew the cucumbers myself growing up, and cucumbers are crazy because they grow under a canopy of leaves. Like the plant, the cucumber plant will grow leaves and pretty much cover and have the leaves gathering up all the light, and then you have to sort of like sort through the leaves and find the cucumbers. And so you might pick them one day, and you go back and pick 2 days later, and there's a cucumber that's like giant. It's like stretching at the seams, way too big for a pickle, but they just grow so fast.
Yeah.
A lot of fun. That's awesome. I might have to give it a try. Thanks for explaining the food to me, and now I'm even hungrier.
Sorry about that.
All right. Thank you, Angela.
Thank you. Bye-bye.
Bye. She's so much fun to talk to. She didn't think the Brussels sprout wraps were any good. I thought it was a great idea. Just past the 2 hour and 19-minute mark, about to 2 hours and 20. It makes Seeks International Chef. It's a new shirt idea. I bet we'll have an answer from the jury on food within. Oh, he's not going to talk about food, huh? We're not going to find out if they have a question on food. Love kimchi. Don't care for sauerkraut. I've never had either. I know some people eat like sauerkraut on a brat. Like you have like a hot dog, but like a brat instead. Which I'm a big fan of brats.
Call from.
Thanks for calling the Recovery Addict Food Network. This is Scott. Who am I speaking with?
Sharon.
Hey, Sharon. Did you call to talk about food too, or do you want to talk about the case?
No, I called to talk about the food.
Okay, wonderful. What?
With all due respect to your last caller, what she told you was stuffed cabbage. Dolmas are a Greek or Mediterranean food, and she's right. It can be ground meat, but mostly it's just rice seasoned with Mediterranean seasonings like oregano, thyme. sometimes they have pine nuts in them, and they're wrapped in grape leaves.
Wow.
And they are a handheld food. They're about, I don't know, 4 inches long. Usually you cut them in half. And the other thing you were talking about was shawarma.
Shawarma.
The other food, I think you called it sarma or something.
Solma or dolma or something?
No, that's a dolma. A dolma is a, huh?
Okay, keep going. I'm just putting this together
No,
in my head.
the dolma is what I just told you. It's the wrapped in the grape leaves. You can buy them in the supermarkets in a can even, but they're not as good as the fresh
wrapped
ones.
in grape leaves?
Yes.
Not cabbage?
No, not cabbage. That's a stuffed cabbage.
That's just
and it's not it's not fermented like the kimchi. It's just a regular cabbage.
I didn't know you could eat grape leaves.
Oh, you can. You should Google it.
All these years, I've just been picking the grapes.
EOLMA.
I've picked bushels and bushels of grapes for grape juice, but I've never thought about grazing on the leaves.
Well, you have to cook them.
That'd probably make it
You have to
taste
cook
different.
the whole thing. Yeah, but that's what a dolma is, and it's Mediterranean or Greek. And and the other thing that you said was shawarma, I think.
My favorite.
The food before that, you said.
My favorite, I think it's Greek food. You know the elephant leg on a spit that they cook and you make a kebab out of?
Mm-hmm.
I call it elephant leg. I don't know what else it is. It looks like a large elephant leg turning on a spit.
And they shave it off, right?
Yes, just the cooked part on the outside.
Yeah,
with
and they shave it off and they put it in a pita.
Yes.
Yeah, that's called shawarma.
That's shawarma?
SCHWARMA. Uh-huh.
Oh, that's delicious. That is really good.
Yeah, that is good.
And it's lamb.
It's the
apparently.
same seasonings that are on the. Well, you can get lamb, you can get chicken. Depends on where you live, I guess. I know where we live, we can get lamb or chicken.
You know what I could do with right now? I think I'm thinking British food right now. Absolutely love a good shepherd's pie and roast potatoes. The roast potatoes you get in England you can't make them over here. It's just not the same.
No.
Oh my goodness, they're so good. But a good shepherd's pie.
But you're not having your roast potatoes in your shepherd's pie, right?
I want them separate.
Shepherd's pie.
Because I like the texture of the potato with a little bit of a crunch to the outside, and so good.
Yeah. Well, it does sound good.
It's delicious.
But anyway,
what's your thoughts on the case? Do you think the jury's?
I don't know. I think. I don't know. I don't really want to think she's guilty, but everything she says doesn't exactly add up to. Like maybe she. I'm not. I mean, I could almost be persuaded that she planned it. You know, they had the one thing where she invited him over and intended to shoot him.
Wow.
But on the other hand,
do you know why this? I think this is crazy. Not that I think you're crazy for saying that, because a lot of people believe the same thing, and I can see the logic behind that. But what's crazy about that is if they could convince the jury of the same thing, they could have gone for murder 1 instead of murder 2. But
I don't think they really had anything to back that up except supposition.
Yeah, they didn't have the text messages or the journal entries. I'm planning on killing him tonight type thing. That they need something like that to get that get that conviction.
And the other thing was what I think the defense attorney said. Why would she bother to do that? Why would she wait so long? I don't know. I hope she gets off. I really do.
I think the state did not do a good job in disproving the self-defense claim, and for me that's enough to go lean on the not guilty side. I realize there's some problems, and this I wish it were a cleaner case that you could just. I mean, if it were any cleaner, in my opinion, we wouldn't have this trial already. The case never would have been brought to trial. But
it's probably true too. And I think that the defense attorney in his closing should have pointed out where the prosecution said, well, it might have been, he might have been turning, he might have been doing this, he might have done that. It could be either way, you know, because I thought that was a real good, probable, you know, reasonable doubt.
Yeah.
Because every time they said that, I said, wow, that's reasonable doubt right there.
Yep.
Because they even had doubt.
Every time the prosecution says it might not have happened this way, it's like, wait.
Yeah,
You mean,
exactly.
Oh man, that's basically exactly what the defense has been saying all along. It might not have happened the way the prosecution says. So.
Yeah, but see, I thought he should have reinforced it. He said, look, even the prosecution has reasonable doubt.
Yeah.
And then, you know, repeated their words back to them.
Good
I
stuff.
don't know.
Thanks for clarification and for more food talk. It's always welcome on the channel. So,
okay,
you so
well,
much.
I just couldn't let you go on thinking so incorrectly about it.
Well, apparently I have to
But
try them
Google
both:
it.
the lettuce wrap and
Yeah.
the grape. Does
Well,
it have to be like a
stuffed
special
cabbage
type
is-
of grape, or just any grape?
I don't know. They're pretty big leaves, so I don't know. They might be specially grown for their leaves.
Okay. Well,
I've made it a couple of times, but I just buy them in the grocery store.
Sounds good.
So,
Thank you so much. And tell me your name one more time.
Sharon.
Sharon. I appreciate the call, Sharon.
Yes.
Good talking to you. Have a great
Okay.
night. We'll see
Okay,
you.
thanks. Bye.
Bye. All right. I missed a call from Rebecca during that. Sorry, Rebecca, if you hear this, give us a call back. All right. One thing that jumped out to me just a minute ago, thinking about the defense, while they were talking about this question, and Mr. Taylor got up and was complaining. Oh, this is Thal.
Call from.
When Thal, hold on just 1 second. When Mr. Taylor got up and he said, I think you have to do this or this will be a prejudice to my client. And he said, you have to do this because of all the inaccuracies and misconstrusions that is that a word? I'm not sure. That of the prosecution during their closing statement. Guess how many objections he made? 0 during their closing statement. There were 7 by the prosecution during his closing statement. He said nothing during theirs. And maybe that just might be old school. You just don't interrupt a closing statement. It does look like bad form. But I think it was like sour grapes a little too late. Thal, what food have you brought to our discussion today?
Oh, nothing. I had cod, butter and garlic and oregano. I just cooked up the steak. I'm gonna have to yell at you.
I love seafood. I mean, just for the halibut. So
I hate fish. I hate fish. I detest it, but I have to eat it more if I want to lose weight. So I'm going to yell at you because you said something you shouldn't be doing, and I'm going to yell at you about it. And that is, you said you're starving and you're not eating, and this is a part of the diet of starving yourself. No. Going to take you back behind the woodshed.
I have to have regular. I know.
I'm going to slap you.
Let me just say. The reasoning is if you starve your body too much, it thinks, oh great, I'm not getting enough food. Any nutrients I get just store up, and it goes into like a different mode, and they end up actually not losing weight. I hear that.
I don't even care about that. I don't care anything about that. That's not where I'm coming from at all, brother.
I just need
I love your theory. It don't make a ding dong difference to me. What I'm talking about is I'm talking about the psychological aspect. You're going to end up binge eating. You keep playing with this dragon. Okay? You're going to end up doing it. You know I'm right. So stop doing it. You find yourself some sugar-free alternatives. You go snack on them.
I can't stand sugar-free.
They cost. Bear it. I don't care. Get something in your gullet, or you're going to go binge on Dairy Queen, and you're going to set yourself back 2 weeks. So you stop doing that. Go find something nummy and go have a snacky poo. Okay, I don't care. Stop the starvation nonsense. You stop it.
I'm not starving. I didn't eat breakfast because I woke up late. That was my fault. Normally I would eat breakfast. My wife brought in a huge plate, a heaping salad. And I looked at her and said, that looks good. I wonder how it tastes. And she handed me the fork and the plate, and I ate her entire salad. So it had, I would say it was a bacon salad with croutons. There was a lot of crumbled bacon on it, which was delicious. So I've got plenty of nutrients to survive on. I'm just ready to eat dinner right now is all.
Well, yeah, but I mean, if we want to talk straight nutrients, I'm 300 pounds, so I'm 100 pounds overweight. I could go without eating, technically, without nutrients for a month.
So
should I do it?
We're
God,
both about in the
but-
same place. We're about the same place.
Yes.
That's
That's why I'm yelling at you.
I will tell you though, I have never felt better. I've never had more energy. Like in the last, since I've started live streaming, I'd say I've never, like my body, I feel good. I'm sleeping better. I have better energy overall. I'm losing weight. I'm liking the change. So I'm going to keep eating my bacon and lettuce.
Well, and I'm going to take this opportunity to preach my mantra at you yet again.
Go for it.
And chat can listen because it's good advice. That's why Better Call Saul, Uncle Saul says what you do is you start off with the calorie intake you have every day. You figure what that is over a 2-week period of time. You find the average, include all the little tricky treats you want to. It doesn't matter. And then after that 2-week period, you go, okay, I'm going to set the bar down 100 calories for that entire next week. You meet that threshold, you get under that threshold, good boy, good girl. You go to the next one, you go 100 calories down again, because you're allowing, and if you fail, you stop there and keep that until you can make it. Because what you're doing is you're providing yourself a lifestyle change. You're changing your habits. You're changing your psychology. You're changing what you're eating. You're going to feel better eventually. And for God's sakes, whatever you do, don't look at the scale.
Now, I'm glad that works.
Because if you eat less, kids, you will lose weight. It's like falling out of a tree. At no point do you fall out of the tree and float. That does not happen.
I float quite well right now, but I don't want to cut your call off here, so I'm going to show you. I have a...
Yes, you do. You love cutting my call off.
I do a lot. I'm sorry. I have a...
You're fine, buddy.
I have a scale that... I have a little chart that shows how much I weigh, like right here. It's got a little... My scale is Bluetooth, and it connects to my phone. And
okay, fine. You can play with that. You can play with that all you want to. My point is, don't let that rule you. Okay?
I don't. I just
don't focus on that. Don't let it rule you. You keep just doing your thing, regardless of what it says.
For me, I'm focusing on portion control instead of.
There you go.
Instead of eating, as long as there's food there, which I enjoy eating, and food tastes good, and it's so much fun. But I've switched to be like, I will serve up a healthy portion. Okay, I'm not starving myself. I'm not like eating just a sliver of something. I'm piling my plate saying this is what I'm going to eat, and then I'm done. And I might still be like, I could fit some more. Yeah, but I'm done. And that has been the big thing. That and stopping Mountain Dew. I haven't had Mountain Dew in over 2 months.
Yeah, I was about to say it took roughly a month and a half, 2 months for me to switch over to what is it? The Zero Coke, Zero Pepsi, whatever it is. And now every time I have a soda, my guts feel like they're about to explode as far as like swelling. It's weird. My body's like, what is that?
So we've talked about weight loss. We need to talk about food and then something about the case really quickly to complete the call.
Okay. So something about food. Surprisingly, butter, Chat was right. Hats off to Chat. I had multiple people tell me yesterday that butter with, if you baste fish with butter, garlic, a mix of butter, garlic, and oregano, you can't go wrong, and maybe a little bit of lemon. Chat was right. It's worked on every fish I've tried it on, and it's a great way to eat fish. It's surprisingly really good because I hate fish. Yep. And about the case, I loved and hated the defense attorney. Absolutely loved the fact that he was willing to go, just off the rails for his client and just really commit to everything. Hated how many times he interrupted his arguments, his argumentation, and everything else just annoyed the bejeebles out of me. So, yeah, I found him awfully annoying, but I know why he did it. And he did a good job. So love and hate at the same time.
Awesome, Thal. Thank you very much. Good to hear from you again.
You're welcome, sir.
We'll see you.
Yep.
Bye. I kid with Thal a lot. He's a good friend. I really appreciate him. He's helped me out a ton, especially when I just got started, giving me advice and things like that. As a fellow content creator, he's had channels I believe much bigger than mine that he's run. So I appreciate that. A to Z says, did the judge give a cutoff time for deliberation tonight? Thanks. No, he said, I usually just let him go until they ask to go home. And it's another one of those things where I guess they have to just know to ask. Let's see.
Call from
Lego My Briefs.
Lego My Briefs. We've got 3 topics on the table: weight loss, food, and court. Which one are you called?
We'll skip the weight loss, will we? Anyway, hi, boss. How are you, darling? It's been a long time. What? You're speechless.
Are you talking to me?
Yes.
Oh, what? I'm doing well.
Oh, good. Anyway, my parents were both from Dublin, so growing up,
you guys know
bangers and mash.
Yep.
Oh, hell yeah. Mm-hmm. Oh, yeah, every form of a potato. You worship the potato. But yeah, we'd have bangers and mash or shepherd's pie or...
love shepherd's pie.
Even if you'd have like mashed potatoes and meat of some sort, you'd always have the Brussels sprouts were commonplace. Mushy peas. I don't know if anybody even knows what they are. I love them, but marrow fat peas, blood pudding. Anyway,
you lost me at mushy peas, and the blood pudding is definitely out.
Really?
Yeah. I can't do that
sorry.
or
that is a required taste. I grew up with it, so I've learned to love it. Mm-hmm. Very hard to get now, but when we do, it's a celebration.
I will say.
But anyway, I wanted to tell you.
I won't eat that, but I will eat haggis. I'll eat haggis.
I will not eat. Oh, no, gross. Yeah.
I know it sounds
awful. Robbie Burns can keep that. Just the look of it looks like a brain. I'm not interested. Mm-hmm. But when I was growing up, one thing that I loved was when my mom would make steak and kidney pie.
Oh, man.
And, of course, she'd teach us how to make everything. I mean, to do flour, you'd have it all rehearsed in your head. It'd be 3, 2, and 1/4. You know what I mean?
I hear Irish accent come out as you say that. When you say flour and quarter.
Yeah. Yeah. So when we grow up, we want to try your mother's recipes, and I was fantastic at making the pastry. So I thought, you know what, I'm going to surprise everybody, make a steak and kidney pie. My husband loves it, and he used to ask my mom for it for his birthday. So anyway, I'm home alone. I bought all the ingredients, and I'm doing what I got to do, and then the kidneys go into the pan, and I thought I was going to die. I called my mom, and I said, why do they smell so bad? And she said that that's the urine. She said, yeah, it has to kind of cook out. And anyway, I hung up. I persevered with nausea. Finished. The steak was fantastic. I put everything into the pie, baked it in the oven. Smelled and looked just like my mom, but I couldn't eat it. And I've never eaten it since.
I was served it once over in England. I can't do kidney. I can't.
Yes, but when you're little and the kidney's got a neat texture, you'd pop it in the mouth.
It does have the neat texture.
But when you grow up and you try it, then you know what it is. For me, it was the smell. I had no idea my mom went through that before it came out on the tape.
You were out playing every time. She was suffering through the smell in the kitchen. I tell you, my favorite that I did not ever have as a kid, probably because we were too poor to buy it, a shrimp. Oh my goodness, I could eat shrimp.
And see, yeah, my husband grew up on the East Coast, so he's from Newfoundland, and for them, commonplace would be squid and kipling and you name it. Like that's just their mussels and mackerel and God knows what. That's them. Or mostly squid. I remember his mother used to cut up a squid and make squid rings in the oven, but one time, the first time I ever saw her do it, she stuffed them all with stuffing. And
stuffed
can you
shrimp?
picture that? No, stuffed squid.
Stuffed squid. Oh.
And they looked like appendages.
Oops. I'll pass on whatever that is.
Yeah, me too. Oh God, gross. Yeah.
Oh, we just had a
All right,
raid.
so that's
We
well,
just had a raid from Brandy Churchwell and Broken Baker. Just raided us.
right
Welcome
on.
to all the
Broken Baker too.
Yes,
Wow.
welcome to
woohoo.
all the bakers. We're talking about food, which is great. And Brandy Churchwell, welcome. Good to have you here. Thank you so
Yeah.
much. Love the 13th jurors as well.
Hey, Brandy. Hey, Baker. So,
Yeah.
so that's that. That's the
So
food.
we've talked about food. Do you want to talk about court now?
Yes, I do. So this is why I love law, and every trial is different. Every trial is different. Most of the time, you go in with no opinion, and you slide in one direction or another, and then I usually end up somewhere. Right this time, I don't know. I really don't know. I think I'm the most relaxed with this jury out because I really don't know what they're going to come back with, and I'm not committed to either. So it is what it is.
So the defense attorney part of me, which there isn't one, but if there was, would say that, my friend, is reasonable doubt. So,
yes, it is.
But
it is. It's so hard to know on this one because you don't know. The only two people that really know, one of them is gone. So yeah.
And,
so
and
we'll
that
see.
said,
We'll see.
It's crazy. The jury unfortunately has to make a decision. So we'll see. Sunshine Sarah says, "Let's make it rain super chats. Pizza party for RA." So I'm clearly talking about food too much.
That sounds good, especially when on Fridays we don't wear any pants.
Yes, no pants Friday.
So
it's only
pizza
Tuesday
party,
today, though.
pantless pizza party, a pantless pizza party.
Yeah. Wow. Okay.
All right, I'll let you go.
Thank you very
Good
much.
night,
Good talking
Bob.
to you. Can you
Good
say
night,
wait? Can you say something with a strong Irish accent first? Like,
What would you like me to say, darling?
it's magically delicious.
What would you like me to say? Yeah, sure, it's magically delicious. Of course it is.
Okay, there we go. Thank you, Leg of My Briefs. Good talking to you.
Okay, bye.
Bye. All right, I think now it's official. It's official. The Baker raid is coming in as we speak. Brandy's has just barely popped in just a second ago as well. So I don't want to miss and thank them. But we are grateful for both the Bakers. We are talking about food, by the way, on this as we are sitting here in court, looking at the wall with nothing to talk about. We're talking about food. We're talking about court and apparently weight loss.
Third time is a charm, Angela.
Angela, you've used up all three of your calls today. What's on your mind today?
Well, actually, I just wanted to set the record straight regarding the caller that came in after me.
Yeah.
I am from Serbia. I am from Balkan, born and raised until I moved to Sweden. So if anyone knows Balkan food, it's me. I'm not going to bore you with the history. But
I will say this, different
Parma,
cultures use the same name for very different foods sometimes.
Yeah.
Like chips for me
Parma
are different
and
than
Dolma
chips in
is-
England.
Yeah, but also Sarma and Dolma is the same thing because they were born on Balkan way before U.S. was even born. It was like a 1600 years. I actually had to look it up. But actually, this time I actually have to say regarding which I forgot last time. Regarding the jury question. I think that what the most people is believe. What we had was like 66-33 or something like that.
Mm-hmm.
Is that percent? They are also divided. Like, do we believe her, and how does professionals back up her what she testified to?
Right.
And that I think that's what they're. And if I think they should request the read back.
I hope they understand that they can ask for a read back. A lot of times we have, we'll see in a case where juries, they're told, hey, you can ask a question. If you start deliberating, send a question to the judge, and we'll handle it there. They get the question and the judge says no, like he did here. He's like, got your question? No, that's your job. It's like getting their hand smacked. that this whole time the judge has been helpful. Anything you need, is everything okay? Your pens, got good pens, enough paper, everybody? Does anybody need a break? And now you're like, hey, I've got one thing. I just need this question answered. And he's like, no, that's you. And they sort of retreat into their shell, and then they stay there until they've either reached a verdict or hung. So we'll see if they follow up with the question. I like to see questions where the jury gets a little bit of an encouragement during in the answer. But obviously, the judge has to be completely impartial. And in this case, he's such that he doesn't give them any clue as to what they can ask if there was a further question. So, but to be fair, he did the same to the lawyers. He didn't give them any help whatsoever when they were making a motion. And then he's like, well, now I'm going to make a ruling. And they're like, wait, should I have done this? And he said, yeah, you had your time. You didn't do it. It's like, whoops. Oh, well.
But I love that defense attorney did one thing right and made the record that he requested not only to ask the jury if they want to read back. I don't remember exactly his words, but that's what he said. But also to give instruction that they can ask for a read back.
Yeah.
And
they haven't. I don't think they were told that in their instructions.
No, they were not. But it's on the record.
Yeah.
He said it on the record, so he can go back and complain in the worst case scenario she is convicted.
Yeah.
Not saying that she is not guilty, just preserving the record.
Right. They have to have it on the record to preserve for an appeal. So.
Yeah.
Angela, what time of night is it for you right now?
midnight. Olympics screwed up my sleeping schedule, so I'll go back to normal sleeping when Olympics are done.
All right. Sounds good. Wonderful talking to you again. Thank you so much, Angela.
Thank you. Bye-bye.
We'll see you. Bye. All right. Welcome to Broken Bakers and Brandy Churchwell, 13th jurors. Wonderful to have you all here. We are on Verdict Watch. We're 2 hours and 47 minutes into Verdict Watch for the Ashley Benefield trial. We've had one jury question so far. The one question the jury asked was specifically relating to Dr. Quintel, who was a witness that the state called initially. He was a state's witness, and then defense recalled him. When the state called him, he was called as the sort of the therapist that saw both Ashley and Doug. And they got some evidence in from him. When the defense called him, they got some evidence again. It was very similar testimony, went a little bit further. And then, after most of the evidence, they had him certified as an expert, and then he gave his opinion. He never did that for the state. So he gave us this opinion, and that opinion about Doug, specifically that he was alpha male, domineering type, and there were a couple other words there. That opinion is what the jury had a question about, saying, did he form that opinion based on meeting with Doug? Or was that from something that Ashley had told him? And the judge responded and said, we can't tell you that, unfortunately.
Call from
Master Ayden.
Master Ayden, thanks for trying and calling back. I appreciate that. I missed a couple calls from you. I saw that. How are you doing?
Oh, it's okay. I'm doing great. I have two things I want to get out real quick. One, I've been summoned for jury duty August 15th. I stay in Bear County, so please, guys, pray that it's Judge Boyd. I want her autograph.
That would be awesome if you're with Judge Boyd. We'll have to watch. We'll make a note.
I don't know what it's going to be. This is my first time. Yeah, now because I'm blind, they're saying I can get exempt, but I told them, no, I don't want to be exempt. This guy, Recovery Addict, he got me into law and courtrooms, and I want to be a participant. So everybody's like, oh, who's that guy? So kind of shot me out of work. They're like, who's this guy? I'm like getting everybody, no, look, guys, he has all this courtroom content. You're going to love it. You're going to get hooked. And another thing that I noticed about this case that kind of resonated with me, what kind of concerned me, is I share the same opinion with you. I'm emphatically not guilty based off of all the things you said. I was agreeing the same way because I was like, they're all in sync. Like the defense, everybody's singing the same song. There's no discrepancies, consistency everywhere. The only thing that was concerning me is the lawyer. And I was kind of fighting this thought, because in my mind I'm like, okay, he's supposed to defend his client at all costs. Whatever you can do, defend
within the bounds of
Right. And he came off a little overbearing sometimes. I felt like he fought too hard, and in my mind I'm like, well, what's too hard? But he just came off as, I have to get this in. He came off as, a little rebellious, a little overbearing, and I in my mind, I'm like, I hope the jury doesn't feel the same way I feel, and it hurts his client because, at some points I was like, okay, I get he's trying to make the point, but he has to learn to let it go. And sometimes, jurors can see, why is he overdoing it a little bit? Convince me, but don't overly do it, and I hope it didn't come off that way, to some people.
He struck me a little bit like Hunter from the Maya trial, where he comes in with all this experience. Mr. Hunter, I think it was Mr. Hunter. He walks in there, he's like, Judge, I'm old school, 400 cases under my belt. I know what I'm doing. And how many times have you heard the judge say, I'm not sure if you've ever, if what cases you've watched, or, this has never happened in any of the 400. The judge probably has equally, if not more, cases under his belt from all his legal experience. And so him walking in all braggadocio and being like, look, I'm an old school lawyer. I know the ropes here. I'm going to win. The judge sort of got, I think it set his teeth on edge just a tiny bit.
Right. I always see a judge as a referee. So it'd be equivalent to like a football, like Tom Brady walking to the referee and look, man, I played a lot of games in my day. I know what I'm doing. You don't call this call, and I'm like, no, you just don't talk to the judge like that. And in some ways, I thought he was a little bit more favorable to the state because he was more agitated. Even though I like this judge, I think he is fair. But there are times where I was like, I know he's agitated, and he's just like, oh, here we go. But he can't really show it on camera. He has to be impartial. He has to be fair. It's almost like, I know this guy is like pissing this judge off, and he's gonna.
The judge has a pillow in his chambers. He goes in, he's like, oh, he just yells at him.
Right. He's very soft, and then he's gonna have his picture there, and the judge is gonna get a bat and just go to town on all the expensive stuff in the house, and he's gonna be like, I feel better now. Yeah, Tyler.
Master Ayden, thanks for the call. It's a little bit echoey on your end. I'm not sure what's happening, but
I'm in the bathroom because my kids are loud, so I have to get. I figure I get to a quiet spot because they're like, Daddy. But I just want to throw that out there, and I'm hoping it's pizza tonight. I love pizza.
All right, thank you for hitting both the court and the food talk. So appreciate that.
Thank you.
Thanks, Master Ayden. We'll catch you later. Bye.
You too.
Call from
Google Cheryl.
Google Cheryl? Can you turn your TV down just a little bit?
Whoops, I made a mistake again. The last time I called was over a year ago, and I said, Cheryl, and you mimicked me.
Oh, okay. I mimic. I hear what I said. So just Cheryl.
Yeah, it's Groovy Cheryl. Okay,
Groovy
I
Cheryl.
got it this time. Okay.
All right. So are you calling to talk about the trial or about food? Those are our two main topics.
Trial.
Oh, wonderful.
Well, of course, I want to say that pineapple and ham pizza is the best. But also, I do feel like we need to hear from some of the gals that have been through abuse. And so many people are just offhandedly saying things that indicate that they just don't believe a woman. And I really feel like this is an important time in history because we need to first believe a woman until there is a reason not to. And that is the same way our justice system works. You're not guilty until you're proven guilty. And they didn't prove her guilt over the top of the defense. And I feel like they did a really good job, and I'm just hoping that this jury gets it right. But I would just want the people out there to have a moment of time where they actually stop and think about what it's like to be on the other side of this issue, because it's a big issue, and we're hurting.
Cheryl, I've struggled with this because, I mean, there are some things that I see that Ashley's doing that I'm like, that doesn't make sense to me a little bit. I've told you about the behavior that seems different when the jury's there. That confused me. That sort of like, I'm not sure. But at the same point, I've said over and over, there is no part of me that wants to go and say, you didn't suffer abuse. That's not real. That didn't happen. I can't do that. I don't know how I could.
Thank you.
And
thank you. I believe she's been coached to look a certain way, to act a certain way. I don't perceive myself that she is actually as harmed as she tends to look, in her little position and her mopey face.
I think that's part of what she's been instructed to do, but she's been instructed for a reason, and that is that it takes thousands of years of ridiculing women for every single thing that they do. And her attorney knows to instruct her a certain way because it will all come back to haunt her in the social media area.
I will say, I'll say this. I don't know about a lot of that. I really don't. I'm not able to speak on it. And honestly, I don't know even how I can moderate a conversation about it. It's been that difficult for me to find a point. I know there's some very strong feelings, very strong experiences on both sides, men and women, both being abused, and it's possible both ways. But I've had to just step back and look at the law on this one, and that's the only thing I can rely on. For me, I can reach a point where I don't hesitate to act. I say, yes, I'm going to go ahead and say not guilty. I would jump to that because of just the state not disproving self-defense, and I just have to take the testimony on the stand at face value. I don't have any other information to base it on, and Ashley testified that there was abuse, and there was nothing the state did to prove that it didn't happen. All they said was, she complained about it before, but no charges were filed.
Right. I think you're correct in that we spend way too much time negotiating with each other about what the reasoning is, but it doesn't really matter the reasoning. It was a stand your ground, as far as I can tell. She didn't try to get him in that bedroom. She didn't try to get him in a position where he couldn't defend himself.
She lost her stand your ground hearing, and was actually, I think, reprimanded by the judge. Because everything she presented, there was no evidence of or something, or everything that was presented. But it didn't make sense to me. That I'll have to go back and watch it. And it was over 2 days. I think a little bit one day, a little bit the next day. But she didn't take the stand. She didn't testify in that one, which I think was an oversight.
Right. Well, in fact, she was right not taking the stand because they would have used it against her in the court. But they did. She lost the stand your ground on that level. But it didn't mean stand your ground doesn't pertain to her case.
It still could be self-defense.
She gets to still have that as a defense, and I believe she's
the stand your
met that,
ground hearing
level.
is basically the judge. It's almost like a judgment of acquittal, right? It's the judge before it goes to trial looking and saying, yes, actually, you do have a legal defense. You stood your ground. This never should go prosecuted. It's one step to prevent it from going to trial. But as we heard from some of the lawyers down there in Florida, I think Peter, the lawyer, almost nobody wins the stand the ground hearing. But I appreciate the call. Thanks for the information, and thanks for the perspective.
Thank you. I'll try not to stutter the next time.
All right. So we'll see you, Cheryl. We'll see you.
Okay, thanks. Bye-bye.
All right. She did lose her stand the ground. Judge went on facts. She didn't present evidence that, she did not testify and tell her story, which I think was exactly what should have happened there, but I can see the reasoning why she didn't. Almost 3 hours in. Amy, this is Recovery Addict. How are you doing today?
Hi, doing well. This is Kaylee.
Oh, Kaylee. I said Amy. I heard wrong. Kaylee. Is it Kaylee with the flower in chat?
Yeah, Rose. That's my middle name.
All right. Kaylee, are you calling to talk about food or the court case?
Well, so both, I think.
Oh, wonderful. You kick it off.
Okay. I'll be quick. So I've been following this really closely, but I worked most of the day today. So instead of opining, I figured I would maybe ask you for kind of a recap of the closing arguments, and kind of get your take on that. And for food, I was going to say I've been doing, I know it sounds very odd because it's not well known yet, but I've been doing carnivore. So you stick to meat, seafood, products. And depending on how strict with it you want to go, some people can do like Lion diet, where it's pretty much steak only. I'm much more relaxed in order to make it a lifestyle, but I have loved it. So I recommend people check it out if they're curious.
My initial take on the prosecution's closing, both times, were fairly, I'll use the term aggressive in that they were very assertive in their argument, and they did a lot of calling into question Ashley's behavior. And initially, they said basically her behavior doesn't match the textbook domestic violence victim. Okay, she did move away. She didn't return to him. They went down and checked this list, and they said, they called into question, why would you get pregnant with somebody who, within like a couple weeks before just fired a gun into the ceiling in a fight against you, and just did a lot of breaking it down. They didn't spend a lot of time talking about evidence to show that she was guilty. And by guilty, I mean, there's no question that Ashley fired the gun. She's admitting that. They didn't do it with a lot of time to show that it wasn't self-defense, other than asking putting these questions out there. And unfortunately, I don't think that's proven beyond a reasonable doubt for me. You can introduce doubt, and I think they did a very good job of doing that. And there is doubt in my mind as well regarding that. But that doubt doesn't get rid of the other reasonable possibility that this was self-defense for me.
Yeah, I totally hear you on that. Things that didn't come into the trial, I definitely find very compelling.
Yeah, DNA.
What
goodness.
other...
The DNA test didn't come in.
Even just prior judicial hearings, the abuse reports, there's lots of things where I find them very suspect, as did other judges and investigators. We had there isn't a scintilla of odor of evidence in these claims. So there are things that I think lend weight toward the theory that she was setting something up, and then she took her opportunity when she kind of crafted an opportunity and took it when she saw it. But if that didn't go to the jury, then they have tons of reasonable doubt. So while I think a better case could have been put on, I think the jury got handed a very reasonably doubtable case.
Let me ask you this, because the legal system in this case, to this point, has, for the most part, not believed anything she said. Okay, I think that's a pretty fair statement to say. She's made allegations of abuse of all different natures, I think against her as well as her daughter. The only real restraining order they got, I think, was one that they both mutually agreed on. The judge just signed off. That's not really a finding against that. And now we do know there's some acknowledgments of behavior, which I believe are abuse by Doug from years before. But let me ask you this. How many times, or tell me, have you heard of it ever happening that someone went to report abuse to the police and the bruises weren't fresh enough, or there wasn't enough evidence to show? Have you ever heard of this going on where someone goes to the police and they're like, it just didn't meet the threshold, right? So it happened, and you might know the person, you're like, yeah, it definitely happened, but you waited 2 weeks and the bruises had faded, and now there was nothing to photograph. Yeah. Could that also be a possibility? I have to say, for that reason, the fact that the previous courts didn't find anything in their investigation might mean that she might have just a much lower threshold on what she accepts as abuse than a lot of other women who have put up with a lot of terrible stuff. And if she, the first time something happens, goes to the police, and the police are like, this, normally we see, black eyes, there should be a cuts, there should be some evidence, and you've come to us before that has happened. And so there's nothing here. I'm not sure. I have to go back and listen to some of those hearings to hear about, what was the no scintilla of evidence being there. But I'm in a terrible spot. I don't know how to decide one way or another as to whether or not she did experience what she said there was. With that, we just went over 3 hours.
I'm with you on that. I think, I think my experience is more on, because I'm a child therapist, my experience is more on filing reports or parents filing reports. In particular, during custody cases, the investigators almost always just go, this is too complicated. We can't really know what happened. I'm just going to write it off as unfounded because, some of these parents might be ill-motivated. Yeah. So when you file an abuse report, when there's an existing custody battle, investigators are in a difficult position and often just kind of go, well, we can't really know.
Yeah.
So I definitely hear you that just because, like, how do they say, proof or absence of proof is not proof of absence.
Yeah.
Right? So it doesn't mean she didn't experience intimidation or
other forms of
things
abuse
that we would definitely deem problematic.
Yeah.
Mm-hmm. Yeah. Right. At the same time, I want to, if someone makes one or two mistakes, that's not also exactly the same thing as a pattern of abuse that would lend itself toward imminent fear for your life, So I don't know. I don't know how to parse it out either. I agree that there were some problematic behaviors on both sides, and either way, I think it comes down to the state didn't carry their burden.
Yeah.
Personally,
I agree. Deanne B, I'm not saying that's the way it should be. I'm just saying that there have been cases that I'm familiar with of somebody reporting abuse,
of course, yeah.
and because the bruises were not fresh enough, that it basically meant that it didn't happen. As far from a legal standpoint, there was nothing they could do because the evidence wasn't close enough in time to the occurrence. I'm not saying that's that's the case. There don't need to be bruises, and that's what I said earlier. When how many times does a woman have to fear for her life in order to defend herself with deadly force? And I would say one, the first time. It doesn't. You don't have to have a pattern of being afraid for your life and surviving by luck or skill or the grace of your abuser before you actually defend yourself. I'd say the first time, and that could have been the case here with Ashley. And for that reason, I'm still leaning not guilty strongly. All right.
Yeah, and I really appreciated the point you made earlier, just that, if someone fires a gun into the ceiling, if it were a police officer they were speaking to, that police officer is probably justified to use lethal force. And so I appreciated that perspective too. So.
Great. Thank you very much. Thanks for the kind words. Appreciate the call. And tell me your name one more time. Kaylee Rose, right?
Yeah,
Kaylee with the
me.
Rose. Okay. All right. Thank you, Kaylee. I appreciate the call. Good talking to you.
Thanks, Scott. Have a great night.
You too. Bye. 3 hours in. We don't know if the jury has got food yet. If anyone sees on Twitter, there are a couple eyes in the courtroom as far as this goes that might be updating us.
Call from Media Done Right.
Hello, Media. How are you doing?
That's my company name. Sorry.
It's all right. A free promo, What can we do for you?
Well, that's what my husband said last time I called in. It said it's in our company name. I don't know why, because this isn't my personal number.
I think it must be something with Google that knows this number is attached that way and just announces you that way. But
yay, my company name.
Give me your name again.
It's Camille.
Camille. Okay. Camille, do you want to talk about food or the court case or both?
Well, I want to talk about the court case. In response to the woman called just prior to this, we talked to someone who are DV survivors, and I'm a 28-year survivor. I unfortunately am very fluent in this. And I'm in Hillsborough County, which is one county over from Sarasota County, and unfortunately I have the claim to fame of having the longest restraining order in Hillsborough County, 28 years, 1 year for every year I've been stalked by my abuser, who went to prison for 8 years, and apparently that wasn't long enough for him to get it. Wow. He came out and said, let's just keep on going with it, all right? That wasn't long enough. So, I have a plethora of knowledge because I went back immediately to get another restraining order and started seeing what I would call the Amber Heard effect, all right? Women going to get these restraining orders, taking selfies of themselves, like, oh, I hear I'm getting this. I'm going to really show him. I'm going to show my boyfriend. I'm going to show my husband. And then going before a judge who now is making basically a mockery of the system. I'm not going to give you a restraining order, Camille, whose ex-husband, went to prison for 8 years for such extensive battery that my jaw was wired together for 6 months. And broken ribs, and I was in a shelter
trying to not be found, definitely not inviting anyone into my home, because you have this effect where judges don't believe women because they're now led to believe the opposite of believe all women. It's don't believe them. And I think that's where we're getting to the point now, is where you have these cases where it just doesn't make sense. And yes, every DV person has a different story. Correct, but there is a book on this.
Let me ask you this, because I very much believe that, I would say not just believe women, but when somebody comes to you and says, I'm being treated wrong in any type of scenario, whether it's with a child, whether it's a friend talking about their spouse, and it can be multiple, either gender. It doesn't matter. It's not specific just to one gender. I believe they should be believed on the face value. That doesn't mean, in my opinion, that doesn't mean that the other person should be thrown in jail. But I think at the minimum, a restrainer or some level of protection should exist. Because if I were the abuser, I don't have the right to be around somebody. Okay, I don't have the right to follow them around. That's not a right that I have. I'm not losing that, but I think there should be the willingness to give out to those restraining orders. Should be a little easier to achieve. Now it gets problematic.
What was very confusing to me was that in the state of Florida and in almost every county that I know, to Sarasota, because I had worked with some, and until it got too depressing, because a lot of these women just go right back to their abusers. Financial reason, not even that, they just go, they don't know any better. And it was just too depressing to see. You can get a temporary restraining order by just walking to the courthouse and saying, I've had two situations where I was physically abused, I was stalked, and here's the evidence. It goes before a temporary judge. He reviews it, she reviews it, and then a temporary injunction is issued. And then 2.5 weeks later, you go before a regular judge, and they determine if they're going to make it a permanent one. I don't understand. I'm racking my brains to figure out how she could not even get a temporary injunction. That's where this all started to cave for me, is that how did she get rejected for a temporary injunction? Because they hand them out like chiclets. They just literally do.
I don't know. I really don't know.
And so that's when it started to not make sense to me. And then, yes, she has a child, and I've heard people say she had to maintain French. She had a supervised visitation. Someone had to supervise the visitation. So she never had to fear for her child because a third party was there to monitor his visitation with the child. She basically poo-pooed that. She said, no, nobody needs to supervise it. That made no sense to me because, like I said, there's a standard in DV. It's protect yourself, protect your child. Protect yourself, protect your child. That's all it is all about. Get to a safe place, get your child to a safe place, protect yourself, protect your child. Yeah. And it seems like she blew all that off.
Yeah. This is a topic that first of all, Camilla, let me say this. It breaks my heart to hear what you went through. And I'm sorry you went through that. That is terrible. I appreciate you being able to share that and share your experience here with us today. And thank you very much for doing that.
I'll tell people, some people get destroyed by it and some people grow from it. And for me, I grew from it. Okay. Because I knew what I would never stand for again. And I can say there are people that will grow from it or it will destroy them. And so that's what I take from most DV people when I talk to them. It's like, I would not be where I am today. I had 2 sons at the time, still 2 sons, by the way. And you know what? They are in loving, wonderful relationships, and they know exactly how they need to treat their wife because they learned how they should not treat their wife from their father.
I believe that's, I think that's important. Family's always been important to me. And I think that you should learn in the home these sort of things. The government's not going to teach us how to be nice to each other. There's
unfortunately not.
government has its role. Generally, I think it belongs in national defense, and it's got some other areas. But really, I think some of these things need to be taught in the home, and we need to teach them to our kids. And that's where we start is teach our kids that this is what's right, this is what's wrong, this is how you'll show people respect. Just some basics like that, and unfortunately, that's missing in a lot of society, and we're seeing the results of that. But Camille,
And the positive is I met the most wonderful husband in the world.
That's wonderful.
I feel safe and loved, and 15 years in, I know now that I wish I hadn't wasted 13 years out.
Oh man, I'm glad you found him. That is wonderful, Camille. Thank you very much for sharing. Thanks for the
And
calls.
by the way, I love your program. You make my workday white noise great.
Well, wonderful. It makes my workday go fast too as well. We're already at 7 p.m.
Absolutely.
Good grief.
I know, it's crazy.
No wonder I'm
home.
hungry. No wonder I'm hungry.
Go home.
Thank you, Camille.
so much.
We'll see you.
All right.
Bye-bye.
Bye.
All right. I don't know how late the judge is going to let this go. I thought for sure they'd be going home by now. We're 3 hours into deliberation. Can we have a look at the thumbnail? Let's see. Let me pull it up here. If I can find it. There we go. There's our thumbnail. Got bags of sand. Holy cow. There's so much on here I don't even know. I'm going to have to look at this in just a second. Hang on one second. Let's see who's calling.
Call from
Bree.
Bree, it's been a bit since you called. How are you doing?
I know. How are you guys?
I'm doing fabulous.
So, something that kind of threw me, so I'm trying to use GPS. I have to have you on speaker so I can see where I'm going. But anyway, something that threw me is my best friend, her sister. They were best friends growing up. Her husband, he didn't physically hit her, but he would take aggressive behaviors, let's say in the bedroom and stuff like this. This is, you are my wife. This is what you're going to do type of thing. And they had children together, and he would say, I would hurt these kids, and, whatever. So she finally got, a restraining order filed. She had never physically been beat, but she got a restraining order. The police didn't feel like it was strong enough, so they let him go out of jail. Didn't notify her like they were supposed to, and he went and shot her and killed her. Unalived her. Sorry, wrong word on YouTube.
Wow.
Wrong word on YouTube.
It's all right.
Sorry.
It is what it is.
So my thing is that I almost wondered, though, everybody's like, well, they said he didn't hit her and all that. Well, sometimes that doesn't matter. But at the same time, they made a big thing, and the prosecutor made a big thing. Well, even after he put a bullet in the hole in the ceiling and all that, she still went and had a baby with him. So maybe like I said, maybe I'm reading too much just because of the background that I know and that I have with my friends and whatever, is she seemed to have shut down really bad right there. So, what if we don't know? What if it was not something that was maybe let's say a consensual act? Because she said it was the furthest thing from her mind. So what if she was still in that protective mode of trying to protect him, and this is where she got her baby from, and that's the most important thing to her? So it opened that thought to me, but I don't know, because like I said, it was never brought up. But just the way she shut down, and knowing my friend's friend, it really brought back that feeling of how my friend's friends really felt a lot about the thing.
Yeah, I don't know. And I don't think some of this, we'll never get answers to a lot of this.
Right.
But the fact that there are possibilities, and there are reasonable possibilities for what's going on here. There, so many people like yourself are calling and saying, hey, what about this experience that somebody has had that I know of? This is a reasonable situation, very similar to this. Isn't that reasonable doubt? That's what I'm saying. Isn't that reasonable doubt?
And my whole thing today was, like I said, I believe her. And to me, though, it doesn't matter if you did or didn't or whatever. The one thing that was the worst thing to me was I just got aggressive and victim blaming from the prosecutor all day. Like, well, this is what she did. And I'm just like, it doesn't matter if you believe it or not. Have a little bit of compassion, because none of us were there, and none of us know what she felt in that moment. Maybe people don't feel like she should have used justifiable force, but if she felt that in that moment, who are we to know? And just listening to that prosecutor today, it was almost like nails on chalkboard. I was just like, I had to turn her off at one point in time.
I know a lot of us might have opinions. We might listen to that and say, I don't think she's being truthful, or my experience would say that she would be doing something different if that were the case. But her testimony, the words that she testified on stand, that is the evidence. Nothing else is. Just her testimony. The fact that nothing she said was refuted, she was not impeached on anything. I think by the definition of the jury instructions, I think I would have to be not guilty on that.
Yeah. And her story didn't change. And you'll see a lot of people that get up on stand, and the minute they get under pressure from the other side, they buckle. Their story doesn't match. Her story didn't change. And then the fact that there was text messages from him that was saying, yes, I did this, and yes, I did that, and, X, Y, and Z.
That was a court admission.
The fact that there was some of that stuff that actually made sense and matched some of the other stuff is just like, even if it's not as aggressive as what somebody else would think, well, I don't feel like what she witnessed was enough. We don't know what was enough for her.
The only caveat to that, I'll say, is that the terminology, and the state hammered on this in their closing argument very, very deliberately, was those two words, and was that reasonable and that necessary. Those two words, that might come back to bite her, especially if, that she didn't. I mean, there are a lot of people saying, there was no evidence of abuse. And I realize, abuse can happen in more ways than just physical, but there was no evidence. In this case, she had to be worried about grievous bodily harm or death, basically serious bodily harm or death. Without prior evidence, that might be an uphill battle for the jury. But
yeah. It's just, look, I always felt bad for Karen Reed's jury because, and they had a case that you would think was, whatever. And this is, do they think that she felt that way? And it's like you had to put yourself in her head and you don't know. And, if you feel like you make a wrong decision, it's somebody's life. And I do not envy any of these jurors at all.
Not cool. I mean, I'd love to serve on a jury, just not this case. So,
yeah,
Bree,
exactly.
Thank you very much. I appreciate the call. Good to hear from you again.
All right. Talk to you guys later. Bye,
We'll see you. Bye. Gwen, welcome to the gallery. Good to have you here, Gwen. Thank you very much. Corey, I've seen this message a lot. Let me share this. Saying, too bad Doug couldn't get a chance to get up and testify. That trial was days away, but she took away his voice unnecessarily. And that's true. We only get one side of this. Amber?
Yes.
Hey. You're the only one that, for some reason, you get right through. I don't know why you've got like VIP privileges to my phone.
I didn't even call my super secret line.
I know. You called the burner phone and it doesn't screen your call. It's like, oh, she's good. But
not sure how we figured that out, but whatever. I'll take it. I just thought I'd call and see if we could lighten the mood just a little.
Yeah, this is heavy. Yeah.
And see if we've caught up any on what's happening in Young Thug, because it's been entertaining.
Young Thug, let me tell you what I know, and you can fill in the blanks. The new judge has basically laid down the law and said, this is the way it's going to go forward. She's denied motions for mistrial. She's denied Mr. Steele's ability to cross-examine the judge as a witness, or like to call him as a witness and interrogate him and things like that. She's really saying nope to a lot of them and trying to rein this in. What have you seen? I think they are going to be allowed to talk to the guy who was in the ex parte meeting, talk to him about the ex parte meeting a little bit, but not everything they wanted for sure.
This judge is not taking any crap of any kind. And what made me even make this call and suggest such a lighthearted and comical moment is because she is in such contrast with Judge Blanville. I can't help
It's
but
night
laugh.
and day difference. Night and day.
She just told ADA Love, I don't know if she's ADA, told her that she needed to take her candor with the court more seriously. And there was a little bit of snark back. So we have some very rarely seen moments still happening with the new judge.
Wow. This is going to be, if this trial goes to the end, it's going to be amazing. It's going to be a miracle. But it sounds like this judge might be the right one to get further along in the process. Assuming we don't lose the DAs halfway through.
I think so. I think a lot of the theater in that case is going to be
its downfall.
Incredibly limited at this point with this judge, because there's been so much animation between the lawyers on both sides that Glanville let slide, and she's not having any of it.
She's got to keep a tight rein on that, because they will go right back to that if allowed. I mean, we saw that in let's see what case, the Rust case. The Rust judge, she starts out, she's like, I'm going to lay down the law, and then she let it slide. Mm-hmm. And it's hard to claw that back and get control again. They can. We've seen it happen before, but it's hard. I mean, if she can lay down the law and maintain that strictly, I think it will be much more effective.
Absolutely. And we still have quite a bit left to go to see what she's going to do, because the jury hasn't been brought back yet. So once trials restart,
this poor jury. What are you doing for the next 2 years of your life? Is it all right if you serve? Will you be available to serve on the jury for the next 2 years?
Yeah, it's nuts, but it's just the process that you never get to see. Yeah. It's not necessarily the case itself. It's just how the actual judicial process is actually working, and how things are so different between people within the same unit.
Yeah. It's fun to take a break on this. I think we're not quite done talking with about Ashley Benefield in the trial, so we're going to go back to that a little.
I just wanted to laugh about something for a minute.
But the one thing that's unique, I love watching trials with strong personalities. Whether it's the defendant, whether it's the judge, whether it's the prosecution or defense, I love it. In Ashley Benefield, we got that. We got a very strong prosecution, a lot of attitude and sass throughout the trial. We got a judge with a distinct personality as well, but also extremely fair. Oh my goodness, I love this judge. If I could clone him for other cases, I'd love it. I do wish that he wasn't quite so strict on the lawyers just need to know what I expect right now, and then if it doesn't happen, they miss their chance. I wanted some of that. The juicy part. I wanted witnesses to be called during the hearings and things like that we didn't get because of that. But I love that. Young Thug, obviously, you've got a whole bunch of lawyers and a lot of personality in one room, and it's just going off the rails. But Amber, thanks for the little lighthearted break there. What are your predictions on deliberation? Do you think the jury's going home tonight? Or are we in for a long night?
I think they're going to go home, but I think it's going to end hung. I think you're going to have a hung case here.
Yeah.
Just my prediction, and I'm not going to give.
We've had too many
opinions either way.
We've had too many hung trials, hung cases so far. The hung jury is just. We've had a spate of them recently. I'm not ready for another one. I'm ready for a verdict one way or another.
I think a lot of these hung juries teeter along the same kind of topic, or realm, should we say. And I think a lot of these hung verdicts, these hung juries are going to hopefully make some things happen in the right direction for understanding and making laws for things that don't exist, and protecting for certain things that are not protected right now. So I'm hoping it actually gets through to the greater issue is all I'll say.
One more thing. You mentioned you added something to the upcoming cases spreadsheet. What upcoming cases? We've got tomorrow, we've got the Bad Apple River trial with Nikolai Mew. That's the sentencing for him. What is coming up that you're interested in? Is it like Robert Tellis? We've got.
Well, I've been asked to try and help with what's going on with Robert Tellis, because it seems like, and it's something I noticed with the Benefield case. her criminal case listing on the docket is gone. You can't pull it up. And I still haven't figured out why, but now the same thing applies to the Robert Tellez case, where the criminal case is not coming up. It's not populating anymore when you go to search the docket, and it would populate before. And I have a feeling, because there's an appellate case for Ashley Benefield already pending, and I don't remember when the criminal case was went off the docket for accessibility. I don't know what the correlation is, but it seems to me the Robert Tellez stuff went sealed, it seems, after the federal lawsuits against him. I think there were 4. So I can't even pull the docket on that case.
Treehouse murder trial I'm showing is still for 9/6 of 2024 as a start date for that one. So that one's coming up.
Well, that's not the start date. That's the next
is that the hearing? That's the final. I thought it was like the final pretrial hearing or something. I thought it was coming up sooner than that.
I'll double check, but
other things coming up on the
October.
9th. On the 9th of next month, we have the hearing for Karen Reed regarding the hearing the oral arguments. The judge won't make any decisions on that, but oral arguments, we'll probably hear a lot about the jury on that one. That's going to be interesting. That's coming up here in about a little over a week. Let's see. We've got Master Eden's possible trial in Bexar County.
We've got some cases that we've actually not covered that happened all at the same time as we were covering other things, and we had to pick between what cases. I found so many other cases that were going on along at the same time that were super interesting cases. Maybe we can use those as filler when we need to, but those were some pretty interesting cases too.
Yep. And then Corey Richens, I'm going to be there. I don't even know what the date is. I think it's the 8th or the 9th. I think it's Thursday or Friday. I'm not sure which day it is. Corey Richens has a hearing. I'm not sure if that's going to be a long one or a short one. And then we also have a 3-day hearing in the end of August. I'll also be there for that one for Corey Richens, which is going to be that one. That case is nuts. If you haven't followed that one, oh my goodness, another KR case. Says Corina. Yes, it's another KR, different KR. We've had a couple ABs too, right? Alec Baldwin, Ashley Benefield. We get these same letters that are used over and over. Teddy Bear, we've had one jury question so far. The jury's deliberated for over 3 hours. I've got 3.5. I'm about 15 minutes ahead of some of the other timers out there, but there was a Robert Tellez pretrial this morning, 8:30. Didn't see that.
Yeah, but I can't pull it on the court docket. I am gonna insert a suggestion here, and I'm not sure. There's been so many pieces and parts to this particular case that I don't know if we want to cover it at this point, but I think it would be absolutely incredible if we did. The Donald Adelson case.
Donna Adelson. I'm having a food seizure, a food coma in my head, anti-food coma or something. Give me the lowdown on her again. What's the charges?
The FSU professor that was killed, married to Donald Adelson, who was also another FSU professor.
Okay.
It's ringing a bell yet?
Yes, possibly.
There's been Sigfredo Garcia and the other guy. They've already been convicted. Catherine McBanawa has already been convicted after 2 trials. And she's appealing and may actually be cooperating.
Ooh, in Donna's case?
Yeah. Charlie Adelson.
Hang on, appealing and cooperating?
Yeah.
That seems like a funny mix. It's like,
it does.
I got convicted and I'm appealing that, but I'll cooperate with it. maybe if she wins her appeal and then cooperates and gets retried, then she gets a lighter sentence. Is that what she's going for?
I don't want to give too many details into that if we're going to look into the Donaldson case, simply because you are brand new, essentially, to that case.
I have been keeping a distance from that one. I haven't been looking into anything.
Right. So I think covering Donna. So the two hitmen and pardon me if I get details like blended somewhere because it's been forever since I dug into everything. But the two hitmen and the coordinator link between the hitmen and the Adelson family, which was Catherine McBanoa, they have already been convicted and they're doing time. Charlie Adelson just went on trial and was convicted and sentenced and all of that last year in connection with the murder. And now they're going out, and Charlie Adelson is the professor's brother-in-law that was killed.
This sounds like it's going to need a Brandy chart just to understand the players and their connections to each other.
Well, the good thing is there's already one in existence because Brandy actually covered Charlie's case, and she was actually at the trial for Charlie's case.
Yeah, crazy.
So
this sounds. Remember, wasn't there like a family up in Ohio or something, where the two families were sort of at war with each other, and the one like came in during the night and killed everybody, and so it sounds like one of these things where the whole families are involved against each other.
Yeah, it's really wild when it comes to family involved stuff. It gets really crazy, but the rabbit hole gets deeper and deeper, and the caves just get.
There are so many branches and so many. Yeah,
it's just the rabbit holes that I have fallen into when searching these cases that deal with families. I mean, it's insanity. But this is the mother-in-law of the deceased, and I don't say that to be insensitive. So Donald Adelson is the mother-in-law to the deceased, and I'm wondering, there's still speculation on if they're going to go after Donna Adelson, who is the deceased wife, soon-to-be ex-wife. I forget if they finalized the divorce. I think they did. So there's more players coming too, I think. So it's a wild case.
Yeah, we might have to take a look at that. Obviously, we do choose cases. We try to choose cases that are interesting, that are available, that we can get access to, and that work with our schedule, because we can only show one, maybe two cases at a time, depending on if we're running both channels at the same time. But man.
Yep, and that one's in Florida too. So
yes, yay for Florida!
Of course, we have access.
Florida's pretty good. Once our website's finalized, Amber, I've got a really slow web designer. No, just kidding, Amber. You're doing a great job.
Well,
thank you so much.
Well, wait a minute. I have like a slow responding boss. So.
Yeah, I ask your question again and I'll respond. Thank you, Amber. I'm going to let you go. I've got a couple other people who are trying to call in. But we might cover the Adelson Donna's one, and I realize we're coming in late on that, but we'll see what happens schedule wise.
Alrighty, Melissa Webb said read her comment, so I've got to go find her comment. But I'm going to hang up for now. So
Melissa Webb is lucky nobody stole her seat. Okay. Oh no, that's Melissa P. All right. Thank you very much. We'll see Melissa Webb's comment.
And somebody just emailed you another doc, and my kids are now going crazy, so I'm gonna.
All right. Kids first. Kids first. Thank you, Amber. Appreciate you.
Okay. Bye.
Bye.
Call from
Jessica.
Hey, Jessica. How are you doing?
Hey, how you doing? Hi, chat. Hi, Amber.
we just hung up on Amber. It's all you now.
I'm sorry. I've been waiting because everybody has had such great comments. I didn't want to interrupt their comments and stuff. So apologies. So I have a trial that might be a good filler just while we're waiting. If we wait a little bit longer in the morning, okay. The Massachusetts versus Christine Ricci. She's accused of fatally stabbing her Boston firefighter husband.
Ooh.
Yeah. It's just started.
Ricci?
It just started this week. Yeah, Ricci, RICCI. It's on Court TV. When I was waiting for lunch break, because I'm three hours behind you, I was watching some of it on
on the computer.
Wife stabs husband murder trial. Assault and battery with a dangerous weapon. January 21st, January of 2021. It's got mistresses involved. Sounds juicy. We'll have to look at it.
I just find that it might be just a real quick trial.
Is it going to be like a 3-day, like a 3-day trial type thing?
I don't know. I just kind of saw it on their website and decided to watch a little bit of it while you guys were at lunch.
Was Proctor involved?
You know what? Let's hope not. If they have any kind of confidence in their crime solving skills, wow. I don't know. Anyway, food. Yes. I made homemade cheesesteaks last night.
Ooh, so, cheesesteak.
Yes, very, very good. Very fattening, but very good. I did not care.
We had those. What are those flat noodles called that have like cheese and spinach inside? I think it's spinach. It's something green. It's like a ravioli, but there's no meat inside. So you use spaghetti sauce and these little tortellini.
Those are very good.
I think that's what we had. It was pretty good.
Probably. Yeah, I'm a big fan of pasta. Pasta.
Oh man,
it's my lifestyle.
I'm too big a fan of pasta. I need to be a smaller fan of pasta.
Same. I just had one comment about. I have a couple of comments, but I'll keep it brief because I know that you probably have other people who want to chime in. So, I'm voting not guilty, and I can kind of see both sides of people's concerns about maybe she lured him, and whether or not, she was making stuff up and taking the law into her own hands and stuff like that. And here's what I'll say. This is an observation. Like, wasn't her father a naval aviator as well? And then she ended up marrying a naval aviator. It's 30 years older than her.
I don't recall. Some people are saying yes. I don't recall. I know this was, I think this was Ashley's second marriage, right? It was both, I think both of them had been married previously.
Right. Now, being in the military myself, I can tell you, not just Navy, just in general, like the structure that it takes to be successful in the military, at least in my experience. I don't know. I've been out for quite some time, so I don't know if things have changed, but the kind of the focus is, you're told where to go, what to wear, what to do when you're done. You're given very strict parameters. And in some cases, it's really great because, people who need structure, that they thrive in those environments. And then when they're not in that environment, oftentimes they use the control because most oftentimes it's anxiety that forms control. It's not having control over something, so you obsess over it.
You look for something that you can control.
Right. That's one kind of personality type. And I'm not suggesting for a second that I know his psychology at all. And I'm not saying he deserved it at all.
Right.
I'm just saying that when you exhibit terroristic kind of behavior, she knows the man is a martial artist. She knows he was in the military. She knows he has weapons and uses them. He's already exhibited violence by shooting the ceiling, by throwing a gun at her, by punching a wall, by hurting animals. Even if he didn't touch one hair on her head, it doesn't matter. He's effectively setting a scene of terror. And I'm not trying to say or blame the victim at all. I'm saying that what the real true question is what her feeling was at the time. Irrespective of whether or not he was standing a certain way.
Yeah.
But I can tell you that if he was a machismo type of man, which, some testimony was provided that he was, if he was confronted by a girl, his wife, who he's not probably thought of as being very strong with a weapon, that fighting stance would be probably almost an automatic kind of reflex. I think he was shot by trying to kick the gun out of her arm. That's what I think, where he got shot in the leg.
Oh, wow.
Because
he was thought of that.
Because that would have been like, it would happen so fast. Like, I mean, I pulled the trigger on a 45 many times. And with hollow points, yes. And as some people were really upset about her choice of hollow points, but if you're carrying a personal weapon, you're going to have all the tools at your disposal. Yeah. Okay, you're going to do what you need to.
As someone who's carried a concealed weapon and at the request of police, and who suggested, I even had a police department that provided a letter that let me to bypass the state restriction on the delay and got me to the front of the line to get my permit because I needed it for protection for a case I was involved in. They recommend hollow points. That is the recommended round to use. It's actually safer to shoot hollow points. Not for the person you're shooting. Okay, it's going to do more damage to the person you're shooting, but that's what they're intended to do. So,
on a side note, one of these days I'll chat with you offline about it. But I had a really good friend who actually manufactured ammunition that was designed to be home defense weapons that would penetrate a tin can. It would penetrate the tin can and it would dispose of itself. It would actually crumble, so it wouldn't go through walls. So like if you were carrying in your home, it wouldn't penetrate, the drywall. So
but it still had stopping power?
Yes. Unfortunately, he passed away, but he was out of Olympia, Washington. He's a really nice guy. Really, really fun to talk to. At any rate, my point is that I don't...
And then sell it.
I know, right? I'm sure you can Google it. It's been so long. Anyway, I think that for me personally, I think that the prosecutors went a little too hard on the if she wasn't hit, it wasn't abuse kind of situation. It's like, well, if she didn't wear that short skirt, she wouldn't have been, or that kind of thinking is very off-putting.
Yeah,
and then also, I
was thinking about that. I would think that's a risky argument to make, where you've got a lot of women, and statistically, one of the women on the jury has, or possibly two of the women of the jury, have experienced some form of abuse. If you look at the stats, but the flip side of that is, during voir dire, they ask the jury all sorts of questions, probably about this, and they might have a jury that has nobody who admits they've experienced this. Just they might not have anyone on the jury who's been in a domestic violence situation.
And if I was on that jury, I would already say that it would be difficult for me to be unbiased, because I was the child of domestic violence, not on myself, but I experienced it. So I knew that I would know that I couldn't probably be impartial as far as like looking at both sides. The facts I could do for sure, but like it would be difficult for me to really knuckle down. But at any rate, but I do think that her defense team did, a pretty good job closing up. The one thing that I really wish he would have maybe, and I don't know the rules of evidence and stuff at closing, so it could be that he may not have been able to answer it, but one of the things that I feel like he should have maybe said is, put yourself in, not put yourself in her position, because I know he got in trouble for that. But I wish he would have like really, really went all in on the building up, of the tracker. It's tenuous. She's scared. She's about to lose custody, and maybe not lose custody, but she knows that he's getting angrier by bumping her, by checking her. Then he hits her in the face. Just build that up, and like make the jury like sit there and feel that what's going to happen next feeling.
Yeah.
And then say,
Ashley did a better job during testimony describing that build up of the disagreements they were having about. I mean, it started with the fact that that he was loading the luggage wrong. She's like, "Look, we're going separate places. We're dropping my stuff off at my place, and you're going to your place, and you're mixing all of it in together, and that's not going to work." And that, I believe, that was the start of what she was describing, what happened, and it just possibly escalated from there. But the defense attorney didn't even mention that at all. It was just like, it happened.
That's my only criticism of his closing, that I really felt like he could have been a little bit more, clear on. And then the one last thing that I'll say is this. My mother strongest woman I've ever met in my life. She made some poor choices in some husbands, and she was a victim of domestic violence. But I'll tell you what, she gave it as much as she got sometimes when she had to. Like if she was being hurt, she would, you know what I mean? She'd stand up for herself. Does that mean that she's any less of a victim or that she deserved it? You know what I mean? Like, so Ashley has, you know, a support system, or maybe she's not afraid to stand up. And then the other thing too is that I think that her actions were pretty despicable for a custody situation. I think she was acting ugly, like a lot of us do, but I don't think she was setting him up for murder. And that's the last thing I'll say.
Interesting. Thanks for sharing. I appreciate the call.
Of course.
And call again anytime. Now it's time to eat, right?
Yeah.
Okay. All right. Thank you so much. Appreciate it. Bye.
Uh-huh.
All right. Here's what we're gonna do. Every time I kill the live stream, they come back with a verdict. We're approaching 8 o'clock. I don't know how late they're gonna go, but I don't think they're going to have a verdict tonight. So what we're going to do is we're going to wrap up tonight, and I think they're getting dinner and then going home is what they're doing. It's like as soon as dinner arrives, we're going to go home. Donnie's like, "Stay on." Yeah, I reserve the right to revisit my decision, Donnie, and we're going to kill the live stream, yes, and then they're going to immediately announce a verdict, and I'll just be sitting here ready to be like, boom, and we're back with the verdict. So that'll be how it is. Don't kill the stream, but go eat. I can't. It would just be you looking at my office. I'm not supposed to eat after 8 p.m. So I have got 20 minutes to go do some food. It's only 4:30. Tell you what, let me give you a song. Let me go ask my wife what the plans are, and you guys can listen to a little bit of music just briefly if I can find it. There we go. And I'll be right back.
Not a camel.
Shame on you, sir.
If they didn't, I would lose my mind.
When are we going to break for lunch, Judge? Are we going to address subject matter jurisdiction?
I think I'm about to catch a whooping.
I was kicked back, taking it easy.
I saw a chicken fight.
The zombie apocalypse may be upon us. This is not Burger King. People do not get to have it their way.
Because he's the guy.
Sent me a video of roaches fighting. I don't know who won.
When are we going to break for lunch, Judge?
I'm not a cat.
The zombie apocalypse may be upon us.
I'm not a camel.
Have them send someone with more experience. Subject matter jurisdiction.
I think I'm about to catch a whooping.
There's a lawsuit.
You're talking about stuff that is not relevant.
The zombie apocalypse may be upon us.
Because he's the guy.
So, my wife, I don't know where she is. There's nobody in the house. I'm like all by myself. But there was a plate. On the plate was one tilapia fillet. There's some brown rice, still warm in the fridge. And I ate it really quickly. I devoured it. I nearly inhaled it. So there we go. I had a little tilapia fillet. That was dinner. I'm good. I got it done before 8 o'clock. RA is home alone. I am. They probably went out to dinner. I think they're eating pizza right now. It was a small tilapia fillet, and it was. I love tilapia. I will say, tilapia on its own tastes awful. Tilapia has no flavor. It's a great fish to go with any other food that tastes good. Oh, no. Tilapia, no bones. We have no bones in our tilapia. 0. Like eating toilet paper. I wouldn't use the toilet paper. I'd say paper towels is a more visual that I'd go with. But yeah. Float my fish in malt vinegar. That is the proper way to do it. Mrs. R.A. is not a big fan of malt vinegar. She's not a big fan of the smell of malt vinegar. I grew up eating fish and fries with malt vinegar, not ketchup, just the vinegar. Then when I went to England, of course, that confirmed my long-standing belief that was the proper way to do it. And then I got married, and none of my family likes malt vinegar. It's terrible. Let's see. You like quail? What's quail? Like quail? Is there missing an I in there, or just quail something? I thought tilapia was a myth. I actually raised tilapia, Bob. Fun fact: I had a aquaponics greenhouse where I raised tilapia.
Call from
Amanda.
Amanda, this is RA.
Hey, RA.
Happier RA, who has a little bit of food in his belly.
Happier? Okay.
How are you doing?
Good, because I didn't want to have to tell you that I made chicken spaghetti and it was amazing. But
yeah, don't do that.
I would never do that. I would never. But no, I'm calling mainly about the case because, I spoke to you earlier, or I guess it was last week, about kind of everything. I think we're going to have a hung jury. I really do, because I don't think either side proved 100%. I just that feeling. I hope for her sake that if she truly was a victim of DV, that they don't retry her, because that's a lot to go through again. But I think with these two prosecutors, they're so gung-ho, I think they'll go for it again if it goes to a mistrial.
Wow. That would be huge. I don't know.
And I think both prosecution and defense probably learned a lot of things from this first one, that if they do go to a new trial, the DNA will be brought in, a bunch of additional stuff will be brought in.
I think the DNA should be brought in. I think that's very important. I think it goes to support Ashley's claim, even though there are other explanations. It is supporting evidence to her claim that was not brought in. That just astounded me. Obviously, defense will call those experts if they have to, but
yeah, and I think they both sides learned a lot on this first go round. I hope for her sake that it doesn't come down to that. If she is truly a victim, that heartstring, that mama, that empathetic person I am. I hope she's lying because I don't want anybody else to have to go through that. But seeing the emotions, the trembling, the body shaking like it is, that's not like she was. That's not just a normal, you can make yourself tremble like that and feel, I could feel it for her, and I guess that's the empathetic person in me. People are talking about the tears and stuff, as a victim, when I'm triggered, whether it was, I go through bouts, I've been raped, another situation, but in a DV case, bunch of things that's happened in my life, and I have different triggers and different things trigger me. I may not break down and be crying. I may, what I call sob, but not have tears. But that tremble, I've been there, I've seen it, I felt that tremble. And as she was trembling, talking about it, I just don't see that she could fake that unless she's like, give her, an Academy Award because she's best actress in the world. There was just something about that tremble to me that was so real.
I have a hard time talking about her manipulating Doug. That can happen, very much so. It's harder for me to believe that was happening when you look at, there's a 30-year age difference between the two. I mean, Doug is not some young kid new in love.
Exactly.
He's been in a marriage before. He's lived life. Okay, 50 years old. He's older than I am.
He wanted that arm candy. He wanted the arm candy.
I can't say that's what it is, but
I just feel it. He wanted that arm candy. I mean, he's an older man. He's getting up there. He sees this 3-year-old young lady that's interested. So hey, she's going to make me look good. And again, going back to the DV, we don't know who coerced who or who brought up the subject of the vasectomy reversal and having another baby and all that. He very well could have manipulated her into doing that so he could try to keep her there by getting her pregnant. There's just so many unanswered what ifs it could have been, that I just don't see how a jury can go straight for either a conviction or guilty or innocent. There we go. That's the one I'm looking for.
Yeah.
So I don't think we're getting a verdict tonight. I don't think we'll get it till at least after lunch tomorrow. There's just too much.
Well, I by my count, we're just past the 4-hour mark. So now,
I don't think we'll go as long as Karen Reed.
About 40% of us are wrong so far in this deliberation.
I went for the 4 to 8, so I feel like it's going to be closer towards the 8.
Now I'm feeling I should have probably put it in 1 day, 2 day, 3 days instead of 1 hour, 2 hours, 4 hours.
Right. And something that, I can't remember who it was that talked about, y'all made the comment about whether some victims could be on the jury, and it was probably a question during the voir dire process. But, there's the cases, and I'm thinking of it this way. Some of those women may not even realize they were a victim of DV until they heard some of this stuff about the verbal abuse, because a lot of people don't consider name-calling and stuff like that as abuse.
I mentioned that a little bit. I thought the Duluth wheel, as he's spelling out all the different types, I think this might resonate with people. There might be people on the jury who's like, really? Oh my goodness! There's my life on the wheel. This is what I went through. So we'll see. I think that's probably why the defense tried to discredit that wheel and sort of they almost mocked it in a way in their closing. But I think they pushed too hard in that area on sort of even mocking and making fun of. I mean, at one point they were like, "Oh," she was like, "Yeah," did some sort of sound effect. That's too far.
I don't know. I get the blonde. I don't know their names. The blonde prosecutor, very cocky, very demanding. Where the other one, there's something about her. She just irritated me. Like, I don't know what it is about her. She irritated me because it's like every time she talked, it was just that almost more of a condescending tone, And maybe that's just a trigger, is the condescending voice, but she just irritated me. I don't know. I didn't care for either one of them.
I love these personalities in court. I
do too. It makes for a great case to watch.
It really does. I mean, it can be even if they have annoying little affects and mannerisms, I love seeing these strong personalities in court. I think we should have somebody who's, fighting for what they believe is right. I think on the prosecution, it should be for the truth, and on the defense, it should be for their client.
Right. Well, and especially as a woman, I love seeing those strong women. It's nice to see that because far too many women don't believe they can be that strong person. And they are. I mean, they're both strong women. They did a good job. They're doing their job. I don't think they did it good enough. Too much.
It got a little personal.
House.
It got a little personal in this.
Oh, absolutely, absolutely.
And as fun as that is to watch, as far as the entertainment value, I think it's not appropriate for court. I like to see it.
And same thing with yesterday and today with Mr. Taylor. You could tell he was sick because his whole temperament, personality was totally different in my opinion.
Yeah.
He did not come out near as.
Can you win an appeal because your lawyer was sick during closing arguments?
That could be a good question. I don't know on that. I mean, he admitted he was sick right at the beginning of it. So.
I mean, what if it was on some
cold medicine or something?
Medicine, yeah. It's like, don't drive while you do this. It makes you drowsy. And she's like, he missed all the objections, because he was on drugs for the closing.
Right. He was zoned out because he was on NyQuil, or Dayquil. That would I've never heard of. That would be interesting to do some research and find out, though, if there was ever a case.
I forget what I said. I think I said state, or I said defense and not state. I swapped the two. I do that all the time, usually when I'm tired.
Oh, and the delete will. Yeah.
Yes. Okay.
I knew what you were talking about.
Okay.
I knew what you're talking
thanks
about.
for catching me. Chat caught that immediately, so I apologize.
I can't even see. I'm on the phone, and that's what I'm watching because I've got you on my phone, and I've got the Olympics starting up on my TV. So.
Nice. Who's winning?
Got to watch the women's gymnastics.
Wait. Before I say this, I'm about to ask a question that might give some spoilers about the Olympics, and I know the people are on time delay. So turn your volume down for a minute if you don't want to know. What's the gold medal count? Who's winning?
Well, as far as overall medals, the U.S. is winning.
Okay.
We have the most overall medals, but we do not have the most gold. And they just showed it a minute ago, and I think it was Japan or China. I glanced at it that had 7 gold, and they're it's 3, on us. I mean, I know how the U.S. women's gymnastics does because I couldn't wait to see it. I had to, look it up today. I want to watch Simone Biles because this is probably, I have a feeling, going to be her last Olympics. So I don't want to miss out on seeing her.
Yeah.
So,
Amanda,
anyway,
thank you very much.
Well,
appreciate the conversation.
I appreciate you, and you have a good rest of your night, and I'll see y'all tomorrow.
All right, we'll see you.
Bye-bye.
Bob says it's not about the medals; it's about taking part and the medals. Yes, I will say this: there are some amazing stories of people who have overcome incredible odds to get to the Olympics. Or teams that just you don't think should be there, and I'm not just talking about cool runnings. There's some incredible people who have just accomplished amazing feats, and I love seeing that in people because I like to believe that we can be better than is expected of us. That we can achieve things that are bigger and greater than anyone has done before. Really, that's the thing. It's yes, there's a world record, but that world record can be broken. That is the inspiring side of the Olympics. I love that. I also like to see good competition that has respect for each other, the respect for the athletes. I love to see that as well. So that's good. Linda, you missed the poll. I'm sorry. I guess the poll was done. I did the poll. Was the poll done? Yeah, the poll was done. I forget what the poll was now. Let's see. I think we've got to be close to being done. It's 8 p.m. I don't know how. You want to do the thumbnail now? Okay, I've had a little bit of food. Maybe I can focus on the thumbnail. Let's see here. Thumbnail. Let me turn off this. that better? I'll turn this off too. There we go. The thumbnail looks like this. I need it full screen so my old eyes can see. We have all sorts of crazy stuff on here. These scissors, these gold scissors in the back, are being held by the judge because he was cutting up the evidence, which is really cool. We have a power line. Power pole being replaced there in the background because my power and my internet cable was replaced, or they did work on it throughout the day, as you guys watched in the pole replacement and during the live stream. We never lost internet, so props to the crew who did that. The creepy way, we've got the poison tea kettle. I see our little Recovery Addict YouTube plaque in the background. Free headphones. That's from early on in the court when one of the witnesses asked if he could keep the headphones. We have the choo-choo train because we had amazing gifting train happen. I'm not sure what the Cheshire Cat's for. Heart XXX. Not sure this. It looks like a keychain. No clue what this even is right here. Cell phone, HDMI cable, the wheel, this is a Ferris wheel or Bueller, as well as the domestic violence wheel, I guess. I don't know. Oh, that's Ferris's wheel, I think. The moving truck. Got the number 13 from something that I can't remember anymore. Sand. Not sure about the sand. We've got squirrels that are dancing and ballerina. We've got the bra with the gun in it. Tissues. A xylophone. Was that somebody's phone? The ringer? I forget what that was. Tickets, admit one. Not sure about the what that is. LOL. Our ear-splitting noises that we've heard. The ballet shoes. Diamonds. Not sure what the diamonds are. Shrimp. Peanuts. What is that? A baby. 230 objections. Don't know what this is. Did I cover everything? There are a few things I don't know what they are. Sorry, I've got the volume turned off. Amber, I apologize. We've got squirrels on there. Hey, Mrs. R.A. Are you... I assume since you're here, are you home? The objection counter is the 230. That's the number of objections we had on it. Dump truck from moving. Doug threw the fluffy cat. Oh. What's the stuffed animal saying talk right here? I don't know what that is. Upside down pineapple. Yeah, we got a lot of stuff there. I don't know what everything is. All right, are we back? We're back. Here we go. That being said, let's go back and make sure that we still have our feed, which we do. Verdict clock, they're showing approaching 4 hours. I'm about 15 minutes ahead, so maybe they think maybe they took a break for a little bit. See, I'm looking to see if my wife responded. I think she's home. Thank you for dinner. Sand is sandbagging. Got it. The switchboard and paddle. Just noticed the judge has scissors for cutting the picture in half. Yes. The diamonds are for jewels. Okay, I see that. Jewels in court. The whoopin'. Okay, there you go. The paddle for whoopin'. Somebody's going to get a whoopin'. Okay. We've got the Sarah Boone shirt link. Thank you very much. Stuffed animal, TED Talk because he's a teddy bear. You need no DNA sign. George Allen Kelly update from his GoFundMe page. The Santa Cruz County attorney has filed to the Arizona Appeals Court to hear her case as to why it should not be dismissed with prejudice. So they've appealed the prejudice ruling. Hey, you are here.
What's about dinner?
I assume it was some cooked fish. There was some fish on the plate.
Oh, yeah.
And I ate it. And I ate some rice, too.
Oh, guess what happened with that rice?
I don't know. Hopefully nothing bad.
Yes, it'll be bad.
Oh, now she tells me.
We are completely out of food in this house. Like, we're out of food. And I'm trying to do this. I'm trying to get done with our food so that we won't have anything going bad here. But we hit the out of food a couple days before we hit the we're leaving part. And so today I'm like, okay, well, we're going to make some rice. I mean, that's what we can do. We've got some rice. So I put it in our pressure cooker and I got it ready to go. And the little valve that lets the pressure build up and then also lets the steam out is missing. I don't know where it is. I can't find it anywhere. The house is clean. I don't know where it could possibly be. It's just gone. And so I turned the pressure on. I let it get till it started steaming and then I turned it off and it cooked it. That was dinner. How was it?
It stuck in my teeth quite a bit. The rice was quite al dente. I think is the technical term for the rice.
It was a little crunchy. This was not a good day.
There was something wrong with the rice, and she didn't tell me. She just served it to me, and now I've got rice forever in my teeth.
Why are you at work at 8:00? What is happening?
We are in verdict watch, and the judge has not sent them home.
Meanie.
I know.
Who keeps all of their people waiting at 8:00, Scott? What kind of a meanie does that?
Oh, what are you talking about? I don't know. Anyway, so I tried to go to dinner and then said, okay, if I go to dinner, then the verdict will come in, but it didn't.
Because there's no dinner.
Oh, I didn't stop. I think it's because I didn't stop the live stream. I'm going to order that part for the pressure cooker.
I already ordered it.
Did you?
We need it. The thing does not work without it.
You seriously ordered it?
Yeah, I ordered it.
Wow. I thought I had one job around here. But
you're the orderer of all things that I
order
lose.
things online. It's a skill I've got. Okay, is this bugging you as much as it's bugging me? This is nuts. This cable needs to go right through here, which means I have to take this off. Probably.
Oh, there went the microphone. It's fine.
Might have to turn the volume down. Okay, hang on. Rebecca's calling me. Just 1 second.
Call from
Bite Me and Buttercup.
Buttercup, who's a good dog? Who's a good dog? Hey, give Buttercup a pat for me. Rebecca, how are you doing?
I'm doing great. How are you?
Other than my mic is breaking. Well, I'm breaking my mic.
I see you fixing it.
A little washer just fell out. I might need that for later.
Uh-oh.
You're going to have to order that online.
Okay, hang on.
Hello, Mrs. R.A.
Hi, how are you? Oh, did you see
fabulous.
that? That was like spring-loaded.
Oh.
I did not know that did that.
I was not expecting that.
I saw that.
Wow.
Can you stick your hand in here?
Oh, my goodness.
Okay.
Buttercup saw it, too.
What do you want?
Okay, I'm good. All right, I'm good.
You good?
Yes. Hang on.
Sorry, Rebecca, what's up?
I forgot that this was a spring-loaded arm.
Oh, I haven't called in a while. Well, I've called, but he didn't answer the phone call. But I haven't talked to him in a good while.
Yeah, me either.
And and I wanted to give you my condolences about your sister.
Thank you.
So that was sad yesterday.
Yeah.
And this is only Tuesday, and y'all have had 2 crazy days.
It's been wild.
Yeah,
It
been wild
has
for sure.
been.
Good.
Yeah, it's been crazy. But Buttercup and I missed talking to you, and we just wanted to call and say hey.
Awesome.
Wonderful.
I haven't watched this case at all, so I have absolutely no dog in this fight, but do you think that it's guilty or innocent?
You know, it's kind of hard. I think that the state did not prove without a doubt, and with that, I would say they would have to vote not guilty. But some of the things that she testified to, I don't know. It's really a hard one to call because, each situation is different. And having been through domestic violence myself, I know how difficult it is, and as well as many of your members and subscribers, Scott. So each one is different, and who am I to say that she's not telling the truth? Because I know how it can be. So, it's just hard to call. I don't think the state did a good job, though, proving her guilty. I have to say that.
Yeah, well, I would say they did a great job proving that she pulled the trigger and killed Doug. That part they got, but their burden was to prove that it was not self-defense, and that, for me, they didn't do that.
Yeah, I have to agree with you. I really do. The whole situation is unfortunate, but I think you're right about that.
Yeah,
I think you're right. Was Jules sick today?
Yes, well, she's getting over an illness just recently, and she was worried she wasn't going to make it in court at all, I think, previously. And with so many people coming down with illnesses in court, she thought, I'm just not going to be there for that. She's just getting back on her feet. So she stayed home. I think she did a live stream, or possibly was on with Ada K today on her YouTube channel.
Okay. Well, I wish her all the best. I hope she feels better soon. And prayers for Mrs. R.A.'s sister.
Thank you.
And I just missed talking to you, so I thought I'd just give you a shout about nothing in particular.
Sounds good.
Rebecca, thank you very much.
Your light pole, your telephone pole out front.
Now, I'm just glad it's fixed. I want to go out and look at it, because there was one point where they actually pulled on my line itself and pulled and moved it. I'm like, don't break it. But it's working. It's still working. I'll run some speed tests tonight.
Did they pull it a little tighter?
They did. There was a phone line that strung down from our house down and then up to the pole, and then from the pole it goes down and across the road. And the part across the road has been so low that trucks have hit it before.
Yeah.
And it's and they've had to pull it up and tuck it up again. But our end was really low, but they pulled it tight. Now it's pulling our house towards the pole. It's
we're going to zip line that thing.
It's a zip line, yeah. So
that's good that they pulled it up some.
Yep.
Yeah. I'm surprised. That's a residential street, right?
Yeah, well, it's got houses on it, but it's also, I think it's a state road.
Oh, is it a state road?
Yeah.
I'm surprised they let big trucks go down that road.
Yeah, that's part of the problems. That road needs to be completely redone. Unfortunately, underneath it has the original sewer lines that were constructed when the town was first built.
Yeah, have you ever read Les Mis?
No.
No. Oh, okay. Well, there's a whole section in that book about the underground sewage system. Ours was built about the same time as the one that they talk about in Les Mis.
It's so old, and it's faulty, and it's got all the problems in the world. Unfortunately, the town does not have money to fix it because we're upside down, and the state won't fix it because the state won't fix the road until the town fixes the sewer underneath, because they don't want to fix the road and then have the town dig up the sewer line afterwards and fix it. So basically, we're waiting for just a catastrophe where we have to fix it, at which point the town will be bankrupt. The state will come in and take, conservatorship, whatever, take over the town, running the town, and then they'll get it fixed. That's basically what we're waiting for.
That's interesting because my son works for a company that actually does surveys of sewer systems and water mains in towns and cities. And they go in with cameras and they see, where the faults are, where the cracks are, and give the city an estimate of how much it would cost to replace. And now he actually sells the equipment to those companies that does that. So,
well, I can tell you with our system, the first fault is that all our rainwater runs into our sewage treatment plant. So every time, and we pay per gallon to have
Yeah.
our water treated. So every time we have a hurricane here and it dumps, I don't know, 11 inches of rain, our water bill goes through the roof because we pay to treat all that rainwater.
And everybody complains about it, and the city's like, sorry. Oh, well, they don't even say sorry. They're just like, that's how it is.
Just how it is.
It's
like,
I can imagine. There was maybe a year or two ago, when Ida came through, down in Lake Charles, my son Nicholas, working for that company, they had to go down with 18-wheelers. They had 20 18-wheelers that went and pumped out because the electricity was out. They had to go pump out the sewer plants where all of the waste goes, because with no electricity, none of it was getting pumped out. So he was down there for a couple of weeks doing all that. So I know now it's hurricane season again.
Rebecca, let me ask you a question about your job before I let you go. How are the mosquito? How is the mosquito population this year? Is it up, down?
My traps that I do in my office, they've been kind of on the light side. Now, last year was very, very heavy. Last year, I counted over 1 million mosquitoes, and that was just in the traps that were brought in to the lab. This year, so far, it has not been nearly as heavy. The traps have not been as heavy, but we suspect that August will be a really heavy month. But so far, and we've had a couple of positives for West Nile virus.
That's the one I don't like. Yeah. At least it's not like the bird flu, whatever. So.
No. West Nile virus. We do testing in our lab, and we send pools off to LSU for them to do testing as well.
Sounds good. Well, give Buttercup a pat on the head and maybe a little treat for me. Thank you very much.
Sure
it's good to hear from you, Rebecca. It's been a while. So thank you.
Please know that we love you, and you do fabulous. And I can't tell you how much you brighten my day listening to you. You're an inspiration to all of us. And thank you so much.
Kind words. Thank you very much. I appreciate that. We'll see you.
Thank you.
Bye.
Love you too. Bye-bye.
Bye. We have Greeners was asking, how much does a new fiber line cost? The first install here was free, which
Was it?
Yeah, it was free install.
We paid a ton at our last house.
I paid $3,000 at the last house to run fiber into our house.
And then immediately decided to move.
It's
like,
I fought for years. I wanted fiber so badly in my yard, and to get fiber installed in our community, in our little neighborhood, we had to have a whole bunch of neighbors say express interest.
Call from
Ricky Watson.
Hey, Ricky, hold on just one second. Let me finish this fiber story, and I'll bring you on. Is that all right?
Oh, you got her done. Get it.
Okay. So our neighborhood did not have fiber internet, and our internet was terrible. And so what I did, I wanted it so badly, I went out and I got a sign from the company that installs the fiber internet in the area, and I put it up in my yard saying, like, I've got fiber internet. And all the neighbors are going to be like, how'd you get fiber? And I'm like, well, I don't. But if you and me and everybody else will head down to the city council and say, we want fiber, then they'll bring it in. And so they finally brought fiber into our neighborhood. I mean, they had to dig 9 holes in our yard to put this in. And they broke our sprinklers, every single one of them. It was terrible. And on top of that, and having all the boxes and everything put in our yard, the junction boxes, you name it. On top of that, I paid $3,000 to have it installed. Then we moved immediately as soon as we had the fiber. Ricky, my friend, how are you doing?
I'm doing well. How are y'all doing?
Verdict Watch 4 hours in. I'm ready for maybe a break for the night. But
I'm ordering pizza. No, I'm not.
Go.
Sorry, Scott.
Hey, Miss R.A., if you'll get a pizza with no cheese, because I'm lactose intolerant, I'll be right yonder.
I cannot imagine a pizza with no cheese. Is that really a pizza?
That's a breadstick with fixins.
Well, it's a pizza to me, so
awesome.
I mean,
yep.
But anyway, Miss R.A.,
yes, sir.
I am very sorry about your family deal.
Thank you.
And I really hope you take my sorry into gratitude.
I will. You know what? We're gonna see her here in a week or so, and I will be certain to let her know how many people are reaching out and thinking about her and praying for her. I really do appreciate that.
And let me just add, there have been many people who have reached out personally. There's even some things that we're going to be giving her from this community that have been sent, and thank you very much. It means the world. Obviously, we can't make anything better for her. For those that don't know what happened and missed yesterday. My wife's sister lost their baby, and I don't know what was the condition.
It's trisomy 13.
Trisomy 13. So the condition itself, the child was not expected to live very long. So basically she was pregnant, knew there was a problem, and had to be planning for a birth and a funeral at the same time. And they expected to have some time together with the child, and it ended up passing away before it was born.
She was so heroic in the way that she approached this. She was just so getting to know the baby even in utero, and just rejoicing in the moments that she had to have him in her life. It was, yeah, it's still tender.
Yeah. But
well, gosh, I'm going to put this out here for y'all. If y'all need anything, RA, you got my number.
Thank you, Ricky. We are great. I appreciate all the offers. We've had many people say those same sentiments, and we appreciate that. We're going to carry that same message and share that with her, and hopefully she understands and feels the impact that we have from the outpouring of support and love. So
yeah, I really do appreciate it. It's very sweet.
Thank you so much, Ricky.
I don't like to talk about.
Oh yes, sir.
Yep. So if she's crying, I'm crying. We're trying to be on verdict watch here. So.
I'm sorry. I didn't mean to do that to you.
It's all right.
You're good.
Thank you so much, Ricky. It's good to hear your voice, my friend.
Oh, yes, sir. Y'all enjoy your pizza.
Yeah. I wish. She fed me half-cooked rice, and now she's going to get pizza.
I know. The thing is, I'm starving, too, because I came in, I gave him my lunch, and then dinner was so bad, I didn't eat it. I'm like, oh, I'm so hungry.
She didn't tell me. I'm like, I guess they ate it. I'm going to eat it.
Well, Mrs. R.A., if you'll get one without cheese, I'll be right
You'll be there.
yonder.
Awesome.
All right, Ricky. Thank you so much, my friend.
Thank you.
All right.
We'll see you.
Y'all be safe now.
You too.
Love y'all.
Bye.
Thank you. You guys, I can see how much love is just absolutely pouring out, and I'm not great at being in public while I'm feeling my feels, so but I really appreciate it. Thank you.
Kelly says, hey, Mrs. R.A., here's a couple bucks for the cooker. Thank you. We've got the new part on the way. I use it for cooking eggs. If you haven't cooked eggs in an Instant Pot, oh my goodness. They peel, like they almost peel themselves. It's a miracle. Okay, guys. New poll.
Call from.
Should I accept this call? It's not, just kidding. Thal, how are you doing, my friend?
Pretty good. Your wife's having way too much fun over there. I'm going to end it now.
Stop having fun.
Okay, so I'm coming up. So I'll let your wife respond to this. I think she's guilty, manslaughter.
Okay. How come?
I think that's what
I know like nothing about this. Some ballet.
Yeah, she's not
going to
argue with you. She knows it's the ballerina, so you'd have to cover the entire case.
Some sort of domestic violence. That's all I know.
See, when I go home after work, I don't talk about work. I'm like, so how was your day?
I wouldn't either. My Lord, you spent 9 hours, or God, like 20 today doing it. Anyway, so I'll be the bad guy. The reason I think she's guilty of manslaughter is that I think that basically what happened was it was one of those. To me, in my mind, this is my opinion. Okay.
Okay.
Is that basically what I think happened was she got herself in a relationship. It was abusive. She started being manipulative to try to, you know what I mean? She got out of it, and then she got a boyfriend, or it got to this big old mess of, back and forth. The problem was that she started being manipulative about it, trying to get him locked up in court, saying things to cops like, arrest him now. In court, you can't do that. So that kind of skews me toward being manipulative. They had a kid together. She ends up shooting him at the end. Now, the end of this is that she called him over to help her do something. Her her mom left the residence to go to the park. And he came at her. She ended up shooting him. Now, here's the thing with me, is that I think that given her manipulative behavior before, DV or not, it doesn't matter. That's not an excuse. So if she planned it, or if she had knowing that this might happen to get him out of her life permanently, and if she viewed it this way as the only way to do it, then she's manslaughter, period.
Well,
you know what I mean?
But if she planned it, that's not manslaughter. That's like first.
That's murder one.
Yeah.
This is funny because a lot of people have said this. They said, I think she planned this out. And that is murder one. I mean, that would be murder one. It's very hard to prove because there was no evidence that, we would need like her handwritten journal of, this is where I'm going to do. This is the setup. I'll do this. I'll make sure mom's away.
Yeah,
you'd need all that. And that's very difficult to prove.
You'd need her thoughts at the time, which is impossible. There's no way to do that. But so this is why I'm saying that I think it's manslaughter, because I think what it was is I'm going to put him in a situation knowing the likelihood of what the reaction will be. And if I can have this action happen, then I can take action on the action that that I think he's gonna have. That's what I think it was. I don't think it was specifically malice. I don't think it was specifically planned. I think it was just, if I put these two people in a room, the likelihood of me getting this reaction is high.
There's a legal argument that, and this was taught to me when I was trained for carrying a concealed weapon. There's a legal argument that if I instigate a situation, I am not authorized. I legally cannot use deadly force in self-defense if I instigate, if I start it. Right? And basically what I'm hearing is you basically saying the same thing. She set up the situation where she would be justified. I would have to say I don't see the evidence that way. It doesn't speak to me like that. So I would say that is a possibility. But not something that's been proven to me. But
the thing is where I differ from a lot of people, though, Mrs. Aria, but you got to know, is where I differ from a lot of people is I think that this was not done out of malice. Like I said, I think this was done out of desperation. I think she didn't know what else to do to get this guy out of her life. That's why I think it came from.
I
don't think it came from this evil twirling the beard. I don't think that's where it came from. I think
do you mean the mustache?
I don't know what else
to do. Because twirling the beard is a really funny image.
It's like a Gandalf. And Gandalf with the staff. I'm not sure if we want to recreate that. But
okay, wait, though. Isn't that abuse? I can't remember what it's called. The defense that says you've been beat over time. And so
that would be battered spouse.
Battered spouse, yes. Doesn't that fall into that category?
Battered spouse?
No.
There has to, the way it's written, and this is a problem for domestic abuse because it doesn't take into account other forms of abuse. A battered spouse specifically is talking about physical abuse, and there has to be that pattern of physical abuse. Well, I don't know why.
Oh,
my computer just went to sleep. That one, it's done. It's like
is anybody still out?
Chat just died.
It's just us and you, Thal. I don't know what happened.
YouTube just crashed for me on that one.
I brought the hate, and now it'll
you
get
broke it.
Apparently, YouTube has voted.
Did you go over 12 hours?
No, we're only sitting at 7, almost 8 right now. I'm past the time that I can edit things. But,
okay. I was going to say don't go over a certain time frame. And I got to push back on one more thing.
Yeah,
it's going to light everybody on fire, but I have to because I'm a fairness guy. You know me, Scott. Can't help it. To say that we should believe all women is an absolute witch hunt. You are insane. You have to have evidence. You cannot claim and be believed. You have to claim, have evidence, go to court. That is the way it works. If you don't do that, you start setting up a situation where we have 2 levels, 2 tiers of justice and 2 tiers of who can do what. That is not, I don't know if that's specifically what you advocated before, but it sounded dangerously close to it. You cannot do that. The system we have now is not perfect. It is fair, though.
I would say...
What are we talking about?
We're talking about believing the allegations of abuse.
Without evidence? Is that the hang-up?
Yes. For me, it's without evidence. It was a categorical believe everyone no matter what. No. Take it seriously, but without evidence, there's not much they can do.
I would say there's a difference between listening to someone and believing them and putting the other person in jail, right?
Okay.
Because, and this, we didn't get to this. I did say I have some issues with this. This has problems. I didn't get to this, so I appreciate the chance to revisit this. I've said I don't have the right to be around somebody. So if they claim that that they want a restraining order against me, I don't have the right to be next to them at all times. And so
yes.
I think that restraining order should be very easy to get, especially just allegations, even before it's been investigated. I mean, on the face value, we should be able to get a restraining order. That's how I feel.
Right.
When it comes to,
and just real quick, I'm going to agree with you. In the case of Nebraska, I can get a restraining order against you or your poodle or whatever. You don't even have to be notified. They can just send you a letter.
I thought those were pretty hard to get.
State of Nebraska is very friendly with those.
When it
a
comes
sheriff
to
will deliver it to you and make sure you know, and that's it.
The effect that somebody having a restraining order on you, that starts to be a problem, because I do have some rights. And if somebody out of the blue, say somebody in chat, say one of you in chat gets really offended about something I say, which is possible because I say stupid things all the time. But say that you file a restraining order and you get it, and then I go to
the grocery store
to buy a firearm from my personal collection, and suddenly I have a restraining order, and this starts becoming an issue where I can't do certain things because of that. That's a sticky situation.
Wait a minute. Are you saying if anybody has a restraining order against you,
Depends
you
on the
cannot
state.
get a gun?
I might not be able to carry a concealed weapon or buy a firearm. Or carry.
So that's a problem, because that's taking away your right to keep and bear arms based on somebody's allegations without proof. That is a problem.
Yeah. So there has to be a point where there's
that doesn't matter.
What do you mean?
Yeah, the point, the thing in restraining order in Nebraska, it literally just says don't go near this person, and if you do and they call the cops and you're near them, now you go to jail.
Right, so it has nothing to do.
But it doesn't have any other effect. It doesn't have any other effect.
Okay. So that seems much more reasonable. Except, right. I mean, that does sound more reasonable, but seriously, what happens if, like, you're going to the grocery store, you don't know they have a restraining order on you. They're at the grocery store. I mean, there are some sticky situations, but
if you don't know, that is the court's. The court has to notify you. If they don't notify you, then there's nothing they can do against you.
Yeah, if you're going somewhere where you're allowed to go and they happen to show up there, I think you have an obligation to try to clear out and not.
I need my milk.
Interact, but they're not going to be like, hey, I was going to work and she was parked outside my work. That doesn't mean you can't go to work. The court takes care of issues like that.
Yeah.
All right, Thal, I think you've stirred the pot sufficiently.
Yeah, it looks like you have, yes.
I was about to say, you said that you might say something stupid. R.A., I live on something stupid, so I don't. So get out of my campground, buddy.
I will say this. I have learned from a lot of people who have called in today, and over the duration of this case, learned a lot about their experience, learned a lot about things that I don't have experience in, and I appreciate that because I'm still learning.
It's a delicate subject, and it's a complicated subject, and it's hard not to. It's really hard to balance everything out, which is, it's not easy. So God bless, good luck. All right.
Thanks for lighting the forest fire and then leaving.
glad it's not me. I'm gonna leave the rest of the message in gasoline where they can catch fire and run.
You're like a terrible grandparent handing cookies to the babies and then be like, see ya, have fun with the sugar high.
Yeah, dude, that's my job. Instigation. That's what I do.
All right, Paul. Thank you very much.
All right, see you, buddy.
Right, bye.
See ya.
Man, he does stir the pot. He likes to go in places where it's going to get us in trouble, because I honestly, I don't know how to talk about it. I don't know. I don't think I'm the right host to have the conversation. Does that make sense?
I think you'd need somebody, probably several somebodies who have experience in different areas so that they could share their experience and help try to find a solution. I'm not sure. What is the problem that we're trying to solve right now?
Right now, we're trying to solve why is the jury still deliberating? Why have they not gone home for the day?
But I mean, like, talking about, I don't know which words I'm allowed to say aloud.
The big issue that was in this case was, was she lying and manipulating, or was she abused? That's the issue, because she testified, she took the stand, and if the jury believes Ashley, they would have voted already, and this would be not guilty. because that was testimony. It was not refuted. She was not impeached. And she said, this is what happened. And her version of events, she used the right words to qualify as self-defense, and that burden shifts to the state. I don't think they did anything to prove that this was not self-defense. There's a lot of possibilities, but that's it.
So I am sorry, I'm just catching up.
So we're basically watching this, and I have some problems with Ashley. She sits there during court, and she does this, and she's looking around beforehand. She walks in, she's talking to people, she's animated, and the jury comes in, and
they depress
for
her
hours, and straightforward, not looking, just demure, holding still, no reaction, just very, very still. And I'm like, man, that's hard for me. That's hard
because it comes across as fake.
Chat Mom is on the phone here. Amber, how are you doing?
How am I now? You're calling me Chat Mom? This is not fair.
What did you call about? I'm curious.
So I don't know if you caught it, but I got Saul again, but my finger hit the wrong button.
You timed.
And I meant to go 30 minutes to get through the rest of the evening, and I hit 24 hours. So Saul.
Oh no!
Saul.
So Saul, I kept my promise from the other day.
This is why he's calling in, because you can't ban the phone call. That's why.
Oh no, that just happened.
I will say, in Amber's defense, let me say this: when chat is going fast, which it periodically does, we have to be able to right-click on a message and click and time something out if it needs to, because a lot of messages, if a troll comes in, they need to be deleted. Some are just not appropriate. Some are name-calling to go against our rules here on the channel. But it is so easy to right-click, and right as you're clicking, it scrolls up because another chat's come on. And suddenly you just banned the wrong person, or you just timed out the wrong person.
And you don't even know. It's like, I don't know what just happened there.
And there's no undo for timeout. There's no undo. Unbanning somebody, it takes like 30 steps and requires an affidavit and signed by a notary public. And it's crazy. Our mods, Amber included, you guys do a great job. I realize it's sort of like herding cats sometimes, because things go every which way, and they all have to know that sometimes one conversation, one comment is absolutely hilarious and appropriate, and out of context, it's like, that was rude, and so they've got to follow the 30 different conversations that are going on in chat simultaneously as everyone's talking back and forth. That's why we often say, let's try to keep it relevant. Let's talk about the case, because it helps them be able to say, to not have to follow like the 50 conversations. And so usually when it gets busy, that's when we get a little more strict on the rules and say, let's keep it appropriate. Let's tone our arguments down, maybe not so much back and forth, things like that. But Thal, you were the victim of a right click.
Yeah, but see, I also know Saul well, and I know he's got another account. He can come in
already.
on. In fact, he already has. He already has, but I'm not sure if he got zapped on that one too, just as a funny or
he's
not.
Still here. He's good.
Amber's like, I can take out that one too.
Oops.
Hey, whoa.
No, it was really an accident.
Pretty Eyes says you can fix it by clicking on the person again and time out 10 seconds. It fixes it.
What?
You can reverse. But
can you imagine? You'd have to like chase down that one comment and find it.
You've got to scroll for years, but.
Oh no! I just got Better Call Saul.
You timed him out too.
It on him.
Okay, give him a couple minutes and then time it for 10 seconds. So you gave him. Oh, you timed him out for a day, and then you reversed it. Mm-hmm. Okay.
Did it work?
It works.
I don't know. We'll see.
It worked on my end. Pretty Eyes, thank you. That I learned something about YouTube today. I was today years old when I learned this.
Yeah, I did not know that.
Well, we'll see, because I haven't seen him come back in chat yet. So we'll see if it's just 24 hours plus 10 seconds.
Maybe it adds.
Oh, no. It's a multiplier. Dang it.
I'll tell you, on my screen, it looks like it was right. So he's not saying anything.
Paul's mad.
Okay,
right.
That was whoever made that comment. Pretty Eyes.
He's back. He's
fault.
back. He was timed out, so it worked. Thank you, Pretty Eyes. That's amazing.
That's cool.
Okay, let me stop for a minute. Deep breath, Amber. Deep breath. You with me?
Oh man.
what are we hearing on the jury? Is there any rumblings about the judge looking hungry or eyeing the clock wistfully?
They've already had. Well, now somebody's saying movement, but we'll see. So far, it was they got dinner, and there hadn't been a peep since the question at 5:38. So, since being on the phone, I haven't been able to refresh.
WeatherWatch wants to
call in.
Yes, I won't answer anything but WeatherWatch's call now. So, okay, thanks, Amber. Appreciate it.
See you, Amber. Bye. What time is it where they are? Where the court?
They're Florida. So
they're here?
They're East Coast.
Well, that's mean.
It's terrible. It's 8:30 at night, but the jury is the one driving this. I'm
really?
not sure. I don't know if the jury knows they have to ask to go home. I'm serious. It was not in the instructions. The judge says, I just let them go until they ask to go home. The jury doesn't know. They don't know they can ask to have something read back to them. They don't know they can ask to go home.
Oh, my goodness.
Thomas, WeatherWatch, how are you doing?
Oh, this is perfect. I needed a break from some manual labor.
Well,
you're not doing stuff.
Take a seat. Let's talk about it for the next hour or so.
Oh, hour. Perfect. Mrs. WeatherWatch might say no to that, but I will milk it as long as I can.
Well, you're slacking this week, right? This is the week that you guys aren't doing your podcast.
No podcast. I mean, that is not a change for me, but for you, that means no work.
One may call it slacking. Another may call it 42 hours in a vehicle with their father-in-law. So pick and choose which you wish.
Oh, I'm not touching that. Not with a 10-foot pole.
No, so I rarely call in on trials, right? We have our show and it's lighthearted, and there's so many callers with great insight and great opinions, all diversified, and they deserve that airtime. And this one, while doing my manual labor, I just had these thoughts over and over and over on this particular trial. And here's what's hard for me, and this is the way I dissect it as if I were a juror, right? The evidence that came in, the testimony, the witnesses, her filing issues with domestic violence against him, them not getting granted, back and forth, right? So we, as laymen standing here, don't know whatever actually happened behind closed doors to either of them, physically or emotionally.
Right.
And I would like to think a lot of us could agree with that. Mm-hmm. So if I were a juror sitting there, what I would try to, what we would say, trim the fat. And I would try to think of, on the day she chose to pull the trigger, can we prove she felt her life was in imminent danger or, in fear of death? That's what I would try to trim it down to. Because, correct me if I'm wrong, I could be mistaken, the battered wife issue, was that not denied in
I think it was.
Prior hearings and things, right?
It was denied.
Okay.
It was denied in this one.
So you've got that. Now, the defense did a great job, as they should, fighting for their client, of painting a character of Doug and exhibiting poor behavior and abusive tendencies. So I'm not saying she was or wasn't. And I'm not saying she was perfect or did anything wrong either, because I don't know. We don't know. It does appear it was a very toxic relationship. There's no doubt about that. But I literally want to understand what the evidence is that shows when she pulled the trigger, was she justified? And where I stand is, I don't know. I don't care what she did or what he did prior. That day, afternoon, evening, the fight that broke out, apparently, argument, what have you, did he really grab her? Did he threaten her? Was she truly scared? And I simply don't know. Very easily could have or not. But the fact that I don't know, as a juror, you have to follow the law. So where would that put you?
If you don't know, it's not guilty.
What? But isn't that backward?
And that's what's...
Because she's...
I would flip it. I would say the burden is on the state to prove that it wasn't justified. So it goes backwards because she's asserted that she was in the right. Your animals are fighting in the background.
We can hear your animals killing each other.
I'm sorry.
Sounds like an angry hippo.
Apologies.
No, it's good.
It's an angry hippo or jealous dog, if one of the others. So it makes it really hard. And again, I am not saying there was no domestic violence on either side, either way, or that it wasn't a toxic environment. That appears very obvious. But I'm only trying to make my decision based off of what can be shown and given to me. And I don't know. The facts are we have a deceased individual via gunshots. Now that I can prove. But when you go back to, and I think Scott, you've even mentioned a few times, you can't, people in chat, you can't go back to know what people are thinking or feeling. We are all so different. And so there's a YouTube channel out there. It's something of self-defense. He covers that type of thing all the time. And it's so big. Great guy. He speaks very well. And I would hate to, A, be on this jury, and B, also ever be in a situation where I use deadly force to protect myself and I'm facing a jury. And I'm not saying this is what Ashley's facing per se, because we don't know. But if I myself know what I did was truly justified, and now I'm facing a jury and the only thing is my word, I would be so scared. That is so frightening to think about. But it's real life and what it is. So this is a very frightening trial, in my opinion, for both sides. Yeah, it really is.
Wait, catch me up. How is it a threatening trial on his side?
Well, if the jury says not guilty, that's telling the whole family that he was an abuser. Which
his whole family has to swallow that pill.
His daughter's there in court, who says that there was nothing, there was no violence. That his cousin, who was really close to, testified in court. Other family members are there, extended family.
So on his side, they'd be invalidated and told that their perception of reality is wrong, and on her side, she'd go to jail. Is that what the threats are?
Yeah.
Correct. She'd go to prison. Yeah. Yep. And her daughter that she had would reside with her mother, and she would face, and if she felt extremely justified in her situation, that she did what she could to save her life, she's feeling unjust of being sentenced to prison now and wrongfully accused. So that would be the wrongs of the feelings of either party. And that's what makes it hard. There's so many trials we watch where there's evidence put forward of just this nastiness. There's DNA, there's camera footage, there's eyewitness testimony where it's like in chat, we're not jurors, but it's a slam dunk. Just everyone's going, why isn't there a plea deal here? Why are they going to trial? But this is a case of he said, she said, but unfortunately she said is the only one there to tell the story.
And basically,
it makes it really hard.
All the evidence that supports her comes from her. That's difficult.
That's typical.
If this were a self-defense case where somebody was breaking into my house or wanted to enter my house without permission, and they come through the front door, I give them 2 steps and drop them there. Okay, and so they come and they're like, oh, here's the case. Obviously, I would get arrested because I just shot somebody. I hope to never have to do this, but just know that's an option if you decide to want to play that route.
If you want to visit, knock first.
Yeah, I've drawn on somebody before.
It was my brother. He knocked after that.
But he had a key, and he made the door. He got the door open that far before I had woken up, retrieved my firearm, and had him down sight.
He just was like peeking in the door. He's like, "It's okay. I don't have to visit.
I protect
it's fine."
my family. Anyway.
My dad did that on my older brother because my older brother thought it'd be funny to come home late and bang on my door and yell phony threats as he was coming home. Yeah. So I crawled out of bed into my parents' room I think I was like 11 and said, Dad, someone's banging on my door. They're going to kill me. And so my dad, bless his heart, he won't watch the show, and his Hanes Whitey tidies grabbed his 45 and marched out the front door and held my brother at gunpoint. And then my brother starts crying and was just like, oh my God, I'm so sorry. But my brother learned a great lesson at that time.
Yeah.
No, I will say, let me continue that. If somebody came into my house and I shot them in self-defense, I was in fear for my life. That is very clean and very clear. And the evidence from the crime scene would speak to the fact that, that this was what happened because we have somebody who has no right to be there whatsoever, who's there and might even be in possession of tools, which would be even better, for me as a self-defense side, if he had, burglary tools or weapons or things like that. In this case, you have a spouse, okay, a strange spouse, but a spouse in the same house, and now it's all just one person's word. And if you don't believe that person, and Ashley has some mannerisms about her that make me question if she's being 100% truthful about things. But as far as the evidence goes, nothing that she said has gone against that evidence. Everything has been supported by the evidence in my mind. And so I have to give her the benefit of the doubt. The judge says, you only hear the words that came across as testimony, as your evidence, and that's it. So I can't take these other factors that I'm observing in her mannerisms in court into to factor that in. I'm still strongly not guilty. I don't think they proved that it was not self-defense.
And I 100% agree. If you follow the law to a T, and as jurors are supposed to do, that's where, in my opinion, it would land. Again, what makes it hard, and we've even talked about it on the podcast before, of where we either share advice or opinions or things of that nature, all comes from real life situations and experience we have. So we've created these opinions and these knowledge and how things work. So in a case like this, that's so heavy when you're discussing domestic violence and things like that, you're listening to testimony or you're watching how people react. And so those opinions are going to be formed outside of evidence. And I'm sorry, but that is human nature. It's just going to happen. Yeah. There's not a perfect jury out there that follows the law to a T. And unfortunately, that's just the way it is. We're all human and it's going to happen. So I'll back up with saying I'm with you as far as my legal conclusion where it lands, but I also would never want to be on this jury because I cannot ever say she had to be thinking and feeling this, and he had to be thinking, feeling this. I wish there was, I wish there was security cam footage in that residence when everything unfolded and happened, and we could all have more and a better understanding.
And barring that, we wouldn't know. We don't know. We've only got one person's word, and this is one of those situations where our legal system is designed to let a potentially guilty person go free rather than to put an innocent person in jail. So
right, I agree.
So Thomas, you're saying that you would go with not guilty?
I would in this case, and my reasoning would be because I cannot say guilty. I don't have proof. Doesn't mean there's not a thought of was there some weird things with this relationship? Did she maybe take advantage of scenario? That's a question I have, and I would really like to answer. But when it comes to the book of law, I would have to follow the judge's orders and go with not guilty because I do not have evidence that she 100% did what she did without protecting herself. I don't know that. I can't. And so it doesn't scream a murder to me with zero conflict.
Thomas, you're very eloquent and you've got a well thought out opinion. You should have some sort of show, like a podcast or something, where you can talk to people.
Usually, everything I talk about is completely
is not relevant.
Yeah,
that's not relevant. That's usually what I talk about. So I rarely call into the show, but this trial really intrigues me, and I hope I'm not watching chat. I can't see it. I'm just on my phone. I hope I didn't offend anyone with it because I'm not diminishing domestic violence on either party, male, female, whatever it may be. I know it's real. I know it exists. I know a lot of people experience it and they're passionate and they believe she was conniving and was tricking him and things like that, or vice versa. And I completely respect both of those opinions 100% because everyone's experiences and things are going to justify those opinions. I fully understand. I've never been in the situation myself, so I cannot speak to it or preach to it. I'm just coming from just a layman over here, watched the Day Show and calculating evidence and wanting to be convinced one way or the other by either counsel. And I wasn't. And based off of our law, innocent unless proven guilty. And I couldn't find it. I couldn't bite it saying 100%. So I would have to default to what we're supposed to in that situation.
I think you're 100% right and very well said, better than I've put it all day long. So thank you very much for calling. Appreciate that.
Yeah, Chap thinks that you're very brilliant.
Except for this guy named Thal. Just kidding.
Yeah, they're just tired. They don't know what they're saying. They're tired. They're just defaulting to cheering. But no, like I said, I don't always call in on the trial stuff, but this one, it's so different to me. It feels different. It's gone different. I will also agree with you, Scott. The judge did certain things that I didn't love, but I think he's probably been the most refreshing judge in the last, I don't know, since Judge Carroll. He's integrated some humor when it was applicable and not inappropriate. He seemed to be attentive. He explained rulings, but much more concise than Judge Schroeder. no hate on you, Schroeder, but he was a little bit quicker with how he was explaining rulings. I liked him. I liked the way he operated his courtroom. I like how he addressed jurors as well as counsel. And I think he was fairly fair. So I enjoyed the trial in that regard.
The best is when he was upset with one side, how he handled that. That was stellar.
What did he do?
He was measured. He was calm. He was there was no anger. There were no outbursts from the judge, and there were times when he rightfully he could have had a big bring down the banhammer moment, and he didn't. And I think that was really what speaks to his greatness as a judge.
He did very well in that particular moment, especially against Taylor, when Taylor deserved a reprimand, and he gave him the almighty.
Taylor deserved to be bent over the knee and paddled with the gavel. I mean, he deserved a spanking.
Yes, and Judge White gave him the almighty, not I'm furious, not I'm mad, not here's the smackdown, but the worse of I am disappointed in you.
Yeah.
He mentioned how many trials he knew Taylor's been a part of, and mentioned that and brought appeals and this. I mean, he educated him in his discussion and his reprimand in the most calming tone. And I thought that was very professional. So that was neat to watch. Although as a viewer, we were kind of hoping for more sparks, I think. Yeah. But he did what he did.
I think he handled it the better way. I mean, I watch NASCAR for the wrecks, but really, it would be awesome if we just have a new world record on the course. But
exactly,
we were looking for the wrecks, and he instead delivered, just
nobility.
wide wisdom, and measured response. So, Thomas, thank you very much. There's a reason why I have this amazing man who's on the phone right now as my podcast partner. It's because he suggested it, and it was an excellent idea. I said yes, yes, 100%.
Thomas, you're brilliant.
Thank you. We are going to miss you in the podcast this week. Next week we'll be back.
We'll be back. Thanks for letting me call in, and I hope everyone has a great evening. And I'll be checking in. Hopefully, there's a verdict tonight, but I'm guessing tomorrow after lunch. That's my guess.
Oh man. Okay, sounds good. Thanks, Weather Watch. Appreciate it.
Y'all have a great night.
You too.
See ya.
Laurie, I saw you tried to call a couple times. I was on with Weather Watch. If you give me another call, give me another chance, Laurie. I'll see if I can take your call.
Greener says, I watch Recovery Addict for the tech failures.
Well, you get a lot of those. Some would say that if I used less tech, there would be fewer failures. But I'm always the more tech is the answer guy. It's Laurie. I know you left a message. Holy cow!
It's 9.
I missed 20.
How are they still deliberating? Did they go home and not tell us?
Today is flying by.
For you?
Yeah. Like it was 7 just a minute ago. We were at 4 hours a minute ago. Now we're at 5.
No, it's been an hour.
Labman, as far as the switcher, obviously the money has to arrive here first, so we're waiting for YouTube to get with the program. So we're figuring out how we can make things work in the meantime to make it last. Hello? The call just failed.
Did you hang up on him?
No, it said the call was connecting.
The switcher cannot handle your call. I'm sorry.
So we're running skinny with the channel that's accepting the audio properly, and I'm just not pushing the buttons that I normally push because they act up and do things they're not supposed to do. So I've also been unplugging it, which maybe this is my fault. I've left this switcher running since I went live at the beginning. It's been powered on the entire time.
What, since Daryl Brooks?
Yeah.
Oh yeah, maybe.
Is that
I think you may have found the problem.
It's
that's funny.
It's running 8. It's running 8 scalers, nonstop HDMI scalers to adjust timing, frame rates, everything else at the same time.
It's just taking a nap.
The problem is it doesn't have a power switch. I have to unscrew something and pull a plug or flip off a main breaker, and that means turning off my computers, and I just don't do that. But why is Mrs. R.A. not on camera? Mostly because we live in a house that was built in 1915, and there is not a spot in the house that's big enough for a shot like that. To get that wide of a shot that would allow 2 people to sit side by side, the camera would have to be outside the house.
It'd have to be super big because right now I am completely reclining. I've got my feet up. I'm so
You do look pretty comfortable over there. Do I ever restart my PC? I don't have a PC. All Macs. No, just kidding. Yeah, I know what you mean. Yes, I do. Every time it has an update, it makes me, but that's the only time. Can we get some of Mrs. R.A.'s recipes? She knows how to cook rice halfway.
I think I should get props for this. I cooked rice without, like, actually cooking it. That's pretty impressive.
Let's see. Larry Ross says, let me see if I can find the message here. I might be able to play it. Let's see. I'm going to try. Nope. The call's coming in. It won't let me play.
Call from Lori Ross.
There we go. Lori, I was just trying to play your voicemail, but you were on the phone. So first of all, thanks for calling back. And what was on your mind today?
So I've been watching the show. I've watched like all my trials with you because I think you're great. And I'm actually friends with Jules. So Jules and I know each other. We did
awesome.
Maya together.
Yeah.
So we know each other. We're pretty close. She's sick right now. So she didn't get to watch it. So I had to kind of chit-chat with her over text. But I am a true victim of domestic violence. And I read the chats and I watched this trial. It was really difficult for me on both ends because I came into this with a preconceived notion that she was another Amber Heard. I really did. Yeah. And then I watched her and I watched the trial and I listened to the evidence and I don't think she's guilty. And she made me cry. She made me cry. She made me feel. Amber Heard just made me angry, like angry as a true victim. And I think what the chat doesn't understand, and if I get emotional, I'm really sorry. I was in a marriage for 5 years with a man who I had known my entire life. Never mind just met them. I knew him my entire life. He promised me the world as my friend, as everything. And it started off just the way it started off with Ashley. Name calling, you're nothing. I don't like your hair. I like it curly. You need to wear it curly and all this stuff. And then it got progressively worse. So then the emotional part kicks in and then you start fearing everything that you say, every move that you make, every look you give. And then it turns violent. And it's in a split second that happens. It can take years for it to get there. It took me 5 years to realize I was in the worst situation of my life until he choked me on a cruise and almost killed me, and we had to be separated in Miami. And that's how it ended. And so I hope the chat understands that we can look at a situation from afar. And if you looked at my Facebook page or you looked at my pictures or you talked to me like you're talking to me right now,
everything
or
looks
you've seen
okay,
him,
right? It's the
exactly.
Instagram
Everything
of us.
looks exactly. Everything is picture perfect. So I really felt like the prosecution just re-victimized her over and over and over again. Like he didn't slap her, he didn't kick her, he didn't beat her with a knife, or he didn't threaten her with a knife, or he didn't shoot a gun at her before, but he did. And there's a letter from his ex-wife. And so if you take all those factors and you stack them on after one another, this is what you end up with. And so people can say she's not scared. You don't know. And unless you've lived it, unless you've been in it, unless you feel it, unless you've gone through all those cycles of violence like the doctor talked about, and it doesn't have to be physical. Mine didn't start off physical. It didn't start to get violent until 2 years into our marriage. It started off all verbal, but it progresses. They progress. I just wanted to give my 2 cents because I thought it was important for your listeners and for the chat to understand, because I watched the chat and I think that some of their comments are really, and I know we're supposed to all be friendly and we're all supposed to take each other's point of view. And if there's a right way and a wrong way to put your points in without victimizing other victims, and I don't think you guys are realizing you're doing that because you're calling us all liars, because it's not the picture perfect that you think it should be. It never is. It's different for every one of us.
Yeah, it's our personal experience and coloring the way we look at something. And Weatherwatch was talking about this earlier. We look at everything based on our own personal experiences in life. You, Lori, first of all, my heart goes out to you. I am so sorry that you went through that. You experienced something that tragically was very similar to what Ashley recounted in her experience, and so you can see that there are other people who have experienced a very different type of abuse where it was the cycle was different, even though some of the same things might have been there. It was completely different, and they might look at this and say, that's not what it was. No, that's not abuse. I know abuse because I've been through it. And they're literally saying, I've lived through this, but experienced it differently, and I don't believe her for that
Exactly.
reason.
Exactly.
That's why it's so hard for me. I can't be the one that decides and say, yes, this happened, and no, it didn't. All I can do is look at it from a legal perspective, and I think for me, I'm very comfortable in the position that I've reached in my decision on this case. But I appreciate you being able to share this.
Absolutely. And here's the other thing I wanted to make your viewers aware, because I saw this come up a lot, is that where they said she can leave, right? It's not that simple to just leave. It's not, because then you're afraid what's going to happen after you leave. Are they going to come after you? Are they going to follow you? Are they going to stalk you? And the other thing is a lot of the times I didn't report it. My kids called the police, and I ran upstairs, put makeup on my neck from him choking me, and lied to the police straight to their face because I was afraid what he would do if he found out I told them. Because he took off after he found out the kids called the police. So, I mean, it's a lot easier to judge something when you have an experience, and we all experience it differently. That doesn't mean we're all lying. It doesn't mean she's lying. You have to take it with what you know, yes, but also be more thoughtful of, is it possible? Because it's very well could be possible.
And I think there is another side of this as well, though, that has to be mentioned, and that is that there are some people who see this as an opportunity and make a claim that isn't founded, and that hurts people. That hurts it hurts other victims. Because if it's proven that it's not founded, and we've seen plenty of court cases, where that has come up.
Amber Heard.
Okay.
Amber Heard.
I mean, I was going to talk about some in Arizona as well, or New Mexico, I think it is. I can't remember where.
Yeah, I know which case you're talking about.
That's very detrimental to the whole conversation. And it does make people say, well, which one is it? Is it truthful or is it not? And it hurts when somebody is telling the truth and that somebody questions did that really happen, or what's the evidence? Because last time somebody told me that, it turned out that it was a complete fabrication. So I can see both sides. I appreciate everyone being kind in the way they share this, and we're trying give each other some space and grace is what we like to say, because
exactly
our own
and that's all I'm saying is don't. There's a way to disagree without being attacking. You know what I'm saying? I agree with you 100%. There are people that lie. But there are people that tell the truth, and we can agree to disagree. Just do it kindly. Yep. Be careful of your comments. Not you. Oh, you're great.
Too.
Well, everybody.
I can't tell you the number of times I've stepped in it. And I will be quite honest. This community has been so forgiving of when I've made a serious blunder. I made a blunder once.
Once. That one time?
Halloween. Halloween.
Oh my
goodness.
Oh, that was like, please don't call the cops.
There's a time when I just said something that was just, anyway, I want to go into it because it was terrible. Anyway.
We all make mistakes. We all do. And we all say sometimes really dumb things. And it's just, I just wanted to give a perspective from a real victim, and somebody who has seen the beginning. She really was in the beginning stages of this, in my opinion. I think that if they had moved to Maryland together, I think it would have been 10 times worse, and eventually it would have happened. Either he would have killed her or she would have killed him. And I can understand that people, maybe she did set him up, but that doesn't mean he's not an abuser, right? It can be both. And so I agree with you. This relationship was completely toxic. They shouldn't have been together. And I think some of the ways she went about it was incorrect. but it doesn't change the facts of the facts. And I agree with you. I came in this with she was so guilty, and then I listened to it and I watched it and I heard the evidence and I felt it.
Yeah.
And you can look at it from a different perspective. But I wanted to say thank you, and thank you for taking the time to take my call.
Lori,
and
thanks for calling 3 times. It took a couple efforts to get through, but I
That's
appreciate
fine.
that.
No, I've wanted to talk to you for a long time on a bunch of
And
cases.
wish Jules well as she's getting better, and tell her thank you so much.
I will. Have a great evening.
Lori,
Bye,
thank
Mrs.
you.
R.A.
Bye. Thank you so much for sharing. I know that takes a lot of courage and bravery to come out and share stuff that when you are not assured of a positive response.
Yeah.
I mean, you're more assured of it in this chat than other places, but you never are completely
it's
safe.
a vulnerability to be able to share something like that.
Exactly. So. But I appreciate it. And thank you for letting me take the time to tell my story. It took me a long time to tell my parents. So I appreciate it. I mean, the only people that knew were my kids, and my kids, like, even to this day, I wonder how much I messed them up, by putting them through that.
They sound pretty brave to me that they were the ones who called the police. You had to be teaching them something right for them to find the courage to do that. So the kids are resilient.
Thank you.
Yep.
Thank you so
Lori.
much.
Thank
You
you
have
so
a
much.
great
Have a great
evening.
night.
Thank you.
Okay.
Bye.
Bye.
All right, I'm turning down the ringer here. We have now passed, well, by both, it depends on whose counter you watch. We're watching 2 of them right now. By my counter, we're 5:21. Other counters are just after 5 hours, but it's been a long night of deliberation.
These poor people. I wonder if they're like, did you bring your pillow? I'm kind of tired.
It's like, are we sequestered? Do we go to the hotel now? No, we go home? What? Oh, man.
Is the judge sitting there too?
Yes, everyone has to be there. Everyone has to be available, probably within 15 to 30 minutes. So they might be sitting in a nearby hotel or in a conference room or restaurant nearby. But once they get that text, it's like, boom, go time. Get to the courtroom. It might be a jury question. It might be a verdict. But
you're gonna have people showing up, rubbing their eyes. No, I was awake.
The poor bailiffs are like, oh, I guess I'm working overtime tonight. So because the building's not getting locked down like it normally does.
Or maybe they've all gone home and we just are looking at a screensaver.
They said 10 minutes. They accidentally left the lights on all night. We're going to be here for it. You wanted them within 10 minutes. That's crazy. I've got another call. Let's see who this is.
Call from. To accept, press 1.
Who do you think
to
it
send
is?
a voicemail, press 2.
Hey, this is Recovery Addict. Who's on the phone?
Hey, all right. I want to be anonymous, so I could.
Okay. All right.
I might have somebody watching, but I just wanted to, on male side of things, come in as a victim of domestic violence. Okay. So when I was in my 20s, I was dating a girl that I dated for 8 years since high school, and I was never allowed to hang out with my friends. It was always, you're cheating on me, you're doing this, mainly emotional abuse more than physical abuse. And so it took every bit of me, because I thought I was going to marry this girl, to step away from the relationship, right? And, I was big into sports and big into going to the gym and whatnot. And so I finally decided to step away. Well, to what Ashley was saying, that, Doug started showing up in her windows and whatnot. Well, the same thing happened to me in the middle of the night, right? So I'm like, what is going on? So she started showing up to the gym, started showing up to my house, looking at my windows, doing all these things, right? So I kind of like was like, wow, what is going on? So I was living with my parents, with my mom and my stepdad at the time. And so I told my stepdad and my mom to go take care of it because I didn't want, her to see me, So we finally broke away. She ended up turning herself into a mental institute. And after that, I never had any contact with her. Well, she found out I was dating another girl and started harassing this girl. And come to find out, she had people following me. And I was out at a bar one night and ended up getting jumped by 4 different guys. I was stabbed, hit with a baseball bat. And I didn't, put the connection together until I found out who it was.
So she sent people to...
Exactly.
Wow.
And
this,
go ahead.
This story, I will say it's not as common to hear about men being abused. It goes both ways. It definitely does. It is real.
Yeah. And I think there's another layer of difficulty in talking about it when you are a man, because there's that social expectation that it can't happen to you.
Yeah. You're supposed to be the strong one. It's like, why would you let that happen? The words out there, but it's real. It happens. And I appreciate you for sharing the story. I hope you've got a measure of healing and hopefully a relationship that's healthy in your life now with somebody that doesn't do that.
Well, let me tell you this. So after this all happened, right, I threw it to the side and we've connected again.
Oh no!
With this lady?
Okay, hang on. That's
so crazy.
My flags are going up.
Yeah, buddy, this is not a good plan.
No, I know. I'm telling you this. So since that, we connected again, right? And everything was fantastic, right? And we had this great relationship. So, she would want to go out with her friends, and she would come home and she would just attack me. And I was like, I'm out. And ever since then, I've been gone. So
yeah.
So you broke up with her again?
Yes, and I. It was a mistake. I mean, don't get me wrong, it was a mistake, but you learn from your mistakes, and I guarantee you one thing, that I will never, ever do it again. So I just wanted to share my experience.
I appreciate that, and thank you. I'm glad we could let you share this story anonymously. But thank you, caller. That sounds weird to say that, but I appreciate that. Thanks for sharing your story to put a perspective on it that doesn't often get spoken about or heard.
Yeah.
So thank you,
sure.
Thank you, my friend.
Absolutely.
Take
care.
Bye
bye.
All right. With that, we are unplugging the phone. Our mods are like falling asleep on their feet, trying to follow things. We're going to say we're done for the night. We've gone almost 5.5 hours of deliberation. The courthouse may be closed. The judge may be gone. The jury may be home comfortably in their beds at this time. It is 9:15 at night on the East Coast, and
they're all at home eating their crunchy rice.
Yeah, I need to end before the mods revolt and collectively, get me thrown off YouTube or something. I don't know. They're
collectively quit.
I will tell you this. Our mods are amazing, and cases like this that have difficult topics, that brings really strong feelings in chat and personal experience, triggers and things like that. It's difficult because the mods, they have those same experiences. They have those same feelings. They have family members going through the same things, but they have to sit here and watch. Amber says, I'll just turn off live chat. That's all. We'll fix it. Look, I fixed it. They have to watch, and they're wading through basically the worst of the conversations where the people that just popped in here and to make a rude comment. That's what the mods are digging through constantly. It's rough on them. I want to say a big thank you for them for all they do. They're fantastic people. Very, very different walks of life, very different individuals, different countries that they live in. But it's awesome. Kenny, I think that was just a rumor. I've heard there's no basis to that, although it's still a possibility. I don't think Morrissey actually was disbarred. I haven't seen anything on that yet. All right. Let's see. I think that's it. Do you want to be on for the ending, Mrs. R.A.?
Sure.
Do you know what the ending is?
Music?
It is music. When we play this music, that means there's got to be something happening in court. As always, let me tell you this. If you see something, if you see a tweet from one of our sources there in court or news that there is a question or something tonight, I'll pop back on. We'll jump on. We'll cover it live if we can. If not, we might be a tiny bit delayed. But I don't think we've got a verdict tonight. I just cannot see that happening. There's so many people, so many family members that have to travel so far to be here for that. It's just not going to happen. So thank you all for this amazing day. You guys are incredible. Thanks to this community. Thanks for your caring way that you support each other through all of this. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning at 8:45, I think. I'm going to say 8:45. And we'll be back again to follow what I believe will be either a hung jury or...
You think they'll be hung?
Or a verdict. I think it's tomorrow. What I'm saying is it's not going to go another day. I'm putting that out there. That's me putting my chip in.
I just want to be
Tomorrow's
clear.
the day.
What you just declared was it's either going to be hung or they'll have a verdict.
Well,
Way to make
the
it
third
clear.
option is they're still deliberating, right?
Okay.
That's one of the three. I realize I went with the safer bet because it's the two inevitabilities. But oh my goodness, I love my wife. She calls me out when I need it. You guys have a good night. They are still going. We'll keep watching, and if something happens, we'll be back again. I think that's it. That's it. All right. Yeah, that's all. Okay, guys, have a good one. See ya.
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm not a cat.
Because he's the guy.
Have them send someone with more experience.
Scratch all that. Oh, that was terrible. I apologize.
That's not him.